But we will take the papers of HBL. No, please.
May I have your lordships to
Appellate side mentioning?
appellate, sir.
Then we take up appellate side. Now we'll take up original side mentionings and original side. Yes. One who is appeal, Mr.
Appellate side mentioning, no. I'm original side mentioning.
One touch. Yes.
My lord, may I have my lord find leave to mention a matter?
No, mentioning is over. We have taken up matters. Yes.
But only one indulgence, my lord. I appear for the Institute of Chartered Accountants
Yes.
by Mr. Anirban Rai. My lord, my learned senior friend, let him conclude today. My lord, we shall.
Hey, please use the microphone, Mr.
My lord, if my learned senior friends concludes today, my lord, we shall give the reply on the next day, my lord. That's it.
Copy for the
can
company
start
requirement
even now.
2 and 4, my lord.
No, he's there, so he'll start.
He has requested.
No kindness.
Why?
But he, my lord,
Actually, let us see whether he finishes today.
No, I will conclude with.
We'll conclude. You don't
Yes,
take
yes.
much time. Yes.
Yes.
kindly let us come back the next minute.
Unnecessarily kept part hearts for so long.
My lord, if I may say
You
this,
don't
my lord,
want to carry part heart matters too much.
But only next week I'll do it, my lord. Today I have some personal problem, my lord,
Very
if I may
good,
say so, my lord.
Very,
Not personal, as in personal administrative problem, my lord.
very.
If
Yes,
your
Mr. Mujumdar, let us hear you.
Yes, madam. I'm appearing in item number 2.
One who is appearing.
One Mr. Mitro
So
addressed.
Mr. has addressed us.
Your lordship has Mr. Mitro has addressed your lordship. So I'm in item number 2, but I will be referring to the papers in item number 1 because my lord, the papers are identical. My lord, we need not go
We will ask for written notes of arguments from both of you.
at the end of
Please
it.
try to, at the end of the matter, please try to a bit collate between yourselves so that.
Yes, my lord.
Common
There
argument.
will be no overlapping at all.
Thank you.
My lord, I will confine my submissions to two issues.
Right.
My lord, mainly the issue that the complaint was filed with malafide intention. Issue number 1, which has several subsets.
Right. এই এটা যা খুশি করতে এটা কালই শেষ হয়ে গেছে বারবার রিপিট করছে ম্যালাফিডে কমপ্লেন ভেরি ওয়েল
Right. Second, my lord, would be, my lord, the institute, the council, acted in a manner which is not known to law. Which is not known to law while deciding this issue, deciding the complaint. Again, there will be several subsets, including the violation of principles of natural justice, antedating of the report of the disciplinary committee that I will establish, my lord. Now, my lord, my lord, for the sake of completeness, but we have prepared a list of dates for your lordships. Oh, acha. If we miss any date, my lord, I will request. Hey, একটা copy there.
yes
Then, my lord, I will request Mr. Gupta is there for the council.
yes you are appearing in ACA 6
ACA 6, my lord.
Aditya Vikram
Yes, Aditya Vikram. But I will
This-
be referring to the papers of
and
HBL.
this list of dates is also numbered very well all the
That's
same.
there, but it hardly matters because all the papers are identical.
very well
Now, my lord, now kindly take the list of dates.
yes
And on June 30, my dates are very relevant. On June 30, 2005, complaint was filed by the complainants, but there were 3 complainants: Om Prakash Agarwala, Shashi Agarwala, and Suresh Kumar Sharma against my lord Harshvardhan Lodha and my lord this AVL also, Aditya Vikram Lodha.
Aditya Vikram was 16th July
16 July, I'm sorry. Now, then, my lord, kindly take 8th of July.
yes
Affidavit affirmed by Sri Kashinath Tapuria, being affidavit in reply in GA number 4375 of 2004, filed in TS number 6 of 2004 before this honorable court, alleging complaint filed against my lord R.S. Lodha. Again, he referred to, my lord, the complaints against my lord. Reference was made to the 2 sons, namely my lord HVL and AVL. May I use the acronyms? With leave to refer to the copy of the complaint at the time of hearing. In fact, it was done so. On 16th of July 2005, the complaint was filed by the complaints against my lord Aditya Vikram Lodha. Then, my lord, on 27th August 2005, when RSL since deceased, HBL and AVL, received copy of the complaint filed by the complainants with ICAI that would be annexed D to the affidavit in opposition filed by the complainants itself at page 78. Well, I will refer to those documents later on.
Both of them received their respective
So,
complaints
my lord,
against them.
your lordship will kindly note the dates. On 8 July, well, in a proceedings before the High Court between Birla and Lodha,
RSL complaint was referred to.
RSL complaint was referred to.
And on 27th August, they received the
Well, the RSL complaint was referred to, and on 27th August 2005, my lord, the complaint was actually received by the
both of you.
both of us.
RSL's complaint.
Not only RSL, my lord,
All the three complaints.
all the three. So, my lord, the receipt of complaint by my lord HVL and AVL and RSL, since this is
All three complaints were received on 27th August.
yes, was preceded by reference to the complaint in an affidavit filed by Mr. Kashinath Tapuria in a proceedings between Birla and Lodha.
How is Kashinath Tapuria related?
Kashinath Tapuria was filing affidavits in the he was the constituted attorney of the Birlas in those proceedings. In the
suit. That is in the suit.
Probate.
No, this is title suit you have referred to.
Yes.
This was testamentary suit.
Testamentary suit. Yes. We will refer to the relevant paragraph later on. TS 6 number of 2004. That's a testamentary suit.
Yes.
Now, my lord, kindly take the next date. Well, what happened, my lord? With this development, my lord, the petitioner, I mean the appellants before lordship and his father, they naturally got apprehensive about the nature of proceedings and how these proceedings would be concluded by ICAI. So they filed a writ petition immediately upon receipt of the complaint.
RSL was deceased by then.
No, he was there.
27th August, you have stated that
No.
since deceased.
Well, since this is that is reference, but my lord, he died.
He was
later
alive
on.
till then.
In 2010, I think he died. 2008 he died. October 2008 he died. So, my lord, this writ petition was disposed of by Justice Jayanta Kumar Bishwas, which your lordship will find the order at page 49 of the affidavit in opposition filed by the complainant, with an observation that the issue of the whether the complaint has been filed with malafide intention or not would be decided ultimately. This is not the stage. Having regard to the provisions contained in Regulation 12.4, read with Regulation 12.11I of the ICI regulations.
What were these writ petitions filed against?
A challenge against this complaint, that this complaint should not be entertained at all, since the complaints have been filed with malafide intention.
All right.
But my lord, the Justice Jayanta Bishwas' lordship then was declined to interfere at this stage and made it clear that, look, this is ultimately, the expression used is ultimately it will be decided. Now, my lord, 1st of June or 2nd of June 2006, HVL and AVL filed their written statement with the ICAI. 18th of July 2006, complainants filed rejoinder to the written statement. That is also there. 16th of January 2007, HBL and ABL filed reply to the rejoinder, but that will be a rejoinder basically, of the complainants, which is also annexed. 9th April 2008, Council of ICAI referred the matter to the disciplinary authority. Well, this is in exercise of the power conferred under Regulation 12.11I, where the council forms an opinion that, my lord, the respondents or the appellants before lordship are prima facie guilty. That is the exact expression used in the regulations.
RVL never filed any objection.
Sorry?
RVL never filed any objection.
Everybody filed.
You have not referred to that. You have stated everywhere HVL and AVL.
Well, the RSL died, so we did not refer to that.
It has lapsed in
It has
any.
lapsed. Then 9th April it was referred to. 4th December 2008, my lord, we filed a writ petition. challenging this reference to the disciplinary committee. Malad, there, his lordship, Justice Dotto, as his lordship then was pleased to direct that the proceedings were allowed to be conducted, but up to a particular stage. 5th December 2008, hearing before DC commenced. Disciplinary proceedings were heard in respect of few charges, actually, it should be not stages. Na? In respect of few stages, madam.
Stages?
Yes, stages. That is, madam, up to a particular stage. So this is by few stages. So, my lord, now 27 July 2009, what, my lord, we did, that was a gross mistake on our part. We filed another writ petition, my lord, basically on the same cause of action. That writ petition was dismissed and dismissed with costs. So before they referred to that order, but I am referring to that order myself. So 12 December 2009, 7 January 2010, 8 January 2010, and 11 January 2010, further hearings before the DC were held and concluded. 1st February 2010, HBL and ABL, but by that time RSL had passed away. HBL had and ABL filed written notes of argument with the DC. Mal, kindly mark this date. This is extremely relevant. 29 December 2010, that is, Mal, nearly after 11 months, Mr. Learned Advocate wrote a letter to the members of DC on behalf of ABL and HBL, bringing on record that the complainants have not been able to produce the original deed of the alleged partnership deed dated 1st April 2002 relied upon by them, as well as reiterating their willingness of his client to submit the copy of the partnership deed dated 31st December 2001 relied upon by his clients, original whereof was produced and shown to the DC members at the time of hearing. Well, these submissions have been made by Mr. Mitro, but what is relevant is that 1st February they filed their written notes. 9 months later, they filed, the appellants before lordship filed a letter that they are willing. So they presume that the proceedings were pending as on date, that is 29 December 2010. 11th March 2011, there was no response to our letter. 11th March 2011, report of the DC dated 3rd February 2010, received by HBL and ABL. Mala, kindly mark the date. So, Mala, 1st February 2010, written notes filed. 29 December 2010, we write a letter through our learned advocate that we are ready to furnish the deed. No response. Suddenly, after 4 months, on 11th of March 2011, which is, my lord, perhaps, my lord, more than a year from the date of submission of written notes, they say that the report of the DC dated 3rd February 2010.
So this is why you say antedated.
It is antedated. Received by HBL and ABL, out of 15 charges, DC rejected 10 of such charges and held guilty inter alia. But I'm not on that. We'll come to that later. 20th March 2011, Khaitan Company, or the solicitor of the complainants, wrote a letter to the solicitor of the, my lord, this HBL and ABL, enclosing report of the DC of ICAI in connection with the complaints against HBL and ABL. So, my lord, the report was also made available to HBL and ABL. And if once I place that letter, your lordship will find that the date of the report in that letter is 3rd February 2011.
11th March you received from the disciplinary committee itself.
And, my lord, on 20th of March, the builders communicate and send a copy of the report to me. 16th or 17th of May 2012, a report of the DC placed before the council. The hearing before the council, which was scheduled to commence from 3 p.m., commenced only at 7:30 p.m. In spite of request by learned senior advocate, chartered accountant appearing for HBL for an adjournment to another day, the hearing was continued till 2 a.m. on 17 May 2012. The reference has been made in our letter. Then 27th November 2012, decision of the council dated 16 May 2012 was received by the HBL and HBL. 24th July 2012, written representation made by HBL and HBL prior to the hearing before the council of ICAI, that is at page 699. 29th of July 2013, HBL and HBL given hearing by council under section 21(4) of the Act. 11th November 2013, HBL and ABL served with communication dated 6th November 2013 of the alleged decision of the Council of ICI intimating removal of their names from the register of members for a period of 3 months impugned in the present proceeding.
This was a subsequent decision on your representation.
Malad,
Because
there
the
were two
previous-
representation. One at the stage of hearing, where Malad, and at the stage of sentencing.
No, this 27th November, the decision of the council dated 16th May was given to you. This was the original decision taken by the council
Malad,
against you.
original decision was taken by the council on 6th of
6th
November.
16th May.
16th May, my lord, report was placed. Report of the DC was placed. Hearing commenced.
No. 27th November, you received the
6th
decision of the
November is
council.
the penalty. 16th May is the, my lord, the decision.
That is what we are saying. That is the first decision of the
That is
council.
the first decision of the
And
commission.
11th November, you received the decision on your further representation.
My lord, that was regarding sentencing part.
Yes.
But further representation. Because we filed a representation with respect to the sentencing.
All right.
So this is all, my lord. Now, my lord, I take your lordship to the case which I am trying to make out regarding malafide complaint. But kindly take for once
What was the interim order passed in these appeals?
I think stay of the stay chilo na? They were stay. They were stay, right? They were stay.
Yes.
Malad, there are malad, subsets of this particular submission would be one, my lord, the complainants had been set up by Birlas.
Hmm.
Because the complainants had relation with Birlas. One was an employee of a Birla group of companies. Others were chartered accountants who were associated with the affairs of the Birla group of companies. And not denied.
And
Not denied. That they had relation, that was not denied. But I will take your lordship directly to paragraph 30 of the petition. Now, act a second. Before I come to paragraph 30, just 1 minute, just 1 minute, just 1 minute, just 1 minute. I'm sorry, my lord, 1 minute. My lord, kindly take, my lord, our written statement which we had filed, which your lordship will find at page 598 of the volume 2.
there's only one volume here.
Oh, sorry, I am 598, my lord.
Yes, 590.
But this looks like an old telephone directory.
Yes, absolutely. Which Batul the Great used to tear up.
Tear up. Kindly take paragraph 2A.
Yes.
All the three complaints, but this was before the DC, the disciplinary committee. All the three complainants are connected with Birlas. The complaint number 3, Suresh Kumar Sharma, is an employee of Kesoram Industries, a BK
No, this is page 598.
8 though.
This is
Oh, sorry, AO of ICI, part of AO ICI,
part of AIC.
but
Page-
this is
page-
our written statement.
Yes, this is a
Page 598.
Come on.
Page 598.
598 is our written statement which has been annexed to the AO of
Where are you reading from? We are not following here.
598, my lord. The
A.
written statement starts at page 596. My lord has got that? 596. Kindly take
It
596.
does not start at 596 in our. অন্য কিছু?
My lord, kindly take affidavit in opposition of ICAI. Sorry. Kindly take affidavit in opposition of ICAI. Complainant na ICAI. ICAI.
This is
Volume 3 of ICAI. Huh? Na.
opposition.
Opposition.
institute.
Institute's opposition.
SK Sanghi and Company.
SK Sanghi.
ও তো অ্যাডভোকেট আছে এই উপরে লেখা আছে
Who are the advocates on record of
SK Sanghi.
SK Sanghi তোলা দেখো?
Singhi. Sanghi.
What is SK Sanghi?
Singhi.
ইয়ে এটা ওইগুলোই তো এসকে
হ্যাঁ,
সাঙ্গি
এই তো,
তলায় লেখা
এই
রয়েছে
খোলা আছে, এই তো। This is volume
তলায় ওটাই
third volume.
হ্যাঁ
Well, I'm
তুমি কি
extremely
খোঁজ
sorry,
দিলে
my lord. Volume 3, your lordship has got? I'm so sorry, my lord. I should have.
No, no, no.
My bad.
This this also does not. Nothing starts from page 596.
Huh?
Uh,
My lord, your lordship is
we are looking at the written statement on behalf of the respondent.
I'm looking at
Page
this is-
589. It starts. Volume 3. S.K. Sanghi. This is affidavit in opposition affirmed by T. Karthikeyan.
Your lordship has got the written statement.
Written statement, yes. Affidavit in opposition is affirmed by T. Karthikeyan on 18th May 2014.
596 the car volume. This is the institute's operation. Your lordship has got the written statement, my lord.
Yes, on behalf of the respondent.
On behalf
It
of the
starts at page 589 in our copy.
But is it ACA 5 or ACA 6? I put the
But respondent is Aditya Vikram Lodha.
Well, ACA 6. Your lordship would kindly take ACA 5. I'm referring to the papers of ACA 5.
5 refer করবে
Well, well, we are referring to one petition itself, and
Five
all the
opposition নেই?
papers relating to
There is no
HPL.
opposition in 5 they're saying.
I'm not putting an ICA.
On the same boat.
That is
This is between us.
The opposition was never filed.
File করো নি ওটা?
It is in our records, but we have to check.
Was it filed before the division bench of Justice Girish
মানে
Gupta?
this is there, এটা আমাদেরটা তো,
Long back
আমাদের
we have to
আমাদের
check.
মানে HPL এর
If it was before the division bench of Justice Girish Chandra Gupta, it used to happen. We filed and
মানে
the
they
famous
must have filed.
famous SEO was there.
Yes.
So it used
He
to
was
happen
good,
regularly
my
with affidavits of service at
He
least.
was extremely good, my lord.
Yes.
At times.
But the difficulty is we don't have that.
My lord, kindly take 589. Whatever your lordship has got.
Let us make do with whatever we have got. Yes.
And
But
my
this is-
lordship will also find this document.
But this is the written statement on behalf of Aditya Vikram Lodha.
My lord, kindly take for once, my lord, HPL's papers, the affidavit in opposition filed by the complainant. It is at page 158. It is all the same. It is at page 158. Lordship will kindly refer to one set of papers. কেন ওদের নেই, তোমাদের নেই কেন?
দেখি
বার করে দাও। এটা কি ABL? Complainant. Institute.
complainant.
এসকে সিংহি বলে দেখুন।
SK Singhi.
একটি সঙ্গে এটাতে আছে
মানে we should have taken care of
SK
this
Singhi নিয়ে মিস্টার
housekeeping
নাককে
job.
এসকে সঙ্গে নিয়ে পুরোটা নিয়ে মিস্টার নাককে ধরিয়ে দাও
আমাকে
Mr.
আমাকে
Nagar
দিন,
নাকি?
আমাকে দিন। এক second দাও।
যার এফিডেভিট সে দায়িত্ব নেবে
এটা কি ABL তো?
হ্যাঁ ভলিউম 3
ভলিউম 3 বার করো।
এই the first page
First page.
the first
That is what you are saying. That is the written statement of Aditya Vikram Lodha,
Yes, but my written
not ICAI.
it is all the same.
All the same, all the same.
All the same.
this one my
But my lord, I would have referred to HBL's papers because I don't know why the papers are not here before your lordship.
ওইটা
Because it would be difficult for them too. I think so. Kindly take the written statement. I'm so sorry because I would have to refer. ওদের আমি রিজয়েন্ডার মেলাবো কি করে আমি? হ্যাঁ, ঠিক আছে দাও। Kindly take, my lord, paragraph 2A, which will be 592, I believe.
591.
591. I'm sorry, my lord. My lord, kindly take, my lord, 2A. All the three complainants are connected with Birlas. My lord has got that part. The complainant number 3, Suresh Kumar Sharma, is an employee of Kesoram Industries. The nexus of the complainants with Birlas would be clear from the following. Then, my lord, we refer to this Kashinath Tapuria's affidavit. Kindly take, my lord, the relevant part of the affidavit, which is there at page 592, I believe, which was filed prior to the receipt of complaints either by, my lord, RSL since deceased, HVL, or
This was referred to in the testamentary suit.
in the testamentary suit. But this entire this entire proceedings has Birla written all over it. Nothing more than that.
Now, this bench also has Birla written all
All
over.
over it.
Birla and Lodha also.
Birla and Lodha.
We are equal on that.
Yes.
Whatever happens between
Your
Birla and
lordship has
Lodha
been
in Calcutta
burdened-
High Court
your
comes to
lordship
us
has been
because I
burdened-
had the misfortune of returning a bare brief cover of one of the
You just
parties.
use this expression.
I should have taken that and taken the fees, and that was my principle. I don't take bare brief covers unless there's a conference.
You should have.
That
your
is the
lordship should
mistake
have
I
taken.
committed.
My lord, your lordship has been burdened classically and practically with a legacy dispute.
Yes, absolutely. Yes.
So, my lord, kindly take, my lord, page 592.
Yes.
Your lordship will find
We know their family now better than them, actually.
better than all of us.
Not that. Yes. Yes. It is significant that
Mr.
I.
Mitro, I think Mr. Roy Chaudhuri,
Yes, he's also there.
Mr. Mukherjee is not
He's
here,
one of the known
and
culprits.
Mr. Trivedi.
Yes, yes. Mr. Trivedi's name is also written
Yes.
in mail basis. So we'll look into the italics portion.
Italics portion.
Yes.
It is significant that the deponent, R.S. Lodha, a chartered accountant, has been a partner of Lodha and Company, along with his two sons. So the sons are also referred, Aditya Vikram Lodha and Harshvardhan Lodha. I say that the deponent has been indulging in various acts of professional misconduct, including falsification of records, furnishing of false information to the Institute of Chartered Accountant, and carrying on business in addition to the professional practice of chartered accountant without obtaining required permission of ICAI. As per partnership deed of Lodha, dated 1st April 2002, and the balance sheet and the profit and loss account, as well as the tax audit report signed by the firm's own auditor Chaudhuri P and Associates under section 44AB of the Income Tax Act of the said firm for the year ended 31st March 2004, there are only 3 partners of the said firm, namely deponent and his 2 sons named as above, whereas as per ICAI records, there are 14 partners in this firm. Similarly, the number of partners of Lodha and Company Mumbai and Lodha and Company have been reported to ICAI on as 8 and 5 respectively. But this is the exact allegation made in the complaint. Only in each of the said 2 firms, as per the firm's own balance sheets, profit and loss account, and tax audit reports. Clearly, the information supplied to the ICAI to the effect that Lodha and Company has 14 partners, has 8 partners, and Lodha and Company has 5 partners is at variance with the partnership deed, and is absolutely false, untrue, and misleading. Besides, the deponent has been also independently carrying on full-fledged business in the name of and through Albert Herbert and its subsidiary companies in addition to the professional practice as a chartered accountant. As per ICAI record, the deponent has been shown to be in full-time practice as a chartered accountant, and thus he has not obtained any permission of ICAI for carrying on such business along with the professional practice. There are other numbers of instances of professional misconduct of the deponent, which I shall crave leave to refer at the time of hearing. I annex here to a list of partners recorded in the ICAI records of Lodha and Company, Mumbai, and so, along with copies of partnership deed dated 1st April 2002 of Lodha and Company balance sheet. This is that partnership deed, the original of which was never produced. And balance sheets and profit and loss accounts, along with the schedules of the Lodha and Company, Kolkata, Mumbai, and Delhi, and tax audit reports of Lodha and Company, collectively marked as SS, copies of so and so. My lord, I state that the deponent committed the aforesaid professional misconduct to obtain more audit work or assignments, including tax audits and audits of large public sector undertakings as per the Companies Act. Inter alia prescribes limits for audits on the basis of number of partners of the firm. For such misconduct and fraud of the deponent, a complaint has been filed with the ICAI by some chartered accountants, and I shall crave leave to refer to the copy of the complaint at the time of hearing. This was filed, my lord, by these three complainants. Now, my lord, kindly take now what is the response of
This is a quotation from Kashinath Tapuria's thing.
affidavit. My lord, what is the response? May I take your lordship to the response of the complainants in their rejoinder or the counter, which they filed before the, my lord, this institute. But my lord, again, the pages may not match.
Yes, that is the difference.
That's করবে
এফিডেভিট এরম হতে পারে কি ডিপার্টমেন্টে পড়ে আছে আসেনি সেরকম হতে পারে?
মানে your lordship may kindly refer to this.
স্যার আমার কাছে একটা কপি আছে তো
Mr. Mujumdar,
have
the
one
difficulty is our officers have gone to the department and inquired. There is nothing else lying in the department.
Then, my lord, they are
So,
supposed to
most probably it was might have been filed in some court.
my lord.
Misplace.
Well,
That is
we
what
have
precisely-
copies. I think they also have copies. একটা কপি দিয়ে দাও না ডক্টরদের।
উনি কিছুতেই
আরে
record
ওরা দিক
করছেন
না,
ওরা
তুমি
বলতেন
অত লাফালাফি
record
করছো কেন?
করছেন, ওনার একজন কোর্ট অফিসার ছিল ভীষণ
ওদের document।
নেদর, এখনো বোধহয় আছে।
একই ব্যাপার।
সে কিচ্ছু রেকর্ড করতো না এবং কিচ্ছু রাখতো না, ফাইল সমস্ত মিসপ্লেস করে।
মানে
রেগুলার
we-
হ্যাবিট ছিল।
But it must have been misplaced, my lord. It happens, my lord. It's an old matter. Must have been misplaced.
আর অর্ডারে একটাও রেকর্ড নেই। জাস্টিস গিরিশগুপ্ত
তিনটে
অর্ডার
volume
কোনো
একটু
রেকর্ড
দাও না
করতেন
বাবা।
না, উনি যে ফাইল করছে। আমরা বলতাম যে অর্ডারে
আরেকটা
রেকর্ড করুন
copy?
যাতে
তিনটেই আছে?
প্লেস করুন। অর্ডারও রেকর্ড
আচ্ছা,
হতো না ও
একটু দিয়ে দাও। আচ্ছা, ওটাই
আমার
না?
নিজের হয়েছে।
ছেড়ে দাও। হ্যাঁ। আচ্ছা, দিয়ে দিই। কারণ ওদেরই তো রিকনস্ট্রাক্ট করতে হবে, আমরা তো রিকনস্ট্রাক্ট করতে পারবো না। হ্যাঁ। We have another set also. Your lordship, your lordships can have.
The pages.
We can treat this as the original.
Yes, yes.
They
They
are
have also
documents.
one set. এটাও দিয়ে দাও। We have scored out the name. It was briefed. Mr. Rai Chaudhuri.
You can retain the phone numbers, but if necessary, if the assistance is required, you can phone either of you. এবার আসল গন্ডগোলটা এবার শুরু হবে।
এটা কি আগের কোনো সলিসিটর ফাইল করেছিল?
No, no, it's an old matter to have.
What are the documents you are filing? We'll have a record. We'll record that in our order.
Yes.
And we'll
Kindly
treat
do
that
so.
as original.
Kindly do so, my lord,
The file-
because আমাদের কি আর কোনো
আচ্ছা।
copy রইলো না?
এটা নেই।
আমার কাছে আছে তো।
3D documented?
না, my lord,
আচ্ছা, ওটা
দুটো now, my lord, the page numbers would be in this case
5
2A. Your lordship will find at 598. It starts at 596. 2A is at 598.
yes,
My lord has got that.
598.
এটা বেটার হলো। ওখান থেকে তো হয় নাকি ম্যাটার?
তা নামিয়ে দাও, তা নাহলে পরে ভুলে যাবে।
My lord has got 598.
ইয়েস, ইয়েস, ইয়েস।
Now, my lord, I may take your lordship to the rejoinder filed by my lord these complainants to the affidavit in opposition, which your lordship will find it starts at page 708.
Yes.
My lords have got that. My lord, kindly take now paragraph 2A, which is at 710. Starts at 710.
Yes. Yes.
The pendency of the litigation between the respondents on one hand and the respondent's father on one hand and the Birla family on the members on the is wholly irrelevant in the facts of the disciplinary case. It will be apparent from the complaint that the charge specified therein relates to litigation between respondent's father and the Birla family, which by itself is a notorious fact. Kindly mark the expression which they have used. The litigation between Birla and Lodha is a notorious fact for Lodha. This is the opinion of the chartered accountant who files complaint with the ICAI. Then, my lord, they deny, they say, contrary to the allegations so as for the reasons our contents of subparagraphs under the paragraph under reference are entirely immaterial. So far as the complaints are concerned, they have no connection with at all with the center of social equity, and all matters between the respondent and the center are wholly irrelevant for the purpose of the proceeding, and no admission is made with regard to any kind whatsoever. Similarly, complaints have nothing to do with the disputes between DC Dharawa, the complaint. So this is a plain simple denial, but there is no substance in this, and I will prove that later on. Now, will kindly now take paragraph 2E. I will come to paragraph 2B later.
Yes.
2E. The respondents believe, bona fide believes, that any document or records as may be produced is likely to be used to be found.
No, this is 2E,
2E.
page 712.
Just 1 minute, my lord. Locus standi of the complainants. This is under the heading locus standi of the complaints under 614. This is another category.
What is the page number?
614. It starts under the head locus standi of the complainants. Kindly take 2E.
614.
614, 615. 614 is the heading A, locus standi of the
Yes.
P, C, then E.
You have come back to
615.
you have come back to a written statement.
Yes, come back to my written statement.
Acha, locus standi, yes.
Firmly believes that any document or records as may be produced or is likely to be used to be found the basis for further harassing and speculative actions to pressurize and coerce the respondent and his family members. So this is on my ulterior motive. So my lord, kindly come back to now 2B, which your lordship will find at page 601. So I have also alleged ulterior motive. This is very interesting. 2B. So first, my lord, I have pointed out to your lordship that all the complainants, particularly SK Sharma, my lord, I will take your lordship through his deposition even. SK Sharma was an employee of Kesuram, and the other two chartered accountants had some relation with Birlas, and they admit that in subsequent in the pleadings before this honorable court. Now, my lord, kindly now take paragraph 2B. The complaint contains almost verbatim the various assertions and charges made by the Birla family and their nominees and associates in various court cases against my father, etc. An illustrative list of various such instances is as follows. But allegations at paragraph 23 of the complaint, similar to the allegations of paragraph 9 of the affidavit of Kashinath Tapuria.
No, but Kashinath Tapuria, it was not Kashinath's complaint. He referred to these complaints.
He
it
referred
has
to
to be
this
similar.
complaint. He made allegations. He referred to this complaint. The complaint was made. He had in possession the complaint when he
He
was
referred
filed.
to those complaints and said in those complaints this has been written.
No,
So
my lord. Your lordship will kindly read that paragraph very carefully. First, he makes allegations that this RSL has committed a serious misconduct in terms of the ICI regulations. Then he says a complaint has also been filed, lodged. Kindly take that portion. First, he
Alright,
makes the
yes.
allegations. The
Yes.
allegations are independent of the complaint. Then he says to to substantiate his stand, he says the complaint has also been filed in this regard
Right.
with
right.
ICI. It is not that he got the complaint from the complainants and he just reproduced the complaint,
All right.
the
Yes,
contents of the complaint.
you're right.
Perhaps I have made myself
Clear. We have also seen that. Yes.
Yes. Now, my lord, kindly come now to 2BII. So, your lordship will find that the contents are similar. These are our allegation. 2BII, the internal facts. The internal facts concerning the power of nominations by Vilda, Telelinks and Universal Cable stated in paragraph 23 of the complaint are similar to those in paragraphs 37 to 39 of the petition filed at the instance of Birlas against India Telelinks Limited before Company Law Board. Allegations in paragraph 35 of the complaint regarding resignation from the board of Birla Corporation in April 1966 are similar to those made in paragraph 15J of the affidavit of Kashinath Tapuria dated July 8, 2005. Allegations in paragraph 50 of the complaint regarding description of the answering respondent as an independent director in the board of Birla Corporation, Universal Cables, India Telelinks and other companies in the MP Birla Group are similar to those in paragraph 15I of Kashinath Tapuria's affidavit dated July 8, 2005. Allegations in paragraph 48 of the complaint regarding the composition of the shareholders in the of Alfred Herbert India Limited and also the annexures of the complaint are and those concerning the business and affairs of Alfred Herbert India Limited and the annexures mentioned then similar to those mentioned in the said affidavit of 8 July. Allegations concerning Clark Gardner Wolf made in paragraph 51 of the complaint are similar to those made in the Company Law Board proceedings para 47 to 51 instituted against Birla Corporation and those made in the Company Law Board proceedings instituted against Vindhya Telelinks Limited, CP number 35 of 2005 at para 25-26. A clear indication that whatever was the stand taken by Birla in several proceedings, either in the testamentary suit or in my lord company proceedings pending before CLB, my lord, that stand was again reiterated in the complaint registered with my lord this ICI. So my lord, the nexus is apparent. Now my lord, having regard to this, my lord, kindly take kindly give me a second, my lord. Kindly take paragraph 30 of the writ petition of the appeal.
Give us the page numbers also.
I am sorry, my lord, it is page 24. That is, my lord, this is the petition. This is the petition. Yes.
24, yes. 30.
My lords have got that, my lord. May I read it out, my lord? It has been ascertained upon inquiry that one of the complainants, Sri Suresh Kumar Sharma, is an employee of Kesoram Industries, a BK Birla group of company. After receipt of the present complaint, the petitioner has made inquiries, has come to learn that complaint number 1, Sri Om Prakash Agarwal, is also dependent on the Birlas, and his main source of income is from various kinds of services rendered by him to BK Birla group of companies such as Kesoram Industries Limited. Sri Shashi Agarwala, complainant number 2, is a chartered accountant who does not have significant independent work and whose main source of income is derived from rendering various kinds of services to various companies, mainly BK Birla group of companies. All the companies are acting at the behest of Birlas, and in particular Sri BK Birla. The complaint does not disclose that any of the complaints has been affected or prejudiced by any of the activities of the petitioner. So, my lord, now kindly take the affidavit of the complainant in response to my petition. There is the affidavit in opposition, where they have dealt with the allegations made in paragraph 30, which is at, my lord, their complainant's affidavit, page 18. Complainant's affidavit, my lord. Complainant affidavit. এটা কি ভলিউম আছে কিছু? This single volume. Om Prakash. Om Prakash affidavit তো Om Prakash. Om Prakash. হ্যাঁ ঠিক আছে। Om Prakash.
This is in ACA 6.
ACA 5. Everything ACA 5. This is also not available.
5, nothing else is available. Only the petition is available.
দিয়ে দাও।
Everything was filed. I don't know why.
Where? When?
Should I give you another copy? Not
When and where? Filed? Otherwise, we cannot trace out. Not in the department that we have traced out.
We have served them. We have served them.
We have. We are asking when and where it was filed so that we can trace out.
I'll just check the orders, not as far as I recollect.
If it was before a particular bench, there would be no order recording that.
I cannot copy.
February 2015, we have
Mr. Mondal says 27th February 2015 order.
opposition
Where?
filed.
Which court?
Affidavit in opposition filed by respondent number 2 and
Have you
4.
got a copy of that order?
Yes, it's in my iPad. My lord, may check. 2 and 4 though.
2 and 4.
27 February.
Which court? Which court?
Justice Mathre's court. Lord, it was filed.
Code number?
Just a
16,
second, Lord.
16, 13 or 16
The
she will sit.
16, my lord. Justice
16,
Matre-
yes.
Justice Matre used to sit in court 16.
16.
17.
17.
Now much
Normally-
water has passed through the Ganges after that.
But I will make another copy and
Do that.
We
Others.
have one copy. We have one copy.
আপাতত তুমি
হ্যাঁ দিয়ে দিচ্ছি।
রিয়াফার্ম যদি জোসেফ করাতে
এই
বলতে
যে
সেটা
তোর কপিটা।
হ্যাঁ অর্ডার দেখে তো লাভ নেই আমার
তাহলে-
তো লাগবে তাহলে
We have one copy.
রেসপন্ডেন্ট নাম্বার 1 করে দিয়েছে আবার শ্রীজিৎ চক্রবর্তী 2 and 4
Mark থাকলে
পাবো কোথা থেকে? ওই কোর্টের তো আর এখন থাকবে
অর্ডারটা পেয়েছেন
তাহলে it may be marked, my lord. My lord, kindly note the markings, my lord.
কাইন্ডলি হ্যাভ আ লুক এট
We'd rather look at the markings.
অর্ডারটা দেখ
একটা কপি রয়েছে একটা কপি তো হবে না।
দেবাশিস করগুপ্ত সাহেবের ঘরে মার্কিং থাকলে জোসেফ তো পছন্দ করতেন না একটা মামলা আর একটা কপি তো আমার কাছে সফট কপি আছে ভাই সরি মানে লিকুইড টেক্সট ফাইল
We'll continue on next Wednesday. You just engage somebody to ascertain which papers are
তাহলে
lying
we
with
will
us and
do the housekeeping job. That
then
will
we'll come back
that
next
will-
Friday.
Aditya,
next
tweet
Friday.
Mr. Mondal will also be here to check the
Wait,
record.
I mean, just you check up with our officers when we are.
But I'm
We have two
extremely
copies, my lord. We have two copies.
Then we can proceed.
sorry. দেখো দেখো
And your copies, if you give up all the copies, then nothing will remain with your
Fine,
juniors.
I'm very much embarrassed.
Another copy, my lord.
You require assistance also. They won't be able to help you.
তোদের কপি নেই নিজেদের কাছে?
সফট কপি তো আইলি
Soft copy
হার্ডকপিটা কোথায়?
লিকুইড টেক্সট
বড় লোকদের
Absolutely. 100%. You're absolutely right.
অর্ডারে রেকর্ড আছে না। আমি তোমায় বলছি না
But another order has to be recorded now.
And this is the inconvenience of no. This was recorded in Justice Matri's order.
দেখো 27 ফেব্রুয়ারি
No. This we have to treat it as original.
But that order, another order has to be.
Happy. And this is the inconvenience of physical copies. ছয় চলবে না।
কোনটা দেখো আবার
করো না ছোটদা ও ছোটদা রেডি করে আনি না এই অসুবিধা হচ্ছে যখন
না করে দিই আমি আজকে সুযোগ পাবো না আমি তা কোন দিন কোথায় আটকে
Because Mr. Relying on other documents also.
মানে I will be relying, will be mainly on the documents which have been used in ACA 5. Because
Yes, because ACA 5 we have only the petition probably.
no, your
nothing
lordship now has petition, now has
Another
your lordship,
one affidavit.
and one affidavit we are getting for the lordship.
একবার তোমাদের রিপ্লাই গুলো আছে কিনা একবার দেখে নাও।
দেখিয়ে দিন ওনাকে
তোমাদের
কি
রিপ্লাই
কি আছে।
আছে কিনা
These are also available regarding ACA 5.
আমাদের reply আছে,
অপোজিশন গুলো even ICA এর opposition
replies are there, my lord.
Nowadays we don't look into thin documents. We have lost the habit of looking unless it's thick.
তার কোনো কপি নেই,
We দেখুন কি
বুঝতেই পারছি না
ও কোনো হার্ড কপি নেই।
কত সাথে
it would be better if you had soft copies also. With difficulties with liquid text we are not being able to implement it. I mean tried level based.
মানে
So convenient is unnecessary these things.
this is
We'd have it on our
Yes.
whichever device we have.
তুমি তো সব কোটে যাও সব কোটেই তো অনলাইন
যেতে দিবি না তো?
এটা কি
Oh, আচ্ছা। No, that is
তো মানে what do we do, my lord? হ্যাঁ
No, but,
reply now,
এখানে
কত
তো কিছু
লাগবে?
করার নেই, আমার
But-
সফট কপিতে রিসার্চ করতেই হবে, এভাবে সম্ভব না, ফিজিক্যাল আমি পারবো না, দিনের পর দিন
Then what do we do, my lord? Do we then, my lord, whatever your lordship would direct us, we will do that. Whatever is convenient to the court, my lord, that we will do.
না না আমরা সব @gmail.com.
করে দেবে
So, my lord, do we do the matter next day or whatever your
I think you
lordship?
do it next day and we'll just
আর তার মধ্যে উইল জাস্ট গেট দ্য
Then we
ফিজিক্যাল
come
কপি
back on-
অলসো ফর মালিয়াসি কুমার মিলর মালিয়াসি কুমার ফর হিজ লর্ডশিপ মিলর উইল আইপ্যাড ইমেল উইল ডু
ইমেল আইডি দিয়ে দিন, তাহলে আপনাকে পাঠাই।
জজ সাহেব
পারবেন
ইমেল
তো
আইডি
ঠিক
করে
Let us take up the channel.
Kindly give me a minute, my lord. Kindly give me.
ইয়েস জজ সাহেবকে তো ইমেলটা লিখে দিন তাহলে খালি
That
রাইট
is
ডাউন দ্য ইমেল আইডি
That is the best
Is it bookmark
convenience,
and all
the
that?
bookmark and all. And we can take notes there and all these things.
not bookmark yes
Oh,
But 16,
there.
my lord, we come back next week.
you don't have to go to the pages just hyperlink touch that
It's understood, yes.
It is very easy, my lord.
It will take a day or two for us to adjust. I mean, accustom ourselves. No difficulty on that, but we don't have liquid text.
I will email to Justice Kumar also no right now we are
Yes.
sending the link
Lordship should go for an iPad now.
iPad, yes, but iPad is not compatible with many other things, devices which I have. And these free softwares are not available. For official work, we don't need free software. So
Only one software that has increased the sale of iPad is liquid text.
yes
But then
Only due to this software.
available in Android.
That's only for lawyers.
So if I can, when we are provided with iPads, if I'll have to
Yes.
get savvy to that. I mean,
it's very easy 5 মিনিট
It's very easy, very easy. very
এখানেই
So
শিখে নিতে পারো
one of you from each side come to my
এখানেই
chamber so
শিখে
that there is
নিতে
no question of
এখানে
bias and
don't say all
we how to
this.
use the iPad
Yes.
once.
5 মিনিটও লাগবে না
Now I'll personally have to let us see.
and it's very convenient
I'll
to
record a
use
short
now.
vacation for that.
Nothing, my
But
lord.
for the
one-
time being,
one
send.
weekend will do.
1 week.
1 week. Right, right.
That will be
yes.
easier for us.
So soft copies we are, my lord, we
Rather, we are wanting marked copies,
Yes.
and you will code it in a particular color. They'll do it in another color. I mean, yes, you can choose your color. You can choose either green or saffron, either of the two. We don't prefer red nowadays. So
Do you
either of the
still
two.
with red is it still with red
Man, better to use gray because we remain in that region.
But we don't have 50 shades. So how do we proceed about it? I mean, I'm in a quandary actually.
We will transmit the copies to your lordship's email.
For the timing, transmit to the email.
Transmit to the email, and in the meantime, we will also get hard copies for the court records. It would be necessary, my lord. It would be necessary, I believe. I believe because the lordship would have to record a formal order. It's a kind of
Yes, a soft
reconstruction of the
copy we
file.
can use when I mean doing our judgments. I mean
For
writing our
convenience, that is
judgments.
for convenience.
For
but
convenience.
The court records, my lord, hard copies.
Yes, you're right. You're right.
So we will do that in the meantime. We come back on 16th. I conclude on 16th. I will
Would
take-
you like to come
take-
prepared with this your brief written notes of arguments referring to the pages
I
also?
will,
Or that
I will,
may be difficult because they haven't yet
they
argued.
have to.
Convenience note করে দাও।
But we are ready.
But he is more accustomed with this he will do the needful by today
He is very good.
all
You send us the links and we'll go to the links and do the download
right now
and put it on a folder in our tab or whatever.
link টা right
Download করে পাঠাবো। My lord, I will send it the download
Yes.
version.
Everything will download and keep it.
Sorry.
Yes, we'll keep it on a folder.
The downloaded version, the PDF version of the appeal, the oppositions and the applications, my lord.
Yes, for the time being, send the papers of this soft copies of ACA 5 only.
My lord, I shall.
5 only for convenience, and can you put it in different folders? I mean,
My lord,
one set of pleadings of the.
And they will be sending one link. If that link is clicked, all the documents will be available. They will assist. Well, Aditya can also be there.
Yes.
They will assist your lordship.
Mr. Mukherjee is very tech savvy. He can.
No, we know. Yes.
file টা we will check the file also in the
So someone, if you in the link where it's obviously stored in the cloud, there you can put it in folders. For one folder for the
Done.
petitioner.
Pen drive এ
Oh,
দিবি না?
But we can do it in pen drive also.
Yes, that's
So the link that will be easy. Pen
Link.
drive we won't be able to use in tab.
Oh, acha. ठीक.
Tab. So send a link.
ठीक.
না হচ্ছে না ওদের tab Samsung
Then it will be easier for us. We will just go to that link when we sit here and hear your arguments.
মানে maybe take back the opposition, last opposition. we
Last
can do.
opposition ফেরত দিতে হয়। Yes.
এটা
কিন্তু আমাদের অ্যাফিডেভিট গুলো
আর কোনো
নেই,
আছে?
না, অনেক কিছু।
এটা reconstruct করতেই হবে।
যেটা রেকর্ড করছি সেটা থাকবে। ওটা থাক। হ্যাঁ। Very well.
না।
At the time of hearing,
দেখিয়ে দিচ্ছি
যা লিখেছি তারপরে না হার্ড ইন পার্ট করে দিন। হার্ড ইন পার্ট নেক্সট প্যারা। However, during hearing, we face inconvenience due to non-availability of certain pleadings which were filed by the parties at a previous stage of the hearing before a different court. Full stop. Next para. As such, learned counsel for the parties are requested to send soft copies of the relevant pleadings to our respective email IDs at the earliest. Full stop. The matter shall be taken up for further hearing on July 16, 2025. To try to do it by the weekend at least, so that we can.
There are only one permission from your lordship
মানে
lord to
ACO
check the file
ACA 5.
ACA 5.
We are not mentioning. You send.
We will do that. We will do that.
lord
Yes.
to check the file lord
And they can
kindly
assist.
kindly allow us to
ওটা
do
ফাইল
that
দেখতে দিলে দেখে নে কি কি আছে না আছে।
টিফিনে পরে আমি জানিয়ে এলাম
আচ্ছা, side
And may I take your lordship's kindly?
Yes, yes, absolutely.
নিয়ে না নাম্বার নিয়ে না
Correct. Mr. Kaur is also there.
Lord, yes, but your lordship was communicating on a subject with the right person. Because this just went above
No,
my
but we cannot nowadays. We cannot avoid.
No, but Mr. Kaur is also very good in lord
No, only if it is
by
fed
this
into
time.
my system, And then, Lord, with touch of hand, sometimes it goes here, there. So there has to be somebody to bring it back.
No, it takes some time. I have taken that. It was a jump actually. Obviously, we used it in our home and all these things, but it was a jump to bring it in court and for the first time referred to it. That was a psychological, hurdle we had to. It's a mindset problem.
It's a very, very
Totally a mindset problem.
And it's an improved system.
But sometime we'll take some of your helps. For getting acquainted with the iPads. I think that will be much easier for
I
us.
think your lordship should take the help of.
We have iPads. We have been provided with iPads.
Read the liquid text also.
Has the iPad the easiest thing possible?
Then it can be transferred right now.
No, but I haven't yet used it. I'm more comfortable with the tab, with the Samsung tab, but I'll do that.
I heard
Will-
a word saying that something can be airdropped. So I asked my junior, the gentleman here who knows about it, that why can't it be airdropped? It's supposed to be the most convenient way. I'm told that the Samsung iPad that
Doesn't
you
have
mentioned
that.
doesn't have that airdropping system.
No, therefore it's convenient for us to use the iPad.
Send the link. Yes.
Yeah, we'll some of these days we can call any
In
of
fact,
your
if my lord brings your iPad tomorrow,
In the Apple universe, it
Apple Universe. Yes. Yes.
if my lord brings your iPad tomorrow, we can airdrop the file also in court. Then that-
iPad, I am not accustomed as yet, so it will be
Acha,
difficult
acha.
for me to operate. Let me
very well, very well.
not getting time, Mr. Chakravarti. So many CAVs.
Whatever is the
Everyday CAV, everyday judgments can't handle.
absolutely.
We'll do it in some vacation. এইটার মধ্যে ঢুকে যাবে ইয়ে আমি পরে ম্যাটারটা আইপ্যাডটা হাত দিতে হবে আমি কোনোদিন করেছি কিছুদিনের জন্য করেছিলাম liquid text will try to convince our chief justice is personally tech savvy, so we'll have to convince the computer committee through him.
As I'm with Millard, it's very easy. Millard, we are reading 10.
You are all using it. You are also using
Millard, it's just like one click.
bookmarking and hyperlinking and all.
At page 2555, just a click, Millard goes there.
No, I'm very interested.
নম্বরে কি শিখিয়ে দিয়ে এসো ভালো করে।
No, that we can call any of them. I mean, all of them are savvy.
That is better, my lord.
Yes, we'll do that.
Your
Once,
lordship is much ahead
liquid-
than me, at least I can.
no, not much ahead, but it's a mindset problem actually.
Absolutely, absolutely.
It took only Millard 3 minutes for me to
For
understand.
you, it is
While
3 minutes.
Millard, we are doing a matter, my other side Millard taught me in the Alipur court sitting that the other matter is going on.
Liquid text.
It takes 3 minutes. It will take.
But the right person has to teach you. One person came to give a demo once, but he couldn't understand my questions also. I mean, so it has to be an advocate or a judge or whatever. Our biradari. Yes.
For the advocates. It doesn't work for me, not good for any other person.
Judges?
Millard, means our professional means.
Yes, yes.
It doesn't suit Millard any college student.
No, not college student. The people from that company came. I had sought for a demonstration, but he couldn't understand many of the questions. The wrong person was sent probably.
That's right, that is the.
It's very easy. 3 to 5 minutes.
No, my peculiar problems he couldn't understand. That bookmarks, suppose there were certain
What's
typical.
call him? He will make you understand, my lord.
Millard, my will first go by the initial stage. Millard, bookmarks are at the advanced stage. No point. Millard will kindly give, Millard, make, there is a page which will come side by your document.
Yes.
It's a legal, college legal. Now Millard start writing. Just mark that page. Millard, just
Pull that page. Pull that.
Just pull
No,
that
we'll have a demonstration. Let us not use the code time for that. Yes.
page. If Millard goes Millard 2000 page down also, that
Let
just
us have the liquid text first. I'll have a talk with the chief justice.
dot, it will bring you there.
We'll try to have the liquid text at least on our devices so that we can do that.
My lord, before Lordship takes up this matter, my lord, item number 3.
Yes.
My lord, Mr. Jishnu Shah is appearing this matter, my lord. He's on legs in court room 36. Will it be my lord's pleasure?
Let Mr. Datta complete,
Fine,
then
fine.
if necessary, we'll put it to some others.
Hey, lordship had heard me.
Yes.
This is with regard to that maintainability of the suit on the ground of pendency of a matter before the Thika controller.
Yes, absolutely.
Number one, I just want to add 2 more judgments, my lord.
Mr. Datta will hear you. You conclude your arguments. We'll give some time for Mr.
Yes,
Shah.
no problem. No problem. My lord, I had shown your lordship
Yes.
that the learned trial judge had relied on a judgment, my lord, is reported in 2011, volume 3 CHN.
but which in fact has coming no help for passing the decree and ignoring the proposition that the ouster clause is contained in section 21 of the Act. No
Yes.
civil action cannot be maintained. Well, it is in fact the bar under section 9 of the Civil Procedure Code. Now, my lord, there are two judgments. My lord, one judgment of your lordships sitting in singly in a revisional matter. This point came up, and your lordship has also held the same line as I had argued before your lordship. My lord, this judgment
Mr.
is
Datta, did you hand over a copy of 2011 3 CHN?
2011, yes. On the
You
last,
had handed over on the last fetch.
your lordship, I read from my book.
Oh, book. Can you just arrange for photocopies
Yes,
during
I
the
will.
course of the day? That will do.
I will. I will.
Can do it during the course of the day also. If you have copies, then
Right now.
right now, right now.
বলা যাবে 20 মিনিটও শেষ হয়ে যেতে পারে ইচ্ছে করে করে দেবো 20 মিনিট এসছে সবসময় লগে লগে থাকবে আগের দিনও তাই করলে আজকেও তাই কি করবো
Yes. So this was referred to by the trial court in what context?
in the context of maintainability of the suit.
Uh,
The view of the landed trial judge that although the matter is pending there, but since it has not yet been determined whether I am a tika or not tika, so therefore there is no bar for the court to proceed in the
but the first issue formulated was whether it's a ticket tenancy or not.
Absolutely. Absolutely.
That has to be decided by the
Has to be decided.
section 5.3. But in this judgment also the 5.3 was considered.
And there is
This is governed by the West Bengal
West
ticket
Bengal
tenancy, the
220.
new one.
Yes. Because
You want to add something?
because the initial act of
Yes.
71
That was Calcutta.
Calcutta, there was even then there was no ouster clause also.
No,
This
no,
is the
no.
first time it has
That
been
is why
used.
we asked to that.
Yes.
Yes.
Now, my lord, second point, my lord,
Repeal and savings was also there. You also addressed that this does not come under that. Very good. Second point.
second, not the same point, the another judgment, my lord,
Yes.
your lordship was, my lord Justice Bhattacharjee was an occasion to deal with that. My
Yes.
lord, this is reported in, my lord, দিয়েছো? reported in, we লিখে নিতে পারো 2021 SCC online cal 2338. কপি এক্সট্রা কপি আছে না এক্সট্রা নেই রে yes 3055. My lord, statewide, if your lordships kindly come to
Yes.
233 দাদা তো নাম্বারটা মেলেনি তো
এসসিসি অনলাইন আপনি এটা কোনটা দেখছেন
বইটা কোথায় এটা তো অন্য বই দেখছি মা আরেকটা কপি দাও মালনা আই ডোন্ট হ্যাভ এনি আদার কপি নেই দে
আপনি কপি পান না এখনো?
নো নো নো
No, I can follow from the SCC. আপনাকে কপি দিন আমি SCC
নো আই হ্যাভ গট কপি
আপনার কাছে কপি আছে? আমি
2021 SCC online cal 2338 and the
yes.
yes
Para
233
para 30.
para 39 40 and 41. Para 39 40 and 41. May I place this, madam?
Yes, yes.
From another perspective, a conjoint reading of the preambles of 2021 Act and 1995 Acts and Article 246, 251 and 254 of the Constitution of India clearly indicates that 2001 Act passed by the state legislature of West Bengal received the assent of the President vide notification number so as published in the Kolkata Gazette, Extraordinary Part 3 of November 22, 2002. Hence, The same prevails in West Bengal over all repugnant provisions of the 95 Act, which is the piece of central legislation. Even if item number 28 of list 3, concurrent list of the 7th schedule of the Constitution of India is taken to be the category under which the 2001 legislation comes, the operation of Article 254(2) attributes primacy to the 2001 Act. That apart, but this is important, that apart, it may very well be argued that the subject matter covered by the 2001 Act falls under item number 18 of list 3 of the 7th schedule of the Constitution, which confers primacy on the 2001 Act, a state legislation in any event. Comparing the language of the preambles and the objects and reasons of the two pieces of legislation and a non
There was a conflict between the Waqf Act and the
yes,
Wismar
that
Treaty.
was the point
But
taken that the
That is not available here
the point was taken the Waqf can
in that matter.
that matter.
Here in your
Here
case, it is not.
the Waqf.
Here, para
Even then the court said, my lord, held, my lord, the last 3 lines.
Central Act versus
Yes.
we looked at the 7th schedule of the Constitution, concurrent and the in both cases special statute, and this would prevail. Non-obstante clause is also there. But para 30 is clear that the power to decide on the issue as regards whether a property is a Thika tenancy now within the specific domain of Thika controller and not the civil court anymore. Para 30 hits you directly.
That's right. My lord, and one more judgment, my lord, may I also
Yes, yes.
rely on? 2016. 2016, volume 3, Calcutta Law Journal. বই আসেনি দাও বই দাও 281
What is the name of the parties?
Lalit Kumar Bagla and Rajiv Kumar Poddar. Copy নেই But I am relying on paragraph 111 and 112. My lord, kindly see 111.
You don't have a copy? You are trying to
কপিটা তোমরা
পাঠিয়ে দিয়েছিস কেন আমি মানে gives me a moment.
May I hand over my book, my lord, kindly?
So that will be one copy. We are trying to just
If your lordship kindly share this book, my lord, kindly. I'm very
please hand over.
kindly share. 111 and 12, my lord, I have ticked it.
Wait on. Lalit Kumar Bagla versus Rajiv Kumar Poddar. Yes, it's also there in the SCC only.
Division bench, my lord, Justice Banerjee, Indira Banerjee. তারপরে দিয়ে আমার কি হবে?
Alat can look into this.
দর্শক ওখান থেকে দেখছি
No, this is Justice Showman's chain.
But I'm handing over that letter. The airdrop it to myself.
No, this is in the SCC online. It's there.
Yes. হ্যাঁ এসএসসি অনলাইন থেকে পাচ্ছি
Give us the SCC online citation. 2016. Cal 12156. We'll find it out.
Malak can have a look. Justice Kumari.
Justice Kumar has a book,
Oh, Mali.
but you don't have it. You give it to your senior.
116 তো 111
11
Hmm.
ঠিক আছে? এটা তো ইন্দিরা ব্যানার্জি নয়।
ইন্দিরা ব্যানার্জি আর শাহিদুল্লাহ মুন্সি।
সোমেন সেন।
ইন্দিরা ব্যানার্জি 112টা দেখে।
ডিস্টার্ব করছে। Well, I'll take your copy. Oh, you have only one. I'll get it.
Now, my lord, 112 minutes for lordship's kindly sees,
Yes.
maybe as argued by Mr. Mitro, an order with that jurisdiction is a nullity and can ordinarily be challenged in collateral proceedings. However, in view of the specific bar of the jurisdiction of the civil court under section 21, the execution court cannot, under order 21 rule 97 to 99, decide the question of validity of an order passed by the Thika controller under 2001 Act, including the question of whether the order of the Thika controller is without jurisdiction or not, cannot be decided by the civil executing
This
court.
is paragraph?
Paragraph 112.
সিভিল এক্সিকিউটিং বা সিভিল কোর্ট স্ল্যাশ
So civil court, executing court / civil court. So neither of the court has got any jurisdiction, my lord, because of this ouster clause in section 21 of the Act.
Yes.
So therefore, my lord, in view of this settled proposition of law, my lord, my respectful submission that the learned trial judge made a gross mistake by not appreciating this.
The act is very clear actually.
Act is absolutely clear. Act is absolutely clear. And I had shown your lordship the summons issued by the Thika controller on the last day, this pending before the Thika controller, whether it is not being heard or being delayed, that is not in my hands. And my lord, even by consent, we cannot give direct jurisdiction to the court. Suppose it is argued before your lordship, the rent was tendered at certain point of time, that itself also does not give the civil court to entertain the action when the action is pending before the Thika controller.
Rent was tendered where?
Initially, the rent was tendered to the landlord, and thereafter we have given a notice that since we are coming under the provision of this act and matter is pending before the tribunal, so we are not going to pay any rent to you. We will pay rent to the Thika controller, and we have made the payment to Thika controller. Those are also the matter of record. Page 181.
Very well.
Exhibit R, page 181 of the paper book. Lordship will find the letter which were written by us to them intimating that no rent is payable to you. It is covered under the Thika Controller Act.
Page 181.
Page 181.
Oh, okay. আমাদের member page. Thank you.
This is addressed to the plaintiff. We were your lessees and tenants under the lease deed agreement dated
Page 181.
page 181, volume 1, exhibit R.
Exhibit R.
Yes.
We were your lessees and tenants under the lease deed, lease agreement, and etc. in respect of the land as per details given in the schedule below. The said land now stands acquired and vested in the state of West Bengal under the Calcutta Ticketancy Acquisition Act 81, West Bengal Act, with effect from 18 January 82, from which date the said act came into effect as notified under the notification number so published in the Calcutta Gazette, extraordinary dated so. Accordingly, we are liable to pay the rent in respect of the said land to the state, and no rent is payable to you on and from the said date, and you are liable to refund to us the rent already paid for the period between 82. Please note that in view of the above, no further payment of rent will be made to you under the aforesaid arrangements. And my lord, the summons which was issued, my lord, lordship will get it at page 176. The same volume 1, few pages before. This is the summons, my lord, issued by the Tika controller, and the date was fixed, and thereafter the date was changed from time to time, my lord. So therefore, it shows that the matter is pending before the
And you are also, Mr. Shah may also argue section 116 of the Evidence Act, but that is not applicable because that only pertains to the inception of the tenancy. You cannot challenge the title of the landlord at the commencement of the tenancy, but subsequent he has lost title, you can take that point. 116 does not cover that.
That's
Sir, to 174 টা দেখুন,
কি আছে?
notice
This is to give notice to you.
174 টা
Oblige your lordship.
So you'll have to answer this. Well,
Oblige your lordship.
টিকা কন্ট্রোলারের নোটিশ, অফিসার ইন চার্জ টিকা কন্ট্রোলার।
And my lord, also exhibit 1, that is at page 174, may be, my lord, considered. It is a notice by the Tika controller,
yes.
174.
স্পট ভেরিফিকেশন পরে ঠিক দেওয়া আছে,
Yes.
স্পট ভেরিফিকেশন মাথা বলা আছে।
And the last line, be it noted that in the event of your absence, the spot inquiry hearing will be completed and decided expert.
দেওয়া আছে স্পট ভেরিফিকেশন ঠিক দেওয়া আছে নোটিসের নিচে।
আর এটা তো ওদের, এটা তো আমাদের।
এটা আমার তো, হ্যাঁ আমরা এক্সিবিট, আমাদের এক্সিবিট
Notice for hearing,
স্ট্রোক স্পট
spot verification under West Bengal Ticketancy Act 2001.
Yes. Summons on 12th of May and this spot verification notice 20th of May.
20th of May.
Very good.
So my lord, these points have not been considered by the learned trial judge at all. And he, my lord, as I had shown your lordship, the learned trial judge had proceeded on the basis of
That judgment.
that judgment, which has got no application, my lord, as far as the present matter is concerned.
That's all.
কোনটা? না না, ওটা আর কিছু কেন, আননেসারি এক গাদা জাজমেন্ট দেখি কি হবে না।
সিএল যেটা কপি দিয়ে
হ্যাঁ, one judgment copy is not, I will hand over your lordship.
16 সিএল যে মেলেটা
16
The last one.
So, my lord, those
You're
are
concluding
some-
your, yes. Next Wednesday then for you.
Can it be Wednesday week, my lord?
Wednesday week
Side
we will
we have
not be,
some-
this bench will not be there from 21st July to 1st of August. We'll be in Jalpaiguri. So both of us actually.
No, আমার একটা-
So then we'll have to keep it on 6th of August. We can keep it next Wednesday.
My lord,
Mr. Shah won't be there or you won't be there.
I have some personal difficulty on that.
You have a conference in the meantime and keep your learned junior.
No, my lord, if there's a matter, Mr. Shah is required, my lord.
Yes, no, have a conference with Mr. Shah in the meantime. You go there, take your junior.
Today
Your
I'm
junior
here,
will be there to
Mr. Shah
assist.
is on legs, unfortunately, otherwise
He
would
is
ready
not
to do
there
the
next
matter.
week. He will not.
I will be in some difficulty, my lord, personal difficulty.
Junior
That is what we are
is also very competent.
No, we know that. That is the premise. You can have a conference with Mr. Shah immediately.
Had a conference
Have
with Shah.
you have another conference with Mr. Shah, tell what he has said, tell what we have said, take him with you, and on the next date when you will not be there, he will be there assisting. Because this is a part-heard matter, we want
My lord,
to,
I can appreciate, my lord.
we can carry, we
I had
can,
no intention to take adjournment today, my lord.
no, we know
No
that,
intention,
we know
my
that,
lord.
you,
But he
you
is on
never
legs-
take unnecessary
he is
adjournment.
on legs, my lord, so I'm not insisting for.
We
further
could carry something to Jalpaiguri also as a memento of Calcutta, and we could finish the judgment in Jalpaiguri. Anyway,
But my learned friend has not placed section 27 before lordship, my lord.
you will do that, you are there for that.
I will do that, my lord. Because it is a pending litigation, my lord, in 1995. But there is a distinguishing feature is, my lord, the suit was filed on the expiry of the lease in 1995.
So it's covered by
So
the
it is
saving
covered
clause.
by the
Saving clause.
savings clause, my lord. This is what has not been argued at all.
Let him argue, I'll give reply.
Yes, I will argue.
Well,
I will argue. And there is a single, my lord,
heard learned senior counsel appealing for the appellant. Full stop. On the prayer of learned counsel appearing for the respondents, let the matter stand adjourned and next be listed on August 6, 2025 for further hearing.
deeply obliged, lordship.
Thank you.
Deeply obliged, lordship.
Next Wednesday,
6th August.
6th of August.
of August.
না ঠিক আছে ওই এর মধ্যে নোটগুলো আমার আছে This matter is over. We'll come back for the next matter after 10 minutes. Fantastic. Yeah, Colonel.
My lord, I was humbly praying. I should point it out to my lord. I was praying for to be excused, my lord. On the last occasion, Mr. Chaudhary had appeared, my lord. He's online, my lord. The clients had expressed the intention to obtain change from the erstwhile advocates and they had executed a wakalatam on 25th of June, my lord. We had sent it for change, but change has not been obtained. And the letter also, erstwhile advocate is not accepting, my lord. It is our mistake, my lord. We appeared on the last occasion, my lord.
And
without
made
the
submissions.
Wakalatnama, my lord. I was praying humbly to be excused, my lord. Change that is between the erstwhile advocate and the
You know
appellant.
the law. You can, you can send it by registered post with aid if it comes
I
back.
shall do
So
it, my lord. I shall
you can
do
take
that.
leave from the court and also so that we
shall
can
do it.
regularize the previous hearing also. Otherwise, time was, their time was also wasted. So when should you keep it? Tell us. Next week?
My lord, it's unless they can resolve the issue, my lord, the erstwhile client, we are ready, my lord. We had taken up, we had sent the wakalatnama also, my lord. At least for a fortnight subject to my lord.
Till when? Because we will not be there from 21st to 1st of August. Jalpaiguri bench, both of us are going.
The week before that.
These are specially assigned, so we have to take up.
The week before that subject to my lord.
16th. 16th, that is 16th. 1 week from now. We have 2 weeks before 21st.
My lord, in case I'm only intimating, my lord, in case change has not been obtained by us, till then also I will be humbly praying only to be excused, my lord, because we cannot appear without the change.
Well, then the appeal has to be dismissed because
We will not
the
disrupt
present
proceedings, my
advocate
lord.
is not appearing.
We will not stand in the way, my lord. We will not, because without wakalat,
Let us keep it
no
on 16th
authority,
then.
my lord.
Let us keep it on 16th, Lordship. Learned counsel who had appeared on the last occasion on behalf of the appellant submits that that counsel had appeared under the mistaken impression that a change had been obtained from the erstwhile advocate for the appellant. However, subsequently it was detected that no such change was obtained, and as such, learned counsel who addressed the court on the last occasion, as on that date, did not have the locus standi to represent the appellant. As such, an adjournment is prayed in order to ascertain whether a no objection certificate can be obtained from the erstwhile advocate in the meantime. Accordingly, let the matter stand adjourned till July 16, 2025 to enable learned counsel for the to enable the appellant to take appropriate steps. In the event the appellant is not represented by counsel with valid wakalatnama on the next with valid authority on the next occasion, appropriate orders may be passed in the absence of the appellant.
Grateful.
Appellants, my lord.
আচ্ছা plural করে দেবেন appellants. Thank you, sir. Appellants হবে যেগুলো appellant বলেছে appellants. Thank you.
My lord, with leave of my lords, should we put in the names, my lord? Our names are because we have no locus, my lord. That's the
So we
problem.
have recorded that at least one of your names, please give.
We shall do, my lord.
Because you are referred to your submissions.
Yes, lord.
Please give your name. ওনাদের নামে অ্যাডভোকেট পদে রেসপন্ডেন্স দেবে আর এনাদের নামে শুধু অ্যাডভোকেট, ঠিক আছে? যে অ্যাপেলেন্টের অ্যাডভোকেটের নামটা দিয়ে শুধু অ্যাডভোকেট।
Grateful.
Thank you. ওনার নামটা শুধু দিন, হ্যাঁ ওনার নামটা শুধু দিন অ্যাডভোকেট।
Great.
Yes, Mr. Madam.
May please, your lordships, this is my appeal.
Right.
My lord, one formality perhaps has to be done, my lord, so far as preparation of paper books are concerned, my lord. Because what I have with me, my lord, is the stay petition, which has already been disposed of. I think there was a direction by an earlier bench about the trial court's records being called, but I
It's
don't
an
know.
intra-court appeal.
It's an intra-court appeal, yes.
5 years intra-court. So paper books, was there any direction?
No, in fact, Justice Tandon, who was presiding over an earlier bench, he had said, my lord, that the trial court records should be brought before this court.
but I'll bow down to whatever your lordship's pleasure is.
You are the appellant. You are for the.
I'm the appellant, yes.
So can you prepare paper books, informal paper books, without comparing with the records? Do you have all the papers?
I think we do. Achha, na? Yes, yes.
How soon can you do it?
10 days, my lord. 10 days? 2 weeks. 2 weeks.
No, we'll have to give you 3 weeks because we are not there
Yes,
for.
I just heard. Yes.
So we'll keep it on 6th of August and we'll direct the.
I'll serve a copy on the other side also in the meanwhile.
Very well. All of you are for the appellants.
We are all for the
Oh,
appellant. There's nobody appearing for the respondent.
very well.
In fact, last 2 or 3 occasions, nobody's appeared for the response.
We can take care of that. We'll hear it expertly if they don't appear.
If that.
But serve copies of the
Yes,
papers.
yes. So that might prompt them to come.
Right. Learned counsel appearing for the appellant rightly points out that although the stay application has been disposed of, comma, the appeal is yet to be heard out, full stop. Accordingly, we direct the appellants to prepare and file the requisite number of informal paper books without comparing with the records within July 31st, 2025. Push up, advance copies of the same shall be served on the respondent as well. Push up, the the appeal shall be listed for hearing on August 6, 2025.
Grateful, my lord.
The trial court records be brought in the meantime. এসে গেছে নাকি trial court records?
আচ্ছা, save it. আচ্ছা, না, trial court records তো আসেনি।
I'm so grateful, Your Lordship.
কেউ নেবে না কাপুরের এগেন্সটে বায়াস আমরা যদি ছাড়ি কেউ নেবে না হ্যাঁ খারাপ কাজ করলে রবির বাবা তো আমাদের
That could it be taken up next Wednesday?
Yes.
But I am deserted by my junior today. If your lordship.
I'm really glad, Lordship. I am also in a very bad position. I am.
Very well. On the prayer, then we'll put it on both council.
Yes, absolutely, absolutely.
Gladness on record. On the prayer of learned counsel for the learned senior counsel for the appellant and as well as learned counsel for the respondent, let the matter stand adjourned for the day. For the day means next Wednesday.
Yes, highly obliged.
Yes, Mr. Banerjee, seeing you after a long time in court. Yes,
My pleasure, well, to be here.
it's both ways here.
But
You
I'm
are for the appellant.
respondent.
Oh, the pleasure would be very short then. None appears for the appellant at the time of call, although the respondent is represented by learned senior counsel. Full stop, next para. Let the matter stand adjourned for the day. It will come up next week.
Next week. Very well.
For
Tomorrow
the day, for this bench means next Wednesday.
Very great. Richard.
হয়ে গেল অ্যাপেলেট সাইড দীপঙ্কর এবার বলো থ্যাংক ইউ জাজমেন্ট আছে তো যারা জীবনে পাবলিক কনভেন্সে আসেনি আজকে তারাও টাইম চাইবে জন্ম থেকে যারা গাড়ি চড়ছে তারাও টাইম চাইবে
Maybe I'll have to mention order 41 rule.
Yes.
Your Lordships, kind leave to mention a matter.
We took it up first, yes. Application is, yes, ma'am.
For inclusion in the list.
What is the matter?
Application.
Yes. Thus, FA number 156 of 2019 is dismissed on contest, thereby affirming the impugned judgment and decree dated August 17, 2017, passed by the learned judge, 4th bench, City Civil Court at Calcutta, in title suit number 1130 of 2018. No address to cost, interim orders, if any, stand vacated, formal decree be drawn up accordingly. You are appealing?
Yes, I am for the respondent.
So there is no risk of any stay being paid for.
Nobody is appealing for appellant.
Damage done. Yes.
Much obliged.
Next. 2. Yes.
Respondent number 1 to 10.
Respondent.
My lord, pursuant to the last order dated 25th November 2024, my lord.
The last word.
They are supposed to file the requisite paper book, informal paper book.
They have not yet given any copy to it?
4. Paragraph number 4 of the order.
Yes. None appears for the appellant at the time of call. Push up. It is rightly pointed out by learned counsel appearing for the year for 11, year for 4, 1 to 10. Learned counsel appearing for the respondents rightly point out that in the order dated November 25, 2024, we had directed the appellant to prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from that date. First up, however, we are informed that no copies of the paper books have yet been served on the respondents. First up, we extend the time of filing paper books for a week from date. First up, the matter shall next be listed on July 16, 2025 under the same heading. First up, it is made clear that appropriate orders may be passed on the next occasion if the appellant remains unrepresented and/or fails to file paper books. If they fail to file paperwork, we'll have to direct you.
So short default, in default, I mean, the matter should
No,
be.
default,
Because 6
no,
weeks.
today you have that resolution.
No,
That's
no, but I will to appear. I am
Yes.
also appearing.
Yes. Mr. Basu is appearing.
Yes.
We can't see him. We are not sure whether it's him or. Mr. Basu, don't have a repeat of either Gujarat or Delhi, so better not to be
No,
seen.
no chance. No chance.
Then, yes. Delhi was red shorts. Gujarat the last two. We are keeping a track. Calcutta High Court is ahead in all things, but in this we are lagging behind.
No, one day someone was doing from the shopping mall. The
Shopping mall is
was
not so high.
furious.
Yes. Shopping mall is
Furious.
not so no, yes. The status is not so high like the other ones. Anyway, Mr. Basu, we'll take it up next Wednesday. See? Yes, Mr. Sabud, what is the matter?
This substitution application, my lord. My lord,
Substitution application. Have you served a copy or this is for the first time?
I have served, my lord. One has been delivered, my lord. Others dispatched. Long back I have served, my lord.
What about the other?
Other not yet.
Other was a pro forma respondent. You
Yes,
did not,
yes, my lord, yes.
you did not seek any relief against him in the court below. Relief sought.
No, substitution, usually.
Substitution within time?
Within time, my lord.
Oh. Very well.
Service.
Thank you. The affidavit of service filed today be kept on record. First, although proper service has not been effected on both the respondents, comma, since the application is one for substitution, since the application is a formal application for substitution filed within time, comma, we choose not to direct further service. Full stop. The application is otherwise in time and in form. Full stop. Accordingly, can 1 of 2025 is allowed, comma, thereby directing the heirs and legal representatives of the deceased appellant number 1, comma, as the particulars of whom have been given in paragraph number 2 of the application, comma, to be substituted in place and stead of the said deceased appellant number 1 as appellants in the appeal. Full stop. The necessary consequential amendments to the cause title of the memorandum of appeal shall be carried out by the learned advocate for the appellant during the course of the day. No arrest to cost. Any other application is pending?
No.
What is the defect? Let us see. Title suit number you have given in this, in the preamble of the memorandum does not tally with the decree.
I will.
You correct that, we'll give you leave right now.
Yes.
What is the appeal against?
Suit for specific permanent, my lord.
Suit for?
Specific permanent, this is 34. Specifically,
Your suit was dismissed.
my lord.
You don't have any interlocutory application.
No, my lord. Since at present not, my lord. I will.
So we'll direct you to put in postal cost and direct the paperwork to be prepared. Very well. Leave is granted to the learned advocate on record for the appellant to rectify the preamble by inserting the correct number of the title suit. First of such rectification shall also be carried out during the course of the day. 2 corrections. Names of parties.
Yes,
Push up next para. The appellant shall put in postal costs and due appellants shall put in postal costs and due requisites for service of notice of the appeal on the respondents, comma, within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Within 1 week, special messenger, postal cost, corrections right now. Yes.
But defendants.
What happened to you?
Yesterday I met with an accident in
court.
In court.
You fell down?
No, I did not fell down. While I was getting down from the bus, it was wrecked and I was
Oh.
blessed with it.
Are you all right now?
Right.
Yes, Mr. Mondal, what is the
We are for the defendant appellant.
good service effect? No, these are only postal receipts.
My lord,
No.
this is the
Oh, the ID cards are there.
yes, my
All
lord,
have been served.
yes, my lord, except pro forma respondent.
Perform, you are not claiming any relief.
My
This appeal arises out of what suit?
order of remand, my lord. Suit for partition.
Partition suit.
Remand.
Order of partition suit was dismissed.
Partition suit was dismissed.
Against that, you preferred appeal.
Preferred appeal. Well, they preferred
They preferred appeal, remanded.
my lord. Against the order of remand.
So, what is the ground of challenge here?
Ground of challenge, my lord, all materials are there. There is no need to.
Order for Rule 24.
Yes, my lord.
So, appeal court should have itself.
My lord. Could have decided.
Very well.
My lord,
Affidavit of service filed. There was a previous direction of service.
direction of service.
Affidavit of service filed today be kept on record. Full stop. It transpires therefrom that apart from the pro forma respondent, comma, all the other respondents have been served. Full stop. Next para. Accordingly, since none appears for the respondents at the time of call, we take up Can 1 of 2021 for hearing. Full stop. Next para. The learned counsel for the appellants argues that the learned appellate court, first appellate court, comma, instead of remanding the matter by the impugned judgment, comma, ought to have decided the appeal himself or herself. Let us himself, comma, since all the relevant materials and evidence are already on record. Full stop. Since questions of law and fact are involved in the appeal, comma, appeal was already admitted previously.
Admitted.
Involved, comma, we find that a prima facie case for grant of stay has been made out. Full stop. Accordingly,
Stay granted for a limited period.
Acha. Accordingly, Can 1 of 2021 is disposed of, granting stay of all further proceedings in title suit number 54 of 1997, pending before the learned civil judge, senior division at Tomluk, district Purbo Medinipur, after remand till disposal of the appeal. Full stop. The appellants shall put in postal costs and requisites for service of notice of the appeal on the respondents, as well as the pro forma respondent, because it's a partition suit, as well as the pro forma respondent within a week from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Postal cost and special messenger within a week.
Within a week.
ডিফেক্টটা দেখে নি, যদি সেরকম হয় তাহলে ডিফেক্টের preamble is below. None appears for the parties at the time of call. The learned advocate on record for the appellant is directed to carry out the necessary corrections in the preamble of the memorandum of appeal in terms of the defects as pointed out by the stamp reporter by July 11, 2025. Full stop. The matter shall next be listed under the same heading on July 14, 2025. যদি আসে কারেক্ট করতে দেব।
May it please your lordships, my lord, this is my petition.
Yes.
My lord, very innocuous prayer we have. My lord, all the submissions which are being made by my learned senior friend, my lord, are perhaps submissions which can, if at all, be made before the trial court. My prayer here is very innocuous. There was a direction by your lordships that we have to file an affidavit in opposition to the injunction petition, which is required to be heard out by the learned trial court. But we have affirmed within time, we have served within time, we couldn't file it within time. Now it is on the file of the learned trial court. But my lord, there's an order because there's no extension formally. The learned trial court is of the view that unless you seek for this extension and it is granted by the honorable court.
Mr. Bag, on the last occasion, Mr. Chaudhary indicated, we have not heard him completely, we will hear him today also, indicated that it was not, you missed 2 or 3 dates after that.
We did, my lord. We did. It was affirmed. That's what my submission is, my lord. It was-
Affirmed and served in time.
Yes, my lord. And we missed dates.
But why didn't you file on the next,
My lord,
very
they
next
were-
available
my lord,
date?
They could not file it. My lord, that is the fact. So I cannot, my lord.
What is the reason given in your application?
Nothing. My lord, it was filed, my lord, after.
Apart from nothing, any other reason?
My lord, no reasons given, my lord, because
10 days, what? 10 days?
my lord, 10 days, my lord. And I'll indicate, my lord, kindly see paragraph 4.
No, the dates were being fixed in quick succession then. 2 dates passed within 10 days.
No, my lord. No, my lord. Kindly see the dates were. This is GA3. Can 3. Can 3.
10 days?
Can 5, not can 5.
No, no.
This-
Can 5 is what?
Can 5 has been
three.
served today. Can 5 has been served today.
I am appealing
Can
for the
5
defendant number 4, my lord.
Can 5 stands on a
We have
different.
filed, my lord, Can 3. Defendant number 4 has filed this. A very similar application has also been filed by another
My lord, we'll
defendant, but that's
consider 3
defendant
and
number
4
3.
first.
Then well, let
To
us
start
take up
off.
3, yes.
My lord.
Can 3.
But kindly take up my pleadings. My lord, the first line at page 3. My lord, is the time frame given by the Honorable Court, which we have pleaded, 18th March, is when the written objection was affirmed. Paragraph 3, my lord, page 2, the last 2 lines. 18th March 2025. This is within the period of, my lord, 3 weeks from 3rd March.
3 weeks
So
from
that was
3rd
within-
March comes to 24th.
24th. No, this is affirmed on 18th. That's our pleading. Now, thereafter, can you see the next paragraph?
Yes.
And also, my lord, the middle of the paragraph, my lord, in page 3, paragraph 3, we have explained the applicant was advised that ordinarily affidavits and written objections were filed on the dates when proceedings of the matter would be fixed before the court, even though they are affirmed earlier. The applicant was further advised that this was done as per matter of practice. If filed on off dates before the Sheresta of the court, there were chances of misplacement of the documents.
This is the Alipur court.
The Alipur court, my lord.
And served when?
My lord, thereafter,
Correct.
my lord, kindly see 24th March it was served upon the new advocate on record, but that's paragraph 4, my lord.
Yes.
The last 3 lines. And the returnable date was given on, my lord, 10th of June 2025. 25th, my lord, 22nd of May, there was an application for addition of parties by
No,
Roktima Chatterjee.
after you didn't, I mean, the timeline expired on 24th of
On
March.
24th of March. my lord.
Before that, after that, what were the dates fixed in the code bill?
22nd May, my lord.
22nd May was the next date.
My lord.
When
The next date here it is,
you
my lord,
filed your
pleaded-
addition of.
These are all annexed in my affidavit in opposition.
Anyway, let us get the dates. Yes.
The next date, my lord, kindly see paragraph 4. Returnable date of the matter was 10th of June 2025 of this matter, my lord. In the meantime, Roktima Chatterjee filed an application for addition of party under Order 1 Rule 10.
Returnable date for the injunction application.
My lord.
Original.
The original injunction application? I would
Sir,
say original, the injunction application, my lord.
Roktima filed this application for addition of party on
On
22nd
22nd May 2000
May. That was on by a put up petition.
by a put up
Regular date.
regular dates. my lord.
Then how could the
It could not. My lord, the main date was 10th of June. That was the date for, my lord, the injunction. That explanation is given in the previous paragraph that we couldn't file. We did not file it because the papers would not be perhaps in the proper
let us
records.
look at affidavit in opposition টা কোথায় আছে? Affidavit in opposition টা file করছে?
Affidavit in opposition?
Well, just to
But
clarify,
kindly take up-
that was the original date fixed, but after my lord's order, the date was preponed upon notice. By the lower court, because my lord had directed expeditious disposal.
Right.
The 10th of June, whatever was passed before we came up.
My instruction is by then, my lord, there was a change in the advocate on record, my lord.
Your side.
So their side of the plaintiff, my lord. My lord, thereafter. So my primary objection is, my lord, my learned friends are not.
After 22nd May, the next date was 10th. Any date
Was
in
10th.
between?
My lord, 10th was the date for injunction all throughout. So, my lord,
No, Mr. Chaudhary says it was preponed.
preponed to which date?
Apart from that, there was no other date
No
in
other date.
between.
No other date.
It was not taken up
not
on
for the injunction petition. There was a date for their other applications where, my lord, they wanted to. That's 22nd.
No, we have to look at the.
22nd May. My lord, I'll kindly take up the affidavit in opposition.
Yes, we'll look.
Page 59, my lord.
Opposition টা বার করে দিন। Hand 3 টা রেখে দিচ্ছেন।
My lord, kindly take up page 59 of the affidavit in opposition.
3 এর opposition লাগবে। রিপ্লাইটা দিয়ে দিন 3 এর রিপ্লাই অপশন দুটো লাগে ওটা 4 3 and 4 এর একসঙ্গে আছে আর 3 এর রিপ্লাইটা দিকে
Kindly see this order speaks for itself, my lord.
দেখা যাচ্ছে তো টাইম লাগে হ্যাঁ ঠিক আছে ঠিক আছে let us come to the opposition
My lord, the opposition, page 59, there are orders which are annexed. Very important, my lord, the deity. Kindly take up, my lord, page 59.
was preponed by the order.
And that was never served on us. Kindly see, my lord, the first line. Record is put up on the strength of a put-up petition filed by the learned advocate for the plaintiff number 1. That's the deity. Plaintiff number 2 is not represented here, my lord.
No.
The learned advocate for the plaintiff number 1, deity in the suit represented by competent person, not served. We were not made aware of this, my lord. That's my
this
instruction.
was not Shopna Mukherjee Shopna
No, my lord. No, my lord. Made a petition on affidavit apprising the court regarding the FMA order, my lord. That's the order passed by my lords. And prayed for a short date of hearing for fixing the hearing. Considered it is required to mention herein that on 21/3/2025, plaintiff had already filed a copy of the above FMA, but due to resolution taken, matter was not taken up. Perused, and my lord, kindly see the underlined portion. The hearing date fixed on 22/5 is preponed and shifted back to 7/4. That's the date, my lord, for the filing of Order 1, Rule 10.
they were to communicate this date to you
My lord.
did they
Of course,
They have not communicated, my lord. That's my instruction.
how did they appear and take steps?
Mr. Choudhary, please don't comment let him finish this is not proper yes
We are not for defendant number 2, no?
Mr. Bak please
Can I take
continue
up page 60, my lord, thereafter. 7/4/2025.
Hmm.
Step taken by the plaintiffs as well as on behalf of defendant number 2.
you are for
We are
defendant
for
number
1
two?
and 4, my lord. 1 and 4. Kindly see, my lord, the second last paragraph. Learned advocate representing the defendant numbers 1, 3, and 4. So that includes us, my lord. Were also present in the course of the hearing, but from record, no respective steps have been taken, have been found on their behalf. That's because, my lord, there were different matters for which they were present. There's nothing on record to show, my lord, that they have served it on us. We knew it that this matter was going on. Kindly see thereafter, one learned advocate representing plaintiff number 2 was also present and challenges the locus standi of the learned advocate representing the plaintiff number 1 deity. Herein, but the wakalat number filed herein by the learned advocate is devoid NOC. So but today the problem is my learned friends have filed, my lord, the affidavit in opposition without being added as a party to the main suit.
Now, how
They
could
have
you
been-
appear on 7th of April unless you are served with some notice
But we have not. That's the case. Well, my instruction is that they were appearing for some other matter. They were there in court, and that's what is recorded. The learned advocate representing defendant numbers 1, 3, 4 were also present in the course of hearing, but from record, no respective steps have been taken because, my lord, they were not informed. They did not know about this matter. They were present in court, and that's what is recorded. Now, thereafter, the next date is 22nd of May. That's page 61, my lord.
next
And
date
this
was
is for
fixed on-
hearing of Order 1, Rule 10.
no, next date was fixed on 28th of April 25 on 7th of April 28th of
On
April was
28th of
fixed
April was
for-
fixed, my lord, for the
for hearing of the injunction application
of the injunction application. I'll take your lordship to, my lord, because there is no order there.
so in your presence it was fixed on 28th of
My case is, my instruction is this, my lord, because I was not there. My instruction is very clear. I'll indicate what my instruction is. They were present in court. They were not intimated about, my lord, this order. And they did not know this proceeding is going on. They were present for some other matter. The court noted that, kept this, but, my lord, they did not know. Now, kindly see what is the next date, my lord. This is for further hearing of temporary injunction petition filed on behalf of plaintiff number 1.
that is
That's
this
the deity.
injunction yes
That's the date.
that is this injunction to which you have filed to you
Plaintiff number 2. That was plaintiff number 2, my lord. Who is representing? He is, my lord, plaintiff number 1 is the
the
deity
injunction
simpliciter.
application regarding which you had to file written objection was filed on behalf of the plaintiff number 1
By plaintiff number 2.
maybe but it was the application of plaintiff number 1
Yes, my lord, I'm not even going there, my lord.
the injunction date of the
Today, my lord, if this is the, my lord, kindly see the next order. Kindly see that's on 22nd of May 2025.
that is the order of 28th of April we don't find it
My lord, 28th of April, my instruction is nothing happened. The judge did not sit. The honorable judge did not sit. So nothing transpired on that day, my lord. The next date is 22nd of May. And this was the day, my lord, which is fixed for hearing of the Order 1, Rule 10 by by 3 parties, my lord. For addition, this was not. Kindly see the last paragraph of the second last paragraph onwards, my lord. After perusal of record, it also reveals that one another petition of Order 1 Rule 10 dated 4/4/24 is also pending adjudication. None of the contesting defendants have filed their respective written objection in respect of the impugned petition. After perusal of the record, it also reveals that on 2nd of May, this court received an order of the Honorable High Court wherein it has been directed by the Honorable Court to dispose of the injunction application expeditiously as possible, and even the learned advocate representing the plaintiff number 1, the deity, made a submission for disposal of injunction petition along with the petition for Order 1 Rule 10. Per contra, they stress to dispose of the petition under Order 1 Rule 10 first. It has been submitted contesting defendants that plaintiff number 1 is unrepresented. That's the contention, my lord, the second paragraph. And unless and until impugned order is not disposed, impugned petition under Order 1 Rule 10 is not disposed of, there will be prejudice considered, peruse the records, and my lord, can you see the underlined portion? Accordingly, matter is fixed for hearing of injunction petition. Next date is 10/6. That's the day when we bring this on record. That's a pleading in paragraph 4 and 5 of the petition.
That 10/6 was originally also the date.
Originally also the date
before
for
this
injunction,
7/4.
my lord. And then we placed it on record on 10th June. It is in the court
In June
records.
you
my
file
lord.
it.
We filed it. It's on in the court records. Now, if my lord, the real urgency is hearing of the injunction, this entire process is only delaying, my lord. My endeavor is we want to go and have the injunction heard. We have filed it. It's in the court records. My lord, I'm praying for a formal recording of an extension. I'm praying for an extension, my lord, so that this can be considered by the Honorable Court, by the learned trial court, and the matter may be disposed of on merits. It's a very innocuous prayer that I'm making. My learned senior friend is going into the merits that will be decided by the learned trial court. Lord, may I only indicate the order of 10th June, that's at page 31 of our application, my lord. When is the next date? 1st July to where? 1st July. Page 31 of the petition.
Is 31.
Well, it's 10th June. Page 31 of the petition, madam.
Yes.
Can 3, madam. So the last paragraph.
Yes.
At page 31. May I only indicate the first 3 paragraphs also? It was Order 1, Rule 10. The 3rd paragraph, learned advocate for defendant numbers 1 and 4, filed affidavit in opposition. That's us, my lord. Defendant number
Order
1.
1 Rule 10 is yet to be disposed of.
Yes. It's yet to be disposed of, my lord. Against petition under Order 39, Rule 1 and 2. So, my lord, we have filed it on 10th of June. That's the 3rd paragraph. Copy served. Let the same be kept with records. Now, my lord, thereafter, consider the last paragraph, my lord. As per submission advanced by the answering and contesting defendants, and after perusing the records, it is apparent that none of the contesting defendants have abided by the order of the Honorable Court as enumerated in paragraph 77 of the impugned order, keeping in mind that the contesting defendants, more fully defendant 1 and 4, had served their respective written objections to the advocate representing the plaintiffs on, will kindly note this date, this is within the time frame given by your lordships, 24th of March 2025, but filed the same before this very court on this day, on this even day, and prayed that their respective written objections have annexures which were very much essential for the pleadings, and if the same is not accepted by this very court, they will be highly prejudiced. They pray for adjourning the matter for a short period so that they will move the matter before the Honorable Court to seek extension in this regard is considered and allowed for ends of justice, but
Yes,
as a lone exception only. Only this, my lord. And can you see the next page, my lord? The date is fixed on, was fixed on 1st of July. Now I'm told, my lord, that the next date has not been given yet. So, my lord, this is the very short premise of my application. We are at fault, my lord, but I'm only beseeching your lordship, my lord, if this can be extended, the matter may be heard out on merits, my lord. I'm being led by Mr. Banerjee, my lord.
Yes, you have heard substantially, Mr. Yes, Mr. Chaudhary, what do you say? You can give a reply.
Only one thing, Lord, only one thing I must please, Lord, give me half a minute for this. The entire attempt, what is being done today, is also being sought to be done before the learned trial court. A person who is an alias, today a person who is really a phantasma as far as the cause title is concerned, is coming forward and entering appearance on behalf of the deity. I don't say that he cannot ever try to come within the area of parties, but there are means and procedures under the law for him to do so. Please have a look at his advocate on record just once. It's my duty to point it out. I had requested my learned junior friend appearing on behalf of, instructing my learned senior friend for the ghostly party who is not a party, not to press this misadventure any further, but they choose to do it at their peril. Now they are before a division bench of the highest court of the state. Let them press it to the hilt. Will not kindly see who is the advocate on record. The advocate on record is one Miss Shomoita Das Chaudhary. She is my younger sister at the bar. May God bless her.
What is the worst part of that?
The person whose purported signature, under whose authority she appears, my lord, is that Wakalatnama there before your lordship, lord? That will be, I can't ask a question of the honorable court. Please, lord, would your lordship permit me to have a look at the Wakalatnama, if any?
Why? What is the difficulty?
The difficulty is that this gentleman, this lady who has been told to appear, enter an appearance on behalf of a party, of a person who is neither a party nor an applicant. In the court below, he doesn't say he represents whom. He says, I represent the deity. Then he says, I am part of the persons who appointed the second plaintiff, and now the second plaintiff has turned turtle. These are valid points he can take. But for that, he has to make an inroad into the suit.
So what is the difficulty in the advocate on record?
The advocate on record today holds a Wakalatnama executed by X. The only question...
She holds the Wakalatnama for the Swapna Mukherjee.
She holds a Wakalatnama
executed by Swapna Mukherjee on behalf of the deity.
Swapna Mukherjee has executed a Wakalatnama on behalf of someone else to appear in matters in connection with this court. In the Alipur court, Swapna has instructed someone else to appear. That's because my learned senior friend's client, who was making a lot of submissions yesterday.
So obviously, because now there is a conflict of interest, Mr. Banerjee.
Yes.
Now Roktima has come up and she says that I am the Shebait, I should represent the deity. So naturally, Swapna did the right thing. That does not cast any aspersion on anybody.
No, I'm only on what authority, representing whom.
Roktima must have given
But may I please have a look at the Wakalatnama. I generally don't do this. I'm not going to press this to its hilt. But it
you
is
will take her word from her mouth. Yes. Roktima has executed the Wakalatnama in his favor, in her favor. Dekhiye ek minute. Din.
Wakalatnama file hi hoyni ekhon.
You have not filed it as the original has been filed. Huh? Original has been filed.
This is the original. No, this was not there in the department. I sent my person yesterday.
See it.
Roktima Chatterjee Shebait is not a party here. Is not a party. Yes, I'm returning.
Not a party.
Not a party here at all. Let her, if she wants to say anything about that.
You have crossed that half minute long back. Let me hear. Let us hear him. Yes. Yes, Mr. No half minute.
His entire aim today is, my lord, to get observations from this honorable court. So
you had the prior right of hearing as a senior government, but both of you. But you failed. Mr. Bagh was there. We have heard him. No, even then. So what?
No.
What do you want to add, Mr. Chatterjee? That expression. You want to add that expression? Very well. We have accepted. Yes.
While, my lord, his only...
No, so you're speaking too much. Yes.
3 seconds. His only aim is to ensure that there are certain observations in this order which will help him in the trial court. My lord, kindly, my lord, protects that much.
So we'll give that observations and dismiss his application. Yes. Yes, Mr. Chaudhary, what are the what are the substance? Yes. Not the entire history, Mr. Chaudhary. The merits of the matter will be gone into by the trial court while taking up to Order 1 Rule 10. First of all, what locus standi do you have?
I'm not talking about the merits of the main matter, but the merits of the application for extension definitely need to be gone into by my lord.
Absolutely. And your locus standi to take that point, because you were not a party then, you were not a party to the suit as yet.
I am appearing on behalf of the deity. The deity was a party then, and the deity is a party now.
You are a self-proclaimed representative of the deity.
No.
Just as Ms. Swapna Mukherjee is.
No. My lords have held me to be a Shebait.
How?
My lords order dated 3rd March.
In this matter?
Yes.
So that is all on an...
My lord, that rules my lord has held me to be the deity.
No, that was not a conclusive finding at all. And even if you held, it did not fall before us for consideration. This question we did not deal it on merits. Whether you were actually a Shebait or not,
my lord, this is
we never decided it conclusively.
My lord has not held independently. My lord has reiterated the finding of an earlier division bench as recorded in my lord's order.
Earlier division bench in what matter? In a so that's on the merits of your order 1 rule 10. As of date, you are not a party to the suit.
Who am I? That's the question. Ruktima is not a party to the suit in an individual capacity. The deity is definitely a party to the suit.
Yes.
When, for example, in the case of a limited company, the company is a party to the suit.
Yes.
Ex-director signs a wakalatnama being authorized by the board. In this case, it is the board of Shebites who are supposed to act as the board of Shebites authorizes the Shebites to represent the deity. That representation was made. The board of Shebites took a resolution authorizing Shopna to espouse the cause of the deity. That board of Shebites has thereafter, due to the conduct of Shopna, again resolved that such authority has been withdrawn and that authority has been given to Ruktima. So Ruktima can appear as a Shebite in a personal capacity. Ruktima can also represent the deity. The deity is a perpetual minor. It has to be represented by somebody who's authorized by the Shebites. I have now been authorized by the Shebites.
That is on the locus standard.
Huh?
That is on the locus standard.
That is on locus standard.
Yes.
Not only that, my lord will also see the conduct. Shopna is not even appearing today, has not appeared at any time to oppose these applications. But now on to the...
But Shopna was an appellant who obtained this order.
Shopna was an appellant who obtained the order. Yes.
This application is filed on behalf of both the appellants.
The petition on which my lord's order of 3rd March was passed on behalf of both the appellants,
then
including Shopna.
Shopna is before the court. Shopna is before the court.
No, Shopna
is the appellant number 2.
Shopna was before the court then. I'm saying, in fact, is Shopna before my lord today? No. Has Shopna appeared at any time before my lord to oppose these applications filed by the defendants? No. Did Shopna ever take any steps to communicate the order dated 3rd March to the trial court? No. Did Shopna open her brief before the trial court to move the application for injunction? No. Why? The facts are there in the affidavit in opposition. Why they did it? This application, my lord, let us now go by what they say in their petition. My lord will first, just to point it out, my lord will take page 36 of my affidavit in opposition. I'll just show this and then I'll move on.
Yes, 36.
No, ওইটা কোথায়? এটা কোথায়? হ্যাঁ, application 36 এ তো অন্য জিনিস আছে। বলিনি? হ্যাঁ, 36 থেকে স্টার্ট হচ্ছে, ওইটা কোথায় আছে? ওইটা কোথায় আছে? এই পেজটা ওইটাই নেই। না, ওটা খুঁজে বার করো। ভুলভাল পেজ নাম্বার দিলে কেমন করে? Very well, my lord will see what reasons they give and what is the explanation. My lord, this part of it was placed. My lord will take the petition at page 3.
Yes.
My lord, the second line, the last word, it starts off. The applicant was advised that since the applicant had affirmed the said written objection / affidavit in opposition within the time as stipulated by this honorable court, the applicant's written objection in opposition would be considered if the same was actually filed in the records of the suit on the next date fixed in the matter. He said this is an advice given from somebody, contrary to my lord's specific direction to file on a particular date. Let's go on. The applicant was advised that already affidavits and written objections were filed on the dates when proceedings of the matter would be fixed before the court, even though they are affirmed earlier. The applicant was further advised that this was done as a matter of practice, since if filed on off dates before the Sherista of the learned court below, there were chances of misplacement of the said pleadings. So they were advised to file it when the matter is taken up for hearing. My lord will see the orders that were passed on that day. Order block of number page. Order block of number page. My lord will now take page 59. I'll just show the orders that were passed. Order set My lord will take page 50. Let's come to page 59.
Yes.
a lot was said about 10th June. 10th June was the date that was fixed prior. This date was not a sacrosanct date because my lord asked for execution disposal. This being brought to the notice of the court, the date was brought to it. My lord will see what it said. And he says again, who were paying? They said that they have served upon the advocate on record for Shopna before the trial and the deity before the trial court. They say the afternoon opposition was served on such a person. My lord will see from the order itself, I will show that such advocate on record was someone whose authority has been disputed by the trial court because this person filed the wakalatnama without even approaching the advocate on record for a change. That advocate on record who was there was never served. That advocate on record has thereafter given a change on behalf of the deity on the basis of the resolution to the Shabites in favor of Shamoita. My lord will see the learned advocate for the plaintiff number 2, plaintiff number 1, deity in this suit represented by competent person. This was me. The court found that I was a competent person. This question fell. The court saw and said that I was the competent.
It was a premature observation of the
Very
court
well,
before allowing the order 1 rule 10, Mr. Chaudhary.
It has not been allowed.
Therefore, this is a premature. Unless that is allowed and held in your favor, how can it be said?
I am not. I'm just pointing out what.
Because you pointed out, you had to point out.
I'm pointing it out. I'm not relying upon that. In any case, British considered it is required to mention here the plaintiff has already filed a copy of the stated FMA due to resolution taken by the bar. The matter was taken up. This was I filed it. They did.
Yes.
Peruse the solemn order of the High Court, and accordingly in compliance with the same, the hearing date as fixed on 22/5 is preponed and shifted back. 274. They say they did not know, which will be everyone was served. The court was satisfied of this, and as has been recorded. My lord will see.
Where is that recording?
My lord will take page 60. And actually, the first line itself says today is fixed for hearing of the temporary injunction matter. My lord will.
Yes.
My lord, 1, 2, 3, 4th paragraph. Affidavit of service has been filed on behalf of one Shoykot Nondi learned clerk for the advocate for plaintiff number 1. This was, let the same be kept with the record. They knew, and that is why they were there.
It only says that affidavit of service, one affidavit of service is filed.
Yes.
But please come to the penultimate paragraph with asterisks.
Yes, I'm coming there. I mean, so an affidavit of service was filed informing of this order of preponement. That is why they were there. It is
only recorded one affidavit of service has been filed.
Yes, the
What is
context
written
of the
there, not there, but rather it's circumscribed by this penultimate paragraph. No respective steps have been found on their behalf.
What is
the meaning of that?
Steps. In spite of them being served, they did not take steps. They were present in court.
Hmm.
They were served. They're different advocates. They were all present in court, all by coincidence. Affidavit of service is there. The court never sets out the contents and affidavit of service. But the court was satisfied. The court does not say that service has not happened. Court records the affidavit of service.
All right.
And my lord will see fixed 28/4/2025 for temporary hearing or hearing of temporary injunction petition. So this date was fixed for temporary injunction. The next date was also fixed for temporary injunction. In this order, contrary to what they have stated here, contrary to their express advice by their lawyers, they chose not to file any affidavit in opposition, nor to indicate to the court that an affidavit in opposition has been affirmed by me. I forgot to bring it. It is lying in my house. It is not there. This was the date when, according to their own pleadings, they were supposed to have filed it. They did not. 28/4, the judge did not sit. But the matter was fixed. My lord, I've also given my lord will take the last page.
22nd of May.
Now, the case status. 28th April was adjourned till 22nd of May for the same petition.
Yes, there's no.
So he says so it was not fixed for any different purpose. So even though it is not recorded, maybe that when the court has said it is fixed, order 1, rule 10(2). But this was also fixed on that date, as will appear from the last page. 28th was adjourned till this date.
It says
28th April. went to
hearing of
20
petition. Which petition is not clarified? Hearing of your information slip at the last page says hearing of petition.
Yes, but that was fixed for my lord will see. Yeah, case sheet dekha daw. But the petition bole.
Business on date where it, I mean,
My lord will see it was fixed on the 28th of April.
28th of April, business on date where it is stated business on date is 28th of April. That is the slip of the hearing date has been fixed. Next date of hearing is 22nd of
Yes.
May.
So what is the business as on that date has been adjourned?
Purpose of hearing of petition.
Yes. So which petition? The hearing that was fixed on 28th April. I mean, that can't disappear. That can't disappear. That petition has been fixed. The court has to pass an order on that petition.
But Mr. Chaudhary, at the same time on 22nd of May, the first sentence the court records, record is fixed for hearing of petition under Order 1 Rule 10.
I know.
So the court itself says that today is fixed for hearing of Order 1 Rule 10.
Yes.
How can we get over that?
Hmm?
So therefore, how do we know that it was also fixed for injunction? And nothing in the information slip indicates that. And court itself records only one. Court does not say today is fixed for hearing of the injunction application as well as the Order 1 Rule 10, which is normally done, you know that.
Normally, I admit that is normally done.
But that is not done here.
That application couldn't have disappeared. It was fixed for a particular purpose. As they say in Bangla, where is it gone? So that was the understanding. That's how it was fixed. So they didn't file it on that date.
Forget the word understanding in this matter.
No, so even on
rather on this date,
very well on
fixed 10th June as
very well. But even on 22/5, this matter was fixed. The records were there. If they had filed it, it would not have got lost. That was the advice. They did not file. And they didn't even mention that it is there. I've affirmed it. I forgot it to bring it.
Right.
Three dates they do not file it. And how do they explain this in the petition? What do they say about it in the petition? What do they say in the petition? Is there any explanation in the petition why this advice of their lawyers was not acted upon? I have not found any. Actually, the impression has been given that we did it as on that date, and that was the date. And my lord will see from the order itself, the application was heard. My lord will take the order at page 61.
Order 1 Rule 10 was heard.
No. Order 1 Rule 10 has not been opened as yet.
There are two Order 1 Rule 10 applications.
Yes. What was filed by us? One of the Shevites.
You are another Shevite.
Yes, because my mother, plaintiff number 2,
because
of my lord, much water is flown after the 3rd March order. So since apparently she switched sides, so she was removed. I'm the elder son, my lord.
You're on this side now.
I'm on this. He protect the interest of the DD. That's fine.
He's the son. Ruktima is the sister.
Sister, my lord, have been removed.
The mother is alive. The mother is alive. The son says, I am the Sheba.
Yes. No, because why?
Unbelievable.
Because the Orpon Nama lays down.
It's stretching a bit too far now.
I think you've had your say.
My lord, 200 katas property.
1 crore on the.
And who's the one who's orchestrating?
Stretch it, no difficult. We are very happy with the stretching.
Man will take page 60.
A bit too far.
61.
Page 60. Order dated 7th.
Yes. That you had placed.
No, but my lord, see 1, 2, 3, 4, 5th line. Now the record is taken up for hearing of temporary injunction petition.
Yes.
And heard the learned advocate on behalf of the plaintiff in part.
Who was held to be competent previously.
Yes. So not only was the matter fixed, hearing commenced.
How could your advocate be heard, Mr. Chaudhary, unless you were added as a party? You have made an application for additional.
They have made an application, but on behalf of the plaintiff number 2.
Yes.
To be added.
Plaintiff number 1.
Plaintiff number 1 is in any case a party.
Right.
Plaintiff
you want to represent plaintiff number 1 as a Shebite.
For that, I don't need a permission. I need a permission from the.
You have asked for a permission. Order 1 Rule 10.
Order 1 Rule 10 is for Roktima to be added. Like in the same way, Shwapna was a party. Now Roktima also wants to become a party. You as say plaintiff number 3.
Yes.
But that doesn't affect the plaintiff number one.
Very well.
I may have a
You have a locus to represent the plaintiff number one.
I have a locus to represent the plaintiff number one, which I will show, my lord.
Very well.
But here it is not that I don't have a locus. Does the plaintiff, does the deity have a locus or not?
Lord, the submission is he is the plaintiff
Mr.
number
Banerjee,
one.
please.
Sorry, he is
Yes.
the plaintiff number one.
That is never, if he's heard, if that's
We
what
can
is
understand what
understood,
submission is
if that's
being
what
made.
is understood,
Without your interpretation, Mr. Banerjee. Yes.
it's a question of the
Please
date.
complete, Mr. Chaudhary.
But well, if I keep getting,
You have to end somewhere. Yes. What are your next submissions? Please end.
So what I'm saying is, at any,
You cannot spend so much time over an application.
on the next 3 dates,
Yes.
they did not file it. There is no explanation in the petition as to what happened and why they did not file it. I take this point in my affidavit in opposition, saying that this shows that this affidavit in opposition did not exist on those 3 dates. It was brought into being later, because when they found that somebody else is now come forward to represent the deity.
It was antedated.
It was antedated. If it had been in existence, they would have filed it, or even at least made a statement that it is there. Yeah.
All
My lord, if my lord takes page 241, sorry, at page 45. Sorry, man, 241 doesn't exist. This is the earlier resolution by which Shopna was. Amarta kothay ache? Page number This is the earlier resolution by which Shopna was empowered. Now we'll see the number is right at the top right. Who Shopna was empowered?
Yes. Shopna or Roktima
or on the basis of, and this was signed by Shopna, by Roktima or Itrajit. And my lord will now take annexure K to the plate. That's the page.
So it was Shopna or Roktima or Oritro.
Yes. So it is not that I've got no authority. And after that, Shopna has been removed. And my lord, on the
We'll continue after recess, Mr. Chaudhary. It has been Yes, sure.
Lordship, may I, Lordship, have your Lordship's leave to move an appeal without certified copy, my Lord? Due to urgency, Lordship, I'm moving.
We have
this.
determination.
Lordship,
Yes, leave is granted.
May I be permitted?
May I have your lordship's kind leave to trouble your lordship, my lord? I would have mentioned it. Your lordship sat, my lord, item number 1 was called on.
Yes.
But there was an appeal, my lord, which is scheduled to be there on 8th. Now, my lord, if it is not taken up today, my lord, the entire suit and the appeal will become infructuous. My lord, it is
Your other side is there appearing.
no, my lord, this is no caveat is there. Your lordship has taken up a similar matter which is in the list today, item number 27. That is in continuation of that, my lord, your lordship will remember, my lord, it's regarding convening of a meeting. An authority.
Taking up today without notice to, if somebody is watching, we don't know that.
My lord, there is no caveat, my lord. They have not appeared on the earlier occasion as well in the last appeal. Lord, the 12th is the date of the meeting, and tomorrow your lordship.
Very well. Which is the item number?
Lord, item number 27 is in the list, which is the appeal. But the appeal, my lord, which ought to have been there in the list is not there today, my lord.
Then we cannot. If it's not in the list, how can you take up now?
Lord, if your lordship permits.
Why didn't you mention in the first hour?
Lord, I came in rushing, my lord. If your lordship gives one indulgence tomorrow, my lord, because tomorrow your lordship takes up hearing matters. Otherwise, my lord, anytime your
very well.
lordship,
Tomorrow, very well.
Anytime your lordship fixes, my lord, may I hand over to my lord?
Very well. কালকে hearing list এর টপে দিয়ে দেবেন।
Lordship, may I be permitted to?
Anytime your lordship.
আগে দিয়ে দিন, specially fix করে দিন। It will appear as specially fixed at the top of the.
হ্যাঁ, দুটো একসাথে রাখলে কোনো অসুবিধা নেই। If both be taken together, not a
Lordship, may I be
Yes.
permitted?
connection with each other. 27 টা হ্যাঁ, because 27 my lord has lost its force, my lord. It was invariably
Yes.
Lordship, may I be permitted to mention for inclusion in the list?
No, this is not the normal mentioning out.
May I seek my lord's kind indulgence, my lord, item number 51. The date is fixed on 11th of July, my lord.
Nothing doing.
For ex parte hearing, my lord. Listed matter, my lord, today.
Should have mentioned in the morning. Not now. Let us continue with the continuing matter. Yes.
Lordship, may I to permit to mention?
No further mentioning. Thank you. Yes. Mr. Chaudhary, one question. What was the occasion for directing the appellants to file? Because the appellants were the plaintiffs in the trial court.
Appellants were the plaintiffs? No. Yes, appellants were the plaintiffs in the trial court. Yes, correct. Appellants were the plaintiffs. The appellants.
So what was the occasion for directing them to file written objection?
That is the plaint. That is my lord is them to file written objection.
That was what we were wondering. I mean,
that is possible to the order 1.
to the order 1 rule 10.
And most probably, my lord, Ruktima has not filed any order 1 rule 10 application.
Of course, she has. She has.
They have probably.
My instruction, Samla, that whatever we have, it's that it's been filed by my lord.
No, the respondents were to file the written objections. So what is this application for then?
My lords.
This application is for extension of time to file written objection.
Written objection.
To the injunction.
To the injunction application.
Acha, very well. So the respondents are the applicants here.
Respondents are the defendants applicants.
Defendant respondents are the applicants. 3 separate applications praying for same relief.
The respondents in the appeal are the applicants now.
Very well. Yes, and the appellants are represented by you. Who are for the appellants? Yeah. Oh, yeah. Now you. Yes.
Appellants.
Right.
I appeared for the
Again,
appellants
I'm
at
told
that stage.
Ruktima has not filed.
No, Swapna Mukherjee is not represented at any point of time.
Swapna, yes, Swapna was the one who initially obtained the order of injunction.
But she's not there before us.
Not there.
At that point of time, of course, we were in the same boat.
You have served copies on the appellants. Must have served, otherwise how is?
Yes, everything is served.
The first time I have got something was in terms of my lord's order passed yesterday. An affidavit the affidavit filed by Can 5 was served upon me.
Yes.
We have still not been served the affidavits in opposition, copies whereof they say they filed on the 10th of June. They say they have served these affidavits in opposition on someone whom, my lords, I will show my lord the order
This is
record.
the affidavit of service.
Yes.
So, Mr. Chaudhary, how did you come to know of this? How did you get a copy of this initially?
From
3 and 4 by your order.
No.
No, no.
It was served on whom? Swapna.
Separate ones. Shopna was served or not, I do not know. They are copy.
DT was how was the DT served?
DT was served in the temple. I've got it from there.
Deity was served in the temple. We went and gave the deity
Deity was served in the temple.
Deity accepted.
That's what he says. I'm
Deity has
No, whom did you serve? You must know.
We served.
Well, you served on the
Appellate service.
To whom? To both shop.
Number one, appellate number two, they have been served by the.
Who received on behalf of the appellant number one?
But it's by
Track report won't say that.
who's received it, it's there. I just gave your lordship the affidavit, sir.
Original service copy
Receipt for is SD Chaudhary. She accepted.
And then for appellate number one, my lord, it's come back to us because obviously nobody is going to accept on behalf of the deity.
Delivered sender.
Yes. It was sent to the temple.
And kindly, my lord, make sure, may I pray for this before your lord?
You have made an application under order 1 rule 10 there in the chat.
The use. The
It's not made.
application under 1 rule 10 and Somesh has also made an application.
Somesh.
Somesh is the son of Swapna.
Then who is Auditro? Auditro.
Let them show Rokma's application once.
Or this is a member of the governing body. That this is.
Do you have a copy of your order 1 rule 10 application?
It is annexed. Somesh's one is annexed here.
Somesh is annexed.
Yours, Roktima's.
My lord will get it. I'll have to get it from the office.
You have personally seen it, Mr. Chaudhary?
I have not, but I'm instructed that it has been filed, and that's what my instructions has been all. I can show my lord a soft copy. A firm soft copy. Well.
Yes, please continue.
My
Yes.
lord, I have shown my lord the authorization which was given to Swapna. My lord will now take page 53 of my opposition.
The 45 years showing us, Mr. Chaudhary, that authorizes Swapna, Ruktima, or Auditro. The name is not clear, smudged. Auditro. So, and he's Mr. Chatterjee is appearing for someone else.
Mr. Chatterjee,
How do you have locus standi?
I'll explain how he has standing. Swapna was removed. Swapna was removed.
I step into Swapna's shoes.
Where is the removal
Yes, that's
resolution?
my lord. My lord will come to
53.
53.
All right.
Swapna was removed in terms of the Orpon Nama. He steps in
I step into the shoes of
with his brother.
by virtue of the Orpon Nama.
With his brother. It goes there down that line.
Linear descendants, my lord. As per the Orpon Nama, my lord, have to be.
Well, let Mr. Chatterjee show that.
Orpon is there, annexed here.
Orpon Nama would be in my lord's records. I don't have a copy here because that is part of.
But it's my before the trial court, my lord. My application before the trial court, my lord.
Your application before the trial court is here. Let me have one. But I think no, but I all annexures are not there. My lord would have it in my lord's file because it was part of the.
The best would be.
I don't think there's any dispute.
I have a review application pending before your lordship with respect to the main injunction passed. My lord hears that as well, my lord. It will be much.
And who has he served a copy of that on?
Much easier. It's a review application. First, it needs to be admitted, sir.
Page 7 of the Orpon Nama, my lord.
Lord, if your lordship remembers, I had made this submission before your lordships that the main person is a lessee who is sitting there. He is getting hold of
Maybe we do.
getting hold of one person from somewhere and filing an application through them. Then that person will not goes out.
Actually, that person is Mr. Garg.
Mr. Chaudhary appeared for Swapna at one point of time.
I did.
Then he obtained an order of injunction, and now she's out of the picture.
Yes,
now somebody else has come in.
I was appearing for the date.
Oh. Vedic concept. Appearing for the date.
My lord, before this.
No, Orpon we have. What is
this? Goes to sleep. My lord wants to see it. The
what is
addition
this?
of party. Order 1 Rule 10 on
Your
behalf
application.
Yes.
So it's a composite petition by Roktima, Oritrojit and Otish. So Oritro, yes. You just show it to them also because they're disputing. So why is Oritro appearing separately? It's a composite application.
I'm Shomesh.
Oh,
I'm
achha.
elder son, my lord, of plaintiff number
You also have one order 1 Rule 10.
Yes, my lord.
Let us see the Orpun now once. Give us half a minute, Mrs. Chaudhary. Yes. My sense is to perform all the things after my death. It main application ta appellate page 60 te ache. Main appeal ta jeta main page. Je appeal theke asche dispose of appeal. 60. So first the settler and Rajlakshmi Devi,
Then the son of the settler.
and then we'll
Panchanon, and then
after my death my son Panchanon will be Shebait.
Panchanon left 3 daughters. We are all
Panchanon, then eldest descendants, son, grandson, etc. will be the Shebait. So you are how are you related to Panchanon?
I am
Son, grandson, what happened to them?
Panchanon left 3 daughters.
Oh, no son.
Panchanon left no son.
So therefore, who is the eldest? Swapna must be.
The eldest was, I think, Ashalata, then Konoklata, and Diptilata. Ashalata originally.
And Swapna, Ruktima, they are the daughters of whom?
Swapna and Ruktima are the daughters of Ashalata, who originally, because she was married, did not get anything. But when Diptilata died, without being married, her share went to the heirs of Ashalata, as held by Justice Banerjee sitting in division bench, and also by
The daughters also had no son. Grandsons, although he remains minor.
My lord, the genealogical table is there. My lord will give me a minute.
Maintenance of Devotar property and adult Shebait being required anyone among grandsons, daughter's son. Panchanon had any daughter's son? What is that?
This is the genealogical table, my lord.
It's very difficult to follow from the tab all the time.
This will not be difficult.
No, definitely. You just tell us whether there was any son.
Ashalata, Konoklata, and Diptilata. Now, as far as
they had any son?
Diptilataর কোনো issue ছিল না।
Diptilata had no issue. Konoklata had 2 sons, had Sogato, Oritrojit, Indrajit, and Shatrajit. 4 sons.
3 sons, 1 daughter.
And
very complicated.
And Ashalata's heirs came in upon Diptilata's death.
It's the eldest one all through.
My lord, but this was modified to some extent by my lord, by the Privy Council judgment, which said it will go on intestacy to the shares of to the heirs of Panchan. Privy Council judgment is also on it.
Now that everything is open, then we can argue also.
Anyway. Well, so both of you have order 1 Rule 10 applications to add, implead yourselves as parties.
Yes.
You and Shomesh.
Yes. But till
so you together with Oritra another.
Yes. But that till then they can't be allowed to get a walkover. I mean, now the estate has to be, and my lord, I'll show just one judgment. This being an idol, it is the responsibility of the court to step in, and the court, whether we say anything or not, it is the court's responsibility to protect the estate. My lord, just
Swapna is has not signed anything after giving the Vakalatnama to on behalf of the idol. Swapna has not signed anything or filed any application.
She has not signed anything. She may have signed something.
No, not here. Before the trial court.
No, nothing. She says she has signed a wakalatnama in favor
Must
of
have signed, otherwise how could she?
She says she has signed a wakalatnama in favor of an advocate. The records will say that the advocate tried to file his wakalatnama without no objection from a previous advocate. That's recorded in the order. I will place that.
No, at the inception of the suit.
In the suit, everything till my lord's order, everything was hunky dory. It is only after my lord's order was passed that all this happened, because they knew that if they could get Swapna to not proceed with the suit and to have the suit dismissed or compromised or settled, I mean, they are home scot free. Everything will go with an interim order.
Challenge was to
All right.
The challenge was to the sale deed. Whether I say, you say is not the issue. It is the court's responsibility to protect the estate of the deity. I am bringing these facts on record. I am showing the conduct of the party.
There's no one to contest, my lord. That's the difficulty.
Get it? Yes. So page 53 you are placing, Mr. Chaudhary?
I placed 53 to show the revocation.
This was by whom? This was the...
This was by the Board of Shivites.
You yourself, you three revoke Swapna's
Yes,
Shivites and become...
We'll see why I revoked it. And my lord will see.
You arrogate to yourselves
Shivites. This Munisha is admittedly the power of attorney holder of Swapna at present. Munisha is the daughter and the power of attorney holder. Swapna is within the control of Munisha. I have annexed the transcript of a telephone conversation. It's an affidavit.
But Swapna is not even involved. Roktima and Otrojit at page 49. You allege page 49. That the removal of Swapna happens when?
The removals are on the
First
20th
time?
of March.
What is the page number?
Page
40. No, before that. Before that?
When it starts.
Before that, page 47.
Page 46. Will come to 46.
46, yes. No, they were absent. 46, they were absent.
Yes.
Roktima,
Admittedly, there was Swapna.
who admits? Swapna is not there.
So Swapna did not come for the meeting because she had been caught out.
Caught out doing what?
Taking money.
From them?
Yes, it's on record. I'll come to page 47.
Then why did she file the suit in the first place?
At that point of time,
She had not taken the money.
he had not taken the money. And the requirement for managing Swapna was, if you manage Swapna, the suit has been filed only by Swapna, was the only Shivite on record. If they could manage Swapna, Swapna didn't even communicate my lord's order. If Swapna say withdrew the suit, what happens? My lord's order goes? Everything goes. My lord will see page 47. Continuation of that.
Yes, you are there. 47.
My lord, see the middle. However, Swapna, who was earlier part of the joint endeavor to recover the said property from Tirupati, has been approached by Govind Garg. Govind Garg is the owner of Tirupati. Swapna and her daughter Monisha have been in constant touch with Govind Garg during the time that the matter concerning the illegal sale of 97 quotas has been pending in court. However, it is only after the order dated 3rd March that it became apparent to Tirupati that they were most likely to lose and the deed will be cancelled. Hence, they had the motive to offer a large sum of money to Swapna to switch sides and throw away the litigation. And this, the transcript is there of the telephonic conversation on record, on affidavit. And my lord will see the next paragraph. They were informed. Swapna, who despite having been put on notices, failed to respond to any of the allegations leveled against her. But the facts are glaring. Swapna has removed the advocate, namely Shaolini Basu, who was contesting very well on behalf of the deity. The order dated 3rd March bears the name of the advocate. As such, advocate was performing.
Yes, allegations, and she is removed and you come. Yes. Get your
question. My lord, may I
So you say Swapna is no longer, representing the interest of the deity.
not.
So therefore, you are there. You have to come in to protect the interest of the deity. All right.
I have to come in to protect the interest of deity, and my lord will see what they have said there in their transcript.
They have filed reply to this affidavit in opposition.
Yes. Reply করেছে স্যার করেছে আপনাকে
Your affidavit in opposition, they have filed reply here.
Reply is very interesting. My lord will see the reply.
What is their stand regarding this? That at least page 45 that you have annexed those documents, not the removal. Let us come to that.
My lord will see it.
Reply here.
They don't even deal with it. They say you've got no locus to make this allegation, so we will not deal with it. Because they could not. Because they couldn't. The transcript will show Monisha, the constituted attorney, is saying, please pay, please come over. We are going to get some money. Till now, we've been staying in rented property. At least I'll get 20 lakhs. If we talk together, I'll get 40 lakhs. Govind Garg is calling us. Why don't you come? Malad will come to page 28. Malad will come. I've set it out. It is part of the affidavit before the trial court. I've set it out. It's part of the order 1 rule 10. That's why I've asked for it. Malad, please take page 20.
20 of what?
20 of my affidavit in opposition. This is part of Shomesh's. This conversation happened with Shomesh by Swapna through a constituted attorney.
What is this? Page 28?
This is part of the
Transcript.
application for order 1 rule 10 filed by Shomesh, where he set out the entire conversation with Swapna through a constituted, where we are being offered money, being told that this is how much we are getting. At least we are going to get something. Otherwise, Garg has my Pishima entered into a deal with Garg. This is
Garg is the director of Tirupati Assets or what?
Garg is the director of Tirupati. He is the owner of Tirupati. This has not been dealt with. He does not say that the conversation does not take place. He does not say that Garg never said these things. Neither Garg's counsel is here. Nothing in the reply. My lord will see the reply. I'll place the reply. But kindly give him. Soft copy.
You have seen the reply actually. I mean,
My lord, see.
Specific paragraph deal for it.
they have just denied that Roktima has any right to.
Exactly. And he says that I will not deal with the rest.
But what do they say that? Because you don't have any locus. An unauthorized affidavit does not legally deserve to be retained as part. Yes.
Well,
So para 10, yes.
If allegations of this nature were being made against you, that you have offered money, the first thing you are going to do is say, no, at least I have not done so. He doesn't say so.
Very well.
And also I say that this advice, so-called advice, could not have been given to you about keeping the affidavit affirmed and at home. If it had, any normal prudent person would have taken steps on this date, this date, this date. Nothing. They don't even try to explain why they didn't do it. My lord, see the conduct
One
of the
thing,
party.
Mr. Chaudhary, you are yes, you are opposing the opposition. Right. Very well. Right.
I am not canvassing for my interest. I'm canvassing for the interest of the deity.
Good.
And it is whether Roktima brought these facts to your court, to your knowledge, anybody else did, Shomesh did. Shomesh, at present, you can say his order 1 rule 10 has not been allowed, so I will not hear you.
Your order 1 rule 10 is also not.
Been allowed. But therefore,
No, but that in the order 1 rule 10 applications, you sought to be implemented in your own capacity.
exactly in my own capacity.
Not as Shebaita.
No,
So
no,
it's to be decided by the trial court.
I'm a Shebai.
Yes, regarding
that's my
the appellant number 1, the defendant number 1, the plaintiff number 1, you say that you are already empowered
Not by who? By the board of Shebais.
by yourselves.
Maybe not myself alone. All
Yourselves.
Shebais.
You three of you have filed order 1 rule 10, and he has also joined. So all of you comprise of the board.
If
Probably he was not there.
he's not there,
But the 3 applicants in the order 1 rule 10 themselves from the board and remove Swapna.
protecting the interest of the deity, do I benefit by this? I don't. It is only the deity who benefits.
True. Very well.
And my lord will also take note of the fact that Swapna, after the order, till today, has not opened the application.
And also, despite the service of notice on the deity and Swapna, Swapna has not come up because Swapna was representing the deity. That is also in your favor, apparently.
They say
Subject to.
They say even the affidavit is in operation before the trial court have been served on somebody. My lord will see the order records that person who's filed the Wakalatnama has not gotten no objection from somebody, from that erstwhile advocate and record who was there. I mean, I just set up somebody to say I've served you because that person has to accept on the back date. The whole object was that I have to get a receipt on my affidavit in opposition on a back date.
Where is the service? I mean, they have. No, the service of the.
Affidavit in
Have you
opposition.
annexed? Yes. The service of the written objection in the trial court.
Yes.
Is there anything to show?
Objection is service.
No, in the. Have you annexed anything to your reply or your application?
No, nothing is
Probably there is nothing.
It is there's not there because
It's
it
affirmed.
was.
It was
I was
it was-
there before the trial court.
It was affirmed and served. It was affirmed and
That's
served.
the question on whom. The name of the person.
Oh, my lord, in the trial court fashion, it's endorsed on the original.
By whom? That's the question.
In the application.
It's the advocate for Sapna.
Yeah,
The advocate for the
Malu, ask the
plaintiffs.
name. Ask the name. Who's that? Who's the subject?
No, am I under cross-examination? Then I'll come better prepared.
I've asked my lord.
Then I've come better prepared.
You
No, no,
should.
what,
Well, Mr. Chaudhary, please complete. Then we will
Continue.
complete the arguments. Yes.
but he's yet to get added to the party. He has already made, my lord,
I am
allegations
on
regarding
call.
bribes.
So your reply is over.
No, my lord, I will not make a reply. After
Well-
this, my lord, it's a humongous, my lord, submission. I can't fathom it, my lord, enough to make a reply.
Well,
I
You
will-
can't fathom your humongous adjectives. We'll deal with that later sometime else. Yes.
My whole endeavor was to
Yes, to save the interest of the deity.
paragraph of one judgment.
Please. Yes.
Well, for 10 to 50 feet. Side. No, I don't want to calculate. But no, sorry, okay. Much better. But okay. Paragraph. My lord will kindly come to paragraph 27 onwards. The deity in the temple is a minor, and the court should be astute to protect the interest of an idol in any litigation. Therefore, when the trustee or the executive officer or the custodian of
What is the citation, Mr. Just Chaudhary, give the citation for
Very
that.
Well, this is reported in 2021 Supreme Court cases online, Madras 12402.
Yes.
The court should be astute to protect the interests of the idol in any litigation. Therefore, when the trustees or the executive officer or the custodian of the idol, temple, or its properties leave the same in the lurch, any person interested in respect of such temple or worshipping the deity can certainly be clothed with an ad hoc power of representation to protect its interest. Where the person in management of a temple failed to protect the interests of the temple diligently, the court is empowered to take notice of such facts and deal with the issues in an appropriate manner. The court is bound to take notice of the fact that the executive officers appointed at the temples are being changed periodically, and in many a case they do not get fully acquainted with the history and affairs of the temple. If there is any slackness or negligence on the part of the executive officer or the trustees of the temple, it is the duty of the court to ensure that the deity does not suffer thereby. The court should be astute to protect the interest of an idol in any litigation. Paragraph 29. The properties of deities, trusts, and devasum boards required to be protected and safeguarded by their trustees, acharak, shavites, employees. Instances are many where the persons entrusted with the duty of managing and safeguarding the properties of the temples, deities, and devasum boards have usurped and misappropriated such properties by setting up false claims of ownership and tenancy or adverse possession. My lord, one thing to point out here, I have seen in the record, my advocate record has, the defense taken there. Now, in the affidavits of opposition say, this is not the property of the deity at all. It is my secular property.
It's been my
Maybe.
submission from day one.
Very well. So, I mean, after a submission like that, that is my secular property. Not only by them, even the person who's purchased it on the basis of the Indian Trust Act application, and where the deed says that is being sold by the idol.
But the application injunction suit and the injunction application was filed on behalf of the deity
Yes,
by the deity.
They are saying now it's secular property.
They will be saying that's their defense. No, the question is whether Swapna and the deity, they filed the suit and they filed the injunction to protect the property in the first place. So that remains.
That is what I'm espousing now. And I'm saying the defendants who now say, who are now opposing us, they are continuing to say that it is my secular property, it's not deity's property at all. Can a person like that?
Can a person like that what?
I mean,
They are not
saying,
representing the
that's
state.
what they are saying we have a other than Garg.
How can the defendants represent the state?
Garg, the rest are claiming to be Shabites. Other than Garg, the rest are claiming to be Shabites. Other than the defendant number 4 in this suit, the rest are claiming to be Shabites.
Yes.
Well, we'll see. Instances are many where such persons entrusted with the duty to manage and safeguarding the property of the temples, deities, and devaswambals usurped and misappropriate such properties by setting up false claims of ownership or tenancy or adverse possession. This is possible only with the passive or active collusion of the concerned authorities. Such acts of fences eating the crops should be dealt with sternly. The government members and board of trustees, the devotees should be vigilant to prevent any usurpation. It is also the duty of the court to protect and safeguard the properties of religious and charitable institutions from such wrongful claim and misappropriation. Then there is one more paragraph where it says not only that it's a constitutional duty, it goes so far.
That was a public trust, a public endowment. It was a temple. This is a private trust. Anyway.
It's a devoto. It's God's property, neither mine nor theirs.
Right.
Thank God. So they of course claiming it to be theirs. My lord, in these facts, my lord, and one more thing is my lord will kindly direct, if my lord, I shouldn't be making that submission, but, but
if you take a lenient view on the written objection,
which, contrary to my argument,
yes,
my lord will, till now, we have not been served with affidavits in opposition.
With the written objection in the trial court.
Yes. We are in the dark.
Is not a
all right.
And my lord, because of all these shenanigans,
we can do this subject to hearing them, Mr. Chaudhary. We can direct this to be.
Said they don't need hearing anymore.
We can direct the learned trial judge to take up this issue as a preliminary issue before moving on with the matter, or along with the injunction application. Whether you have a right to who has the right to represent, whether Swapna, you or
my lord will kindly not do that. My lord,
otherwise you don't get look at standard. Swapna has
my lord has said that the
order 1 Rule 10 applications will be heard. That is in your personal capacity, but the court has to decide first who has the right to represent the deity. Unless you have a right to represent the deity.
I have asked.
With the suit, you are not a plaintiff in the suit.
I've asked to be submitted. I've asked to be added as a co-plaintiff.
That is what we are saying.
Yes, so
there cannot be two plaintiffs in the same suit.
No, I am not. I am.
So if you want to be added as a co-plaintiff with the deity, it has to be with the deity, not with Swapna.
No, I'm.
Swapna and you have conflicting interests, Mr. Chaudhary.
Swapna and me have conflicting interests
vis-a-vis the deity. So you and Swapna cannot be co-plaintiffs because that will be a conflict of interest, and there will be two plaintiffs then, which is a settled proposition of law.
The plaintiff is there.
Therefore, the court has to decide before proceeding further who has the right to represent the deity. Court may say Swapna as well as you, or you alone, or you with him.
My lord, till now, Swapna has never said anywhere that
the suit has been filed by Swapna and the deity.
My lord.
So you cannot usurp the role of Swapna without her being heard.
I'm not usurping anybody's authority. I've shown Swapna's conduct. But Swapna has till now not said anywhere that she is resigning.
Court will decide who has the right to represent the deity, to represent the interests of the deity.
Swapna is not saying that.
Without deciding that, you don't have a right to get any copy of the written objection even.
Swapna till today has not said that she is resigning from the statements made by her, either in the plaint or on the application injunction. I am supporting the same. There is
no, Mr. Chaudhary. You and Swapna have diametrically opposing interests vis-a-vis the deity. Either Swapna has to be, if you are permitted to represent the deity, Swapna has to go as a defendant, transpose as a defendant. Either that, or because there cannot be one plaint by you and Swapna. Even if you are added, you cannot be a co-plaintiff with Swapna. You can be a co-plaintiff with the deity.
Yes.
So while deciding that order 1 Rule 10 application of yours and his, court has to decide whether you have the right to locus standi to represent the deity as well. Otherwise, you cannot be added as a co-plaintiff with Swapna. That is the difficulty. There cannot be two plaints.
Well, till now, Swapna is not resigned from a plaint.
That is precisely what we are saying.
Shopna is not result from a plaintiff.
If you have to be added, Mr. Chaudhuri, you cannot be added as a plaintiff now. Unless you are added as a plaintiff, you cannot espouse the cause of the duty.
My
So
lord,
therefore, if you have to
my
be
lord,
implemented,
my
Mr. Chaudhuri, you are speaking without letting us complete. That is the difficulty you are facing. So that your answers are incomplete. Our point is that if you are added today, you are to represent the interest of the deity. That is to be found by the court that you represent the interest of the deity. Otherwise, you and Shopna cannot sail on the same boat with a single plaint. What is your answer to that?
I'm saying as of today, on record, my stand and the stand of Shopna is the same as far as the record is concerned.
All right.
Shopna has said something in the plaint. Shopna is still continuing to say something in the plaint. Shopna has not filed any affidavit saying I am resigning from that.
Very good.
Her case and my case is the same. All I'm saying is that Shopna is not pursuing her claim in the manner she should.
Then the premise of your addition would be that Shopna is not any longer pursuing the interests of the deity. That would be the premise of adding you.
That's what I've said.
The moment that premise is accepted by the court and you are added consequentially, your and Shopna's interests go conflicting to each other.
Very well.
Do you get up? Because as of today, you are right. You are selling.
I mean, if
the moment you are added, that can only be on the premise that Shopna is not representing the interests of the deity any longer. But you intend to. So therefore, the conflict starts there. And Shopna and you, then suppose Shopna comes today, the right hand goes one way, the left hand goes another. Shopna comes and says, I don't want to file an application. And you say, I want to file an application. Both of you are plaintiffs, one plaint. How can that be dealt with? So therefore, that issue has to be decided as a preliminary issue.
If the
While taking up your order 1 rule 10 along with the injunction, along with that preliminary issue.
Very well.
Whether we allow their prayer or not, either way we'll do that.
Will have to be disposed of.
Either way we'll do that. Yes.
And my lord will kindly fix that time limit. I will kindly fix that short time limit. I would say 3 weeks. There's nothing. If whether either they have used the affidavit or they have not used the affidavit.
Yes.
If they have used the affidavit, I will take 2 days to file a reply.
Both advocates and high court judges should have a stint as district judges for say 3 weeks. And see what is the immense pressure on them and on torn chairs and non-AC rooms.
My lord did not fix the time limit, but my lord
we will fix it. We will fix the time.
The judge has also appreciated the urgency of the matter. He has been fixing this.
I don't, my lord, I don't claim to represent the deity, but my lord, I claim, my lord, to protect the interests of the deity. My lord, so that's where I come in, my lord, because I've not been authorized to represent the deity per se, but to protect the interests of the deity. My lord, for that purpose, for the injunction at least, my lord, if I may be heard, my lord, to that extent. After that, my lord, my order 1 rule 10 may be heard, or whatever, my lord, orders can be passed.
Or my lord can direct simultaneously
as a trial court. My lord, I pray, my lord, that I be heard at least, my lord, to make submissions to that aspect, my lord. Because I don't claim, my lord, to represent the deity, but I'll have to protect the interests of the deity, my lord.
All right.
The trial court has fixed both together, my lord will continue that.
It's what the order 1 rule 10 and
Yes. He's saying
there are 2 order 1 rule 10s. Yours and theirs.
And my lord, here, my lord, my lord, at least for the property to be protected.
Written objections have been filed to that order 1 rule 10.
My lord, yes, on the last day they filed.
Yes, they are filed.
And we filed a reply also. My lord, at least, my lord, in a time-bound manner, my lord,
Yes, we understand.
Can be protected. That's the
Mr. Chatterjee, you have justified your position.
Because till now on,
Mr. Chaudhary, unless you take your seat, we are feeling threatened.
Till now on record, there's no goalkeeper. My lord needs a goalkeeper there.
Let's see. Yes, we feel like the goal. We understand what the net of the goal feels like. When so yes, Mr. Banerjee, without the fills, plain English, everybody can understand. Including your clients and all. Yes.
Only one thing. Lord,
yes. Actually, the Madras High Court judge, learned judge, I mean, you have met your match probably. You should go through this judgment sometime later. Yes.
He didn't cite it, my lord.
He did.
He just played.
You missed out because you're having an excited talk with your friend. Yes, Mr. Banerjee, what is your reply? Short.
Very short. My lord, what is the scope of this present application before your lordship? We have affirmed affidavits in connection with the injunction application. The affirmed affidavits are already filed in court. They have not been taken on record.
Points have come up before us. One is that whether we should permit you your pair on merits.
On merit.
Second is whether
That
they have
my-
locus standi to object to that.
That my
Both will deal with right now.
to that my humble submission is that as on that date, when the order was passed by your lordships, the plaintiffs' appellants were one and the same, both the plaintiffs together. Today, both the plaintiffs together are one and the same in the trial court. There is nothing to show that there has been a splitting up of the plaintiffs. The deity has come separate from the human agency. If at all it is possible, there's nothing to show. Two pretenders, groups of pretenders, I use the harsh word, let us say two persons claiming to be interested in the deity have filed applications under Order 1 Rule 10. Their applications are pending. It is because of the filing of their applications that hearing of the temporary injunction application got jettisoned, because both of them wanted to step into the cause title first and then make submissions qua the temporary injunction application. If my learned senior friend has been appearing on behalf of his client in the court below, I have also had the occasion, my lord, on 2 occasions to assist the court below. This is the situation. After my lord's order, after the affidavits were complete, hearing of the injunction application was taken up on a particular day. Then Order 1 Rule 10 applications, my lord, were pressed to the hilt by my learned senior friend, and in his inimitable way, he stopped hearing of everything else and he pressed his Order 1 Rule 10 application. My lord will find, my lord, reflection of this in this series of orders. Please see, the first order says, please come to, my lord, page 59 of the affidavit in opposition. The plaintiffs.
Mr. Banerjee, the last order passed by the court is that the injunction application will be heard along with the Order 1 Rule 10 application.
But before that, my lord will see there's one order in which he says that the injunction application the hearing has started. Please come to, my lord, page 60.
No, we understand. He barged in with the put-up petition and
Barged in with a put-up petition.
That is your
the injunction application was being heard. He came in and he said.
But the position as of now is, which you have not challenged that last order also.
Yes, no, we haven't.
That
the injunction application is yet to be heard.
To be heard along with the Order 1 Rule 10.
Yes, our affidavits are on record. That was the last 110 সঙ্গেই বলেছিল তো.
That appears from your application as well as their
yes.
order
That's
sheet.
not under contest at all. Please see, my lord. Yes, page 62, my lord. The last order which he has passed, 10th of June, was injunction petition in conjunction with Order 1 Rule 10 with written objections in the meantime. That is the order dated
10th of June.
22nd of May 2025. এবার 10th of June order টা আছে তোর কাছে?
10th of June has been annexed to Can 3.
That's part of the petition.
That's part of your petition.
Yes.
Can 3.
Yes. Now, my lord, therefore, lordship sees these 2 petitions are now pending. Now, my lord, we cannot possibly stand in the way of the petitions being heard. Who are we to stand in the way? We are trying to oppose the injunction application or react to it. We have already affirmed affidavits. We have put the affidavits on record. Learned trial court rightly says that the honorable court directed you to file them. I don't find them filed on record. Therefore, unless you get that clarification from the honorable court, we will not be in a position. I will not be in a position.
Those have physically been filed in the record.
They have been physically been filed in the record,
but not accepted because because it was beyond the timeline.
Yes. Now, this is the prayer with which so my lord, I suggested, my lord, before the honorable court and various other counsel, then my lord did not join issue, that I should go before the honorable high court and take not a formal prayer for an order for extension of the time so that these affidavits are regularized. As soon as that is done, the reply is also on record because we have already filed it. We have not served a copy on the other side.
But this is conspicuous, Mr. Banerjee, that Swapna Mukherjee or the deity represented by Swapna Mukherjee is not coming up to oppose your prayer. It's only Roktima and the other person, Somesh, who are coming up, despite service of notice. That is also noticeable.
My lord, if Swapna doesn't oppose my prayer for extension of time to file, to put my affidavit, which is regularized, Swapna is doing yeoman service to the deity. There's an injunction application. No, please. He's amused, my lord. He's been amusing me since yesterday. I have not laughed. I've laughed inside. As far as Swapna is concerned, why would Swapna stand in the way of the injunction application being heard out and disposed of expeditiously? In an appeal filed by Swapna with the P1, where Swapna as P2 and P1 have both.
Mr. Banerjee, won't the interest of the DT be subserved if your written objection is not taken on record? Then the injunction application remains uncontroverted. Wouldn't that help the DT?
Lord,
why isn't Swapna coming up and opposing your application, or at least coming and saying something regarding that?
Lord, I'll put Swapna on notice. Let Swapna come and your lordship will
You
see
have
whether
put her on notice. You have tried to serve on them.
No, we've served.
They have served.
No, the reply we've served him. I don't know whether but my lord, there's only one confusion. Please be satisfied when I submit. I don't know who appears today for plaintiff number 1 or the plaintiff number 2. For that,
Nobody knows.
Please, my lord, kindly see.
Nobody, including the deity.
Deity, my lord, is the worst casualty here. Deity, my lord, is.
But you don't have to espouse the cause of the deity. Deity has acted against you by filing the suit. So you operate against the deity for that.
The deity hasn't said anything because the deity has been ill represented according to us, but then that's a different story altogether. Please have a look at whom, my lord, we've served. Mr. Ratan Chakraborty has accepted, my lord, a copy of.
Mr. Ratan Chakraborty, how do we know? Are you supposed to know Mr. Ratan Chakraborty? Do you know Mr. Ratan Chakraborty?
I do not know, but in answer to Mr. Ratan Chakraborty's service, my learned senior friend appears here.
Maybe.
My lord, who is he? I'm asking himself. He can't be a phantasm.
You served, do you know?
My lord, I have served him.
You have served Ratan Chakraborty. You are saying, I don't know who I have served.
Now, my lord, I have served. I am saying, my lord, who is he representing today? He is representing, my lord, 3 persons who want to step into the array of parties in the suit. He is welcome. His file is order 1.
Importantly, they want to oppose your written objection being filed, which will inure to the benefit of the deity.
Yes, this is between.
That is also important, Mr.
This is between the applicant and the court. If the court feels that the applicant has committed a sin which is not condonable, then
they have a right has accrued in their favor by your overstepping that time limit.
Yes.
So they have a right to represent their case also.
Yeah, they have done that.
Not that it is between the court and the applicant only. Their
right
interest
to
will be
represent
served.
Right to represent their case, qua the ills that they would face if we have not filed it within time. That's all. And the frivolity or otherwise of the cause shown for us for extension of time. Who would have done that, my lord? Any person who's on record could have come and done that. He says that he is a ghost representative of the deity. We take it at that. But then here in this proceeding, in this scan, what further can the court do apart from either allow my prayer or reject my prayer? His 110 applications are, my lord, on board there. He himself stopped the hearing of the injunction application.
While allowing your application or rejecting your application, Mr. Banerjee, we have a discussion of whom we would hear. The discussion is dependent on whether they have locus standi or not.
Yes.
Because the appellants per se, they have a right of objecting to your prayer.
Yes.
It's not exactly between you and the court.
No.
A right has accrued in favor of the plaintiff's appellants.
Just like a Section 5 petition.
Whatever application, a right has accrued in their favor. Now, therefore, they have the plaintiffs have a right to oppose this prayer. Now, the plaintiff represented, the deity represented by Swapna is not coming up. That's very evident. Therefore, we are to consider first whether they have locus standi to object at all. If we say they have locus standi, we have to consider their objection and deal with that in our order.
Yes.
If we say they don't have locus standi, then we don't hear them independently. Upon hearing you, it's our discussion, we can do that. So for that, we first have to look into the locus standi.
Yes.
And for that purpose, we had to hear Mr. Chaudhary,
yes.
whether he has locus standi
yes.
to object. So for that purpose, it's not exactly that it's a discussion, either this court allows or even if it allows or rejects, we have to consider whether we hear their objection to your application.
Yes, yes.
For that purpose, we are.
I understood. That is why, my lord, he's been continuing for 2 days.
Even if we allow or reject, either way, whether we hear them on that or not, if we don't hear them, then we don't take their submissions into consideration at all.
Prayer exactly is that, my lord, in whatever, my lord, affidavit I have filed, my lord, in response, I have said that please don't take their objection into consideration today, because within the limited frame of this application in a disposed of appeal, keeping everything open, including the veracity of the allegations and counter allegations made between the parties. I'm not telling your lordship, my lord, to accept anything. Only, my lord, kindly, my lord, pardon my mistake in not having put that on file, my lord, within the date my lord had directed it to be put.
So suit was for eviction. Suit is for what?
No, suit for cancellation of a deed which has been already made about 8 to 10 years ago. My lord found a sufficient ad interim case for the purpose of an injunction, gave an injunction, directed affidavits to be filed.
Mr. Banerjee, the deed was executed by whom?
Me. Claiming herself to be the sole Shebite.
You means?
One of the Shebite. One of the Shebite.
You are one of the defendants in the suit?
Yes. I am defendant number 2.
So that contest is going on. My lord has in my lord.
This written objection is by Tirupati only.
Objection is not Tirupati only. Me also. I am.
All of you are filing separate written objections.
Yes.
You also claim to be a Shevite.
Yes, yes. Shubhadeep.
You also claim to be a
Yes, yes,
Shevite.
yes. There's a deed of appointment in my name, but there are so there's material for the trial court to go into. What I am humbly submitting is today, my learned senior friend with his anxiety. What will be his anxiety? That someone is going to take the suit of file.
He will deal with his own anxiety. We'll deal with
Yes, yes.
legal points.
As and by way of an anxiolytic, may I suggest that his order 1 rule 10 application being on board and that being fixed along with the injunction application, his anxiety right now is premature. The court is in season of his and his co-applicants' prayers for getting added. Whether he will be added as a plaintiff or not is something for him to be satisfied. Court may want to add him as a defendant. He may apply for transposition. So many things may happen. Now, Lord, for those things, perhaps at this stage, his nebulous presence here in this appeal may not.
Why do you say it's nebulous?
He's nebulous because he's not
being like Mr. Kollal Bush now. Why nebulous?
Nebulous because he's not on record. He's a phantasma. He has never grounded himself.
What is a phantasma?
A phantasma is something, Lord, which can only be imagined, can't be touched, something which is intangible. It's an intangible thing. And he says he's the deity. He says he's the deity.
He's the mother of fantasy. Phantasma as in
Phantasma is phantasma. But, my lord, the entire question is, my lord, whether in this, please kindly considers this, we have a limited prayer. They means the persons aggrieved by this overshooting of timelines have a vested right to object. I bow down to that. But these gentlemen, with great respect, are still not those persons.
one lady and a gentleman. He's representing a lady.
No, I'm talking about the clients.
This is the thing. I'm not only representing, I'm representing the deity. I've said so.
My lord, please forgive me, my lord. I've never been able to understand. Why something has happened. There's a merger of, my lord, a person in a deity.
No. One. হারাধন্দা বলছেন বসে পড়ো
The application for extension has been filed. Not accepting. Why? Because it is a procedural lapse, remedial procedural lapse. That can always be not extended under Section 148. Lordship knows that.
Yes, can no, not even them. But whether we will extend.
Extended or not. Extended or not. Number of my submission that he has already submitted objection. But the court, did not want to accept that objection because in view of the direction of the court. That direction is procedural direction. Now, Lord, whether it will be acceptable or it will not be acceptable, at least, Lord, the person who is not made a party,
right,
the original appeal, Lord, he has no local standing to make this. Only after the addition of party, then he can ask.
But who is he?
Malabli,
kindly find out who.
Sahadan Manaj. Want to slow further.
I am a party to the original appeal. And this application, I am also a party.
And nobody leaves the court
No, I
during this matter. Yes.
extension can be made.
Nobody leaves the court. Whoever is appearing, whoever is earning fees cannot leave the court for any other matter.
No, I want to say something.
Oh, you are, no.
Another thing,
Nothing.
Again, after he has finished.
Lord, why he is interested? Lord, he has executed and registered a deed. Lord, he has
After much hardship, we were trying to remember the names. Now we'll forget.
No.
property.
আমি দেখি
Extended
স্যার এই যে
20 bighas 11.
এই যে
This is the deed.
That is the crux of the dispute.
That is the crux.
20 bighas is the problem.
Lord, Baliganj area, Baliganj area.
No, crux of the
Yes, no, the extent of the property.
this one.
Ruby Ganguly to
So are we supposed to decide this suit also, Mr. Banerjee?
exactly the way
So this is malice. This is allegation of malice versus allegation of malice.
The interim order, that is why we not
You are opposing the extension or supporting the extension? You are supporting the extension. It should be extended.
I'm simply saying, Lord, the whole malafide is that interim order can continue. One after another application.
By delaying the process of
Order one.
But that has been argued with.
this one.
Both whether maintainable administration, because they are the same one. One is DTs are being represented by Lord the
Hobna.
plaintiff, Hobna. Now, Lord, if he wants to be represented, Lord, then there will be a conflict of interest. But Lord, therefore, in any case, Lord, your lordship goes if we become to judgment. If any person, Lord, if any person files a suit in his own capacity, not against the DT. If DT did not file any suit, then judgment will not be binding on DT. But if person and a person for the purpose of DT's property is protected, then he can file a suit.
Yes.
That is the distinction between the
Absolutely.
Now, Lord, these are the questions to be decided
by the
সেটাই
তো বললাম
whatever
those applications
support. Her mother-in-law sold the property.
observation is made, that will not
You have removed your own mother, so don't speak.
Not because of the
that will affect my lord the pending application under order 1 rule 10 because it is a dispose of appeal.
Lord, what fell from your
But in a
lordship?
dispose of appeal only two questions that extension and exchange these can be because court in functions of which your lordship knows that.
My lord, we have not yet addressed, we have not addressed, my lord, on CAN 5. The CAN 5 stands on a different footing. CAN 5, the applicants in CAN 5 had made an application before the trial court for extension of time to file a affidavit in opposition. And 10 days thereafter, they have filed an affidavit in opposition, which has not been accepted because that was out of time. But they had approached the trial court with an application for extension of time to file written statement. And they have filed it, not now after 4 months like them, but within 10 days.
10 days is also beyond the time fixed by us.
Time?
So they also require an extension. So how are they different?
But I'm just saying the facts are different in that case to the.
Now, what happens is on 20.
You are in support of CAN 5.
That CAN 5. Lord, what happened was it was my advocate in the trial court pillar is from the other community. Lord, they had Eid at that point of time.
Just use the microphone. You're the advocate on record?
He had a festival, my lord, to attend at that point of time. So he could not, my lord, do that. So it was still 31st of March. We filed it, my lord, 10 days thereafter. We filed an application as well, but praying for extension. My lord, what I was trying to, my lord, submit before your lordship, what fell from my lord, in my respectful submission, my lord, it would be absolutely, my lord, trite law if it is first decided who can represent the deity.
Has to be.
Has to be. If that's an issue that has been framed by my lord and that is decided along with the Order 1 Rule 10, then the suit can proceed in the way it needs to. My lord, here, putting 3 people together, my lord, in one suit and trying to find out what is the best interest of the deity, my lord, those 3 people are going to fight amongst themselves.
But another question crops up, Mr. Chatterjee, as Mr. Banerjee pointed out, that whether while deciding this application, we can go into that.
Your lordship may, my lord, extend my lord's jurisdiction to that effect only.
Can we do we have that?
My lord,
as both Messrs. Banerjee said that
your lordship has inherent
either 148 or
inherent power.
Either 148 or
exercise my lord's inherent powers to my lord decide, to direct the court, my lord, to decide.
Appeal from an ad interim order of injunction.
Lordships,
I'm not against inherent powers, but I say
I understand what
injunction application at large,
But
appeal
for
from an
the
ad
interest
interim order of
deity, your
injunction,
lordship should be astute.
appeal allowed,
আমি
affidavits directed.
বসেছিলাম এতক্ষণ। আমি ইংরেজি পড়াই না বলে আমার বলতে পারবেন না।
ইংরেজি নিয়ে already
take your seat, Mr. Banerjee. Let us hear English for some time, then we'll hear your whatever you are. Normal plain English.
So my lord would be astute, as my lord the Madras High Court judgment, to see, my lord, that the interest of the deity is, my lord, looked after. Now, who looks after that? Whether, my lord, a person who has given it, my lord, on a lease.
An application for extension of time to file
Lord,
an objection.
if the application for extension of time is allowed, in that your lordship is making one direction, saying that frame an issue. It's not beyond my lord's jurisdiction. Your lordship could have done that, my lord, even in the appeal. My lord could have done that. I have a review pending in that appeal. So lordship exercises my lord's jurisdiction and passes that order so that, my lord, this becomes germane first. Because Mr. Chatterjee's client, he has absolutely no right. Swapna, my lord, is alive. And the deed says if Swapna is alive, Swapna will be the Shibai. He can't come up and say that because Swapna is removed, it is on Order 22 Rule 4.
That's why Mr. Chatterjee is representing his client and Mr. Chaudhary is representing the other.
Separate thing altogether. He can't say I'm a Sheba.
Otherwise, it would be reversed.
Absolutely. No, it doesn't say that he becomes automatically after Shopna goes from this world.
After removal.
Cannot be removal in what way? 3 people, there are 16 Shebaites, 3 persons represented by my learned senior friend. Now those 3 persons sit in one table, sign a document, say this person goes out. These needs to be decided. That is below the deity's interest. Whether these 3 people who are filing the application, whether they have done something below bona fide. 16 Shebaites off. 3 of them sit together and say,
We use the word nebulous in our order. We have found out a way to do that. That's what our
more ornamental word, my lord. I am not.
Nebulous will be applicable there. Because the rights are really nebulous. Right on that.
So this needs to be co-ed first. So once that is not co-ed, then the litigation goes forward. Because it's been my submission from day one where this has been funded by somebody else, but that's a different thing altogether. I can, Milord, from that deed which Mr. Banerjee showed your lordship, my lord will find that the Agarwals have got, Milord, a lease of about some 400 cutters or something, Milord, for 1 lakh a year.
1 lakh a year.
1 lakh a year.
And
Milord,
done by Mr.
status quo order. Status quo order.
Yes.
Yes. Roktima.
Yes.
Sir,
now the cat is out of the bag. If it is a play of malice, let us have the entire buffet of malice.
And
the buffet of malice.
And kindly sees this.
Deal with the buffet first, then we'll come to the a la carte.
But kindly lifts the veil and see what's happening. This gentleman wants an order of status quo. Why? Because he is in possession.
There is a suit pending for recovery of possession at the instance of the deity. During the pendency of the suit, Roktima goes and executes a long lease for a pittance of consideration and now comes up and says, I want to protect the deity. So that the ex-lessee trespasser can continue for another 40 years with her blessings. And with Mr. Chaudhary's
that's why I say, my lord, for the interest of the deity.
Yes, he has valued it at 97 crores.
For the
yes.
For the interest of the deity, the best thing is to
Everything is for the interest of the deity.
Absolutely.
You can understand that by now.
Absolutely. For the interest of the deity. Literally, kindly sees who is the best person to, my lord, put forward the interest of the deity. And for that, my lord would be astute enough, my lord, as the, my lord, the division bench says of Madras High Court, to look after the interest of the deity in whichever way. So that issue, my lord, if it is found out that who is the person who can represent the deity, then the things can go forward. And as it fell from your lordship, my lord, that's absolutely trite law. And I make this submission before your lordship, my lord, exercises my lord's powers under 151. Or review which is pending before your lordship. To my lord, say that this needs to be decided first. Because in every matter, my lord, there are 4 advocates appearing for Shopna. There are suits pending in the High Court. There are suits pending in the trial court. 4, somebody gets hold of Shopna. Somebody gets hold of Roktima. And they all say that I am appearing for the deity. Can't happen. Today, my lord, Mr. Chaudhary is representing somebody else. He represented, my lord, Shopna at one point of time, saying, I am for the deity. Then suddenly, my lord, one fine morning, he says, no, Shopna is not interested. I am the interested person. This can't go on forever, my lord. There needs to be an end quietus to that. And the only way it can be, my lord, quieted is by what fell from my lord.
In the trial court, my lord, in spite of repeated
Yes.
queries, my lord, did not say that he was appearing for a person. He kept on saying he's appearing for the deity.
Heard learned counsel for the heard learned senior counsel appearing for the parties. Full stop. Next para.
My lord, now can I?
Yes. The present hearing arises out of 3 separate applications seeking an extension of the time to file written objection to an injunction application filed in a suit challenging a deed in the trial court. Full stop. The short background is that the plaintiff's stroke appellant, comma, being the appellant number 1 deity, D-E-I-T-Y, and the appellant number 2, one Shopna Mukherjee, comma, claiming to be a Shebaite of the deity, comma, filed a suit challenging a deed, comma, in which an ad interim prayer for injunction at the behest of the plaintiff stroke appellants was refused. Full stop. Challenging the same, comma, an appeal bearing FMA 929 of 2023 was preferred before this court. Full stop. By an order dated March 3, 2025, comma, this court had allowed the appeal on contest, comma, thereby granting an ad interim order of injunction restraining the defendants stroke respondents from acting on the strength of the impugned sale deed till sale deed dated July 2, 2015, as well as from transferring, comma, alienating and stroke or creating any third party interest or parting with possession in respect of the suit property till disposal of the injunction application pending in the trial court. Full stop. Next para. While doing so, comma, this court had also directed that the respondents shall file their respective written objections to the injunction application in the court below, comma, if not already filed, comma, within 3 weeks from the said date, that is from March 3, 2025, comma, whereupon the learned trial judge shall endeavor to dispose of the injunction application itself as expeditiously as possible in the interest of justice. Full stop. Next para. Learned senior counsel appearing for the respective applicants submit that although their written objections were affirmed within time and copies thereof were served also within time, comma, the filing of the same was postponed till the next date of hearing of the injunction application, which was previously fixed at June 10, 2025. Full stop. Next para. There were certain dates allotted by the learned trial judge in the interregnum, which, comma, however, comma, according to the petitioners, comma, not dates for hearing of the injunction application. Full stop. It is submitted that the hearing of the injunction application was interdicted by applications for addition of party filed by the present proposed interveners, comma, who have filed written affidavits in opposition to the present applications for extension, comma, by filing put up petition কথাটা use করলাম কি, by filing put up petitions. Full stop. Next para. It is contended that since the prayer is innocuous, comma, this court ought not to enter into the merits of the respective contentions of the parties, which shall be decided in the suit itself. Full stop. Next para. In view of the bona fides of the petitioners, comma, it is submitted that the timeline for filing of the written objection, comma, which have already been filed physically in the trial court but not accepted, comma, be extended. Full stop. Next para. Learned senior counsel appearing for the proposed interveners, comma, stroke objectors submit that they represent the true interest of the plaintiff stroke appellant number 1-DT. Full stop. Learned senior counsel appearing for Roktima Mukherjee, Mr. Chatterjee. Roktima Chatterjee, comma, one of the objectors, comma, submits that in the interregnum, comma, due to activities on the part of the plaintiff stroke appellant number 1, Swapna Mukherjee, comma, colluding with the defendants in the suit, comma, the said Roktima Chatterjee along with certain other Shebites were compelled to remove Swapna from the role of the authorized Shebite to represent the interest of the deity in the litigation. Full stop. Next para. It is submitted that an application for addition of party at the behest of Roktima is now pending in the trial court. Full stop. Next para. It is further submitted that the respondent stroke present applicants have sought extension on a malafide basis. Full stop. It is submitted that the premise of the applications for extension is that the applicants were advised by counsel to file their respective written objections on the next date fixed for hearing of the injunction application, since otherwise the written objection might be misplaced, comma, if filed on an off date, OFF hyphen date within double inverted. Full stop. However, comma, the very premise of the said contention is negated by the conduct of the petitioners in the trial court. Full stop. It is pointed out from the photocopy of the order sheet of the suit from which the appeal arises, comma, which is annexed to the affidavit in opposition filed by Roktima, comma, that on April 7, 2025, comma, the record was taken up, the record of the suit was taken up for hearing of the temporary injunction petition. Full stop. Next para. The said order was preceded by an order dated March 26, 2025, when the record was put up on the basis of a put up petition filed on behalf of the plaintiff number 1 by Roktima, comma, who represented the interest of the plaintiff number 1 DT by this time. Full stop. Next para. The learned trial judge directed the petitioner stroke plaintiff to communicate the date, the next date, that is April 7, 2025, to the defendants and submit compliance accordingly. Full stop. It is pointed out that in the order dated April 7, 2025, comma, it is recorded that the matter was being taken up for hearing the injunction application. Full stop. Next para. The learned advocate on behalf of the plaintiff number 1 was also heard in part. Full stop. Next para. It is further contended that the court recorded on April 7, 2025, that the learned advocate representing defendant numbers 1, 3 and 4 were also present in the course of hearing, but from the record, comma, no respective steps have been found to have been taken on their behalf. Full stop. Next para. A learned advocate representing the plaintiff number 2 was also present on the said date and challenged the locus standi of the learned advocate representing plaintiff number 1, comma, the deity, comma, to appear in the matter. Full stop. Next para. By a subsequent order dated May 22, 2025, comma, the application under Order 1, Rule 10 of the Code of Civil Procedure was taken up, comma, since due to certain unforeseen circumstances, comma, the matter could not be taken up on the next date fixed, that is April 28, 2025. Full stop. Next para. It is pointed out that the court recorded in its order dated May 22, 2025, that an affidavit of service was filed on behalf of the plaintiff number 1 along with a photocopy of postal receipts and postal track report and advocate's letter addressed to defendant numbers 1 to 4, which were kept on record. Full stop. Next para. The learned trial judge, comma, by the said order, comma, further recorded that it was submitted by the contesting defendants that the plaintiff number 1 DT was unrepresented, and unless and until the impugned petition under Order 1, Rule 10 within bracket 2 dated April 25, 2025 is disposed of, comma, they will be prejudiced. Full stop. Next para. In the said order, comma, it was recorded that June 10, 2025 was fixed next for hearing the injunction petition in conjunction with the petitions under Order 1, Rule 10 of the Code. Full stop. Next para. It is argued that that despite the pendency of the application under Order 1, Rule 10 at the behest of Roktima in the trial court, comma, such pendency does not deter Roktima from representing the interest of the plaintiff stroke appellant number 1 in connection with the present applications. Full stop. Learned senior counsel appearing for Roktima submits that even apart from being sought to be implemented in her personal capacity as a Shebait of the plaintiff number 1 DT, the said Roktima Chatterjee independently, as a Shebait, has a right to represent the interests of the deity, more so since such interest is not being represented properly by Shopna Mukherjee. Full stop. Next para. Learned counsel appearing for Somesh. What is your title? Somesh Mukhopadhyay also supports the contentions of Roktima Chatterjee and submits that in the interest of justice, the injunction application ought to be decided early and the prayer for extension of time to file written objections ought to be turned down. Full stop. Next para. Upon careful consideration of the rival contentions of the parties, we find that the first question which arises before us is whether Roktima Chatterjee and Somesh Mukherjee have the locus standi, at least prima facie, to oppose the prayer for extension. Full stop. A factor which cannot be overlooked is that at the relevant point of time when the appeal bearing FMA 929 of 2023 was disposed of, that is on March 3, 2025, neither Roktima nor Somesh were in the picture. Full stop. The plaintiffs stroke appellants were the deity and Shopna Mukherjee, who is still plaintiff number 2 in the suit. Full stop. Next para. Seen from such perspective and taking a restricted view, neither Roktima nor Somesh had any right of audience on the said date of passing of disposal of the appeal, and as such cannot turn the clock back and oppose the prayer for extension of time to file written objection, which was granted by the order dated March 3, 2025. Full stop. Next para. On the other hand, we cannot overlook the proposition of law as cited by learned senior counsel appearing for Roktima Chatterjee in the case of such and such. Reported at 2021 SCC Online Madras MAD 12402, where a learned single judge of the Madras High Court, inter alia, observed that it is the duty of the court to ensure that the deity does not suffer and the courts should be astute to protect the interests of an idol in any litigation. Full stop. The learned single judge used the expression that if there is an act of passive or active collusion of the concerned authorities who are supposed to represent the estate of the deity, such acts of within double inverted fences, FENCES, eating the crops, double inverted close, should be dealt with sternly. Full stop. It was further observed that it is also the duty of courts to protect and safeguard the properties of religious and charitable institutions from wrongful claims or misappropriation. Full stop. Next para. Although the said judgment was rendered in the context of a public charitable endowment, within bracket a temple, bracket closed, the underlying principle that a deity is a perpetual minor, which is a well-recognized legal fiction, and its interests are required to be protected by the court, acting as guardian, cannot be gainsaid. Full stop. Next para. The principle that the court acts as the guardian of all minors can very well be extended to a perpetual minor, that is a deity. Full stop. Next para. Looked at from such perspective, we find that we are at least to prima facie explore into whether Shopna Mukherjee is at present exclusively authorized to look after the interest of the deity, even without going into the merits of the addition of party application pending in the courts below. Full stop. Next para. We enter into such inquiry with a caveat that none of our observations shall be conclusive or binding at any stage of the suit and are only for the prima facie purpose of considering the locus standi of the objectors to oppose the prayer for extension of time. Full stop. Next para. We find that despite alleged service, comma, which is borne out by the affidavit of service filed in court by the petitioners, comma, none appears on behalf of the plaintiff stroke appellant number 2, Swapna Mukherjee, who filed the suit, comma, couched in a manner that the said Swapna represents the interests of the deity. Full stop. It may very well be that Swapna is not represented before us for umpteen number of circumstances beyond her control. Full stop. However, comma, fact remains that the deity would not be represented before us today unless either Roktima or Somesh are heard, comma, even on the minor question of whether time for filing written objection to the injunction application ought to be extended or not. Full stop. Next para. Borrowing the principle that the court is the guardian of all guardians in respect of minors, comma, including perpetual minors, comma, we accordingly allow the leeway to the said objectors Roktima and Somesh, comma, even without deciding whether they have a right to contest, to prosecute the suit in the trial court on behalf of the deity, comma, at least to have an audience before us for the purpose of representing the interest of the deity in the absence of what was the name of Swapna, in the absence of Swapna. Full stop. Next para. Hence, comma, taking into consideration the arguments of both parties, comma, we now deal with the question as to whether the prayer for extension ought to be allowed. Full stop. Next para. It is trite law that directions in the nature as passed by your order dated March 3, 2025, while disposing of FMA 929 of 2023, are in the nature of orders in terrorem. Full stop. Next para. Thus, comma, we do not find that the timeline stipulated for filing the written objection by the defendant stroke respondents were of such a mandatory nature that even this court does not have the jurisdiction to exercise the power under section 148 of the Code of Civil Procedure and look at a situation whether it was not possible for the applicants to file the written objection in time. Full stop. Next para. From the circumstances of the case, comma, we find that the original date fixed for hearing of the written, injunction application was June 10, 2025, when we had passed the order dated March 3, 2025. Full stop. Next para. However, comma, subsequently, the records of the suit were taken up by the learned trial judge on a put-up petition being filed by Roktima Chatterjee, comma, on the basis of an application under Order 1, Rule 10 of the Code of Civil Procedure filed by her. Full stop. In the order dated March 26, 2025, comma, the said Roktima Chatterjee also purports to represent the plaintiff number 1 DT. Full stop. Next para. The trial court recorded on the basis of the submission of Roktima Chatterjee that the said petitioner stroke plaintiff was directed to communicate the next date to the contesting defendants and submit compliance accordingly and fix the matter on April 7, 2025. Full stop. Next para. Although learned senior counsel appearing for the petitioners submit that no such service was effectively completed on defendant numbers 1, 3, and 4, comma, we find from the order dated April 7, 2025 that the court recorded that the learned advocate representing defendant numbers 1, 3, and 4 were present in course of hearing, although from record, comma, double inverted, no respective steps have been found in their behalf, double inverted close, full stop. The expression double inverted in their behalf, double inverted close, clearly indicates that the said observation does not pertain to the non-service of notice on the said defendants, but rather speaks about no action having been taken on behalf of the defendant numbers 1, 3, and 4. Full stop. Next para. Contrary to the arguments of the present petitioners, to the effect that the advocates representing the said defendants were present in the court by chance without service of prior notice on them, comma, we agree with the contention of learned senior advocate appearing for Rectification Chatterjee that it was too much of a coincidence that the learned advocates representing the defendant numbers 1, 3, and 4, as well as plaintiff number 2, were present on the said date. Full stop. Next para. It is apparent from the order dated April 7, 2025 that the advocate representing plaintiff number 2, Shopna, had challenged the locus standi of the learned advocate appearing for Rectification Chatterjee, comma, who purported to represent the deity, comma, to so appear. Full stop. Next para. Hence, comma, as on April 7, 2025, comma, there was evidently a confusion and a palpable contradiction as to who would represent the interest of the deity, that is the plaintiff number 1 in the suit. Full stop. Next para. Moreover, comma, we do not find anything on record to show beyond doubt that April 7, 2025 was actually fixed for hearing of the temporary injunction application, although the same has been recorded in the said order by the trial court. Full stop. Next para. The next date, that is May 22, 2025, comma, the learned trial judge recorded that the record was fixed for hearing the petition under Order 1, Rule 10 within bracket 2. Full stop. At the in the last paragraph of the said order, comma, in fact, comma, the learned trial judge reiterated that June 10, 2025 was fixed for hearing the injunction application in conjunction with the applications under Order 1, Rule 10 of the Code of Civil Procedure. Full stop. Next para. Thus, comma, we find that the present petitioners had actually affirmed their written objections to the injunction application prior to the timeline stipulated by us in our order dated March 3, 2025, and had arguably served copies thereof on the plaintiffs. Full stop. Next para. We do not find much fault in the advice given by the learned counsel appearing for the present petitioners in the trial court to the effect that if the written objections were filed in respect of the suit on an off date, double inverted OFF hyphen date, double inverted close, comma, that is a date not fixed for hearing of the suit, comma, the written objections might be misplaced from the records, and to wait for the next date of hearing of the injunction application to file the same. Full stop. Next para. Hence, comma, we do not find any lack of bona fides on the part of the respondents stroke present applicants in filing the written objection later than the period stipulated by us. Full stop. Next para. In the same breath, comma, since we have already observed that the nature of the direction was in terrorem, comma, we cannot castigate the petitioners per se for the delay in filing the written objection, comma, since the written objections had already been affirmed within the timeline stipulated by us. For the next para. Accordingly, can what application 345
345
In
my
of 2425?
case, but in my case, can number 5
my petition has been affirmed beyond the time, my lord. Within 10 days, it has been filed. The stipulated time was on 24th.
Next para. Although in case of the petitioner
Filed it on 4th April, within 10 days. 24th March, that stipulated time was expired.
in can 5 of 2025, the written objection was affirmed beyond the period stipulated by us, the objection itself was filed within 10 days thereafter. Full stop. Next para. Hence, we do not find any lack of bona fides on the part of the petitioner in the said application as well. Next para. Accordingly, can 3 of 2025, can 4 of 2025, as well as can 5 of 2025 are allowed on contest, thereby extending the time for filing the written objections. You have already, all of you have filed.
Yes.
To the respective dates on which the written objections were filed in the trial court. Full stop. The trial court shall now accept the said written objections and proceed on the premise of the same to decide the injunction application. Full stop. Next para. However, we would like to add further that for an effective hearing of the injunction application, it has to be decided first as to whether Roktima Chatterjee or Somesh Mukhopadhyay or
Swapna
or Swapna Mukherjee
Not only Roktima and others. Right? It was
very right.
Roktima came with 2 others.
Whether Roktima Chatterjee, Somesh Mukherjee and or the other petitioners who have filed applications for addition of party in the suit on the one hand, or Swapna Mukherjee on the other, have the authority at present to represent the plaintiff number 1 stroke appellant number 1
or defendant.
Someshta thale kete din and Someshta bad jabe and Someshta bad Roktima and the others who have filed an application for locus standi to represent the plaintiff number 1 stroke appellant number 1 DT in the suit. Full stop. We so observe, since unless the right of representation is decided first as a preliminary issue, the same will directly affect the hearing of the injunction application as well, where the estate of the plaintiff number 1 DT will also have to be properly represented. Full stop. Next para. In any event, since the applications under Order 1, Rule 10 of the Code of Civil Procedure have been directed by the learned trial judge to be heard in conjunction with the injunction application on the next returnable date, we find it appropriate that the learned trial judge fixes the issue as to who has the authority at present to represent the plaintiff number 1 -DT in the suit first, and immediately thereafter decide the applications under Order 1, Rule 10 of the Code of Civil Procedure as well as the injunction application. Full stop. Next para. Since pleadings are complete in respect of both the injunction application as well as the addition of party applications, we expect that the learned trial judge shall complete such exercise as expeditiously as the business of the said court permits, positively by more than that, by August 14, 2025. Full stop. Next para. We make it abundantly clear that we have not entered into the merits of the respective contentions of the parties in the suit or the connected applications, and it will be open to the learned trial judge to decide all questions in respect of the pending applications as well as the suit independently, without being influenced in any manner by any of the observations made above. No rest to cost.
With regard to the
My lord will direct that the Roktima be served with copies of the objections, otherwise I'll be handicapped.
No, she has an order 1 rule 10 on board. There are objections to that.
I mean,
Which objection?
with regard to the order one,
and
rule,
subject
we
to
have
her
not yet filed our-
objection, they filed
Pardon?
that.
we have not yet filed our written objection, my lord. So
Order 1 rule
the
10.
time will be permitted to file my written objection.
You said you file after 10 days?
No, this is with
Order
regard
1
to
rule 10.
injunction, my lord.
Order 1 rule.
This is order one, rule 10. As my lord says, the addition of party by Shumesh Mukhopadhyay.
That's not here. I mean,
No, to the order 1 rule 10.
This is with regard to order one, rule 10. Till I have not filed.
একটা লাইন অ্যাড লাস্ট সেন্টেন্সটা যেটা বললাম না এই যে it is made abundantly clear তার ঠিক আগে ঢুকবে insofar as the petitioner in can 5 of 2025 is concerned comma the said petitioner shall file one petitioner
It's only one.
he or she
Respondent number 2, he, Orko Prabhu Ganguly.
he shall file his written objection to the applications for addition of party within 1 week from date. Acha, yes, you were saying something.
I was saying
The-
that
We'll keep it open for you to pray before the trial court for being served with the copies, whatever copies.
my
And
lord
where-
will
where my lord has
appreciate, then I'm in the dark as to what their stand is.
Yes,
And my lord,
it will be open to the applicants in the addition of party applications to make appropriate prayers, make appropriate verbal prayers before the learned trial judge. Now, make appropriate prayers before the learned trial judge for being served with copies of all pleadings in connection with the suit in order to properly represent their case.
my lord,
Mr.
When this
Banerjee
is
will
continued, they
direct
will
you.
file-
Otherwise,
I'll file an
yeah, no, no,
objection to
no. Otherwise, Mr. Banerjee, the preliminary issue cannot be heard out either.
because they've
Hey,
taken
last
point
sentence কেটে দিন
that,
একটু আবার।
that the property is
কেটে দিয়ে-
regular. I mean, that's this
No,
is
I have not taken that point. Why are
The-
you putting it
the-
on me? I have not taken that point.
The
when you're
defendant stroke respondents
Yeah.
shall hand over copies of all pleadings filed by them to the learned advocate on record appearing for the for Roktima Chatterjee as well as Shomesh Mukhopadhyay, comma the petitioners in the applications under order 1 rule 10 of the code of civil procedure, comma
within.
in the trial court as expeditiously as possible, comma positively within 1 week from date.
Difficulty in this is they automatically
So
get
give the
added as-
copies. There should be a proper decision on the preliminary issue.
My lord, only one.
This to have rights and content.
Yes, kindly say that this will be without prejudice. Otherwise,
What will
that we are-
prejudice your rights?
that we are handing up in terms of order.
Service of copies. How can that prejudice your rights? Just because Mr. Hardhan Manji is saying, you're also saying.
I had something else to say.
Just because Mr. Arindam Manji is saying, you're also.
I just only one thing. to
Service
say.
of copies cannot prejudice any.
Not so that this cannot be treated as admission, added, that it shall be deemed to have been added.
That's the
without
order of
prejudice-
court.
Without prejudice.
They have directed a preliminary, we have directed it to be heard as a preliminary issue. Who is entitled to represent the deity? For that, you have to give all copies to them.
That's right. But their service not will not tantamount.
As per our direction.
That's for
tantamount into adding.
What sort of right will be created in their favor by service of copy, Mr. Banerjee? Explain to us.
Why without prejudice to the rights?
What prejudice will be created if you give copies? What prejudice will be created? You are admitting their rights.
Because my lord, they.
The prejudice will be that I will get to know what they're saying.
There are only one thing
When
left.
trial court High Court directed them to serve the copy, therefore it shall be deemed to have been allowed.
আপনাকে বলছি আপনি উত্তর দিন।
Addition is allowed.
My lord, only one prayer, my lord.
Yes.
Where my lord has said we'll fix and decide, because my lord has said we'll fix the preliminary issue. So he has to fix and decide it.
Will fix a preliminary issue কথাটা
Fix actually.
প্রেম প্রিলিমিনারি ইস্যু হওয়া উচিত ওটা প্রিলিমিনারি ইস্যু কথাটা দিয়ে সার্চ করে না যেখানে বলেছি ওই উইল shall frame a preliminary issue shall frame a preliminary issue and decide the same
Decide the same.
হ্যাঁ প্রিলিমিনারি ইস্যু দিয়ে ফাইন্ড করে না হ্যাঁ shall fix বলেছি বোধহয় shall frame a preliminary issue and decide the same তারপর যা আছে আছে আচ্ছা লাস্টে যেখানে ওই একদম শেষ সেন্টেন্সে যেটা বললাম না যে shall serve copies of all the pleadings without prejudice to the rights and conditions of the party. Happy, Mr.
Doesn't matter.
এই পেনটা বোধহয় চলে গেছে ফাইলের সঙ্গে ওটা না ওটা দীপাঞ্জনের পেন দীপঙ্করের পেন ঠিক আছে পরে পাওয়া গেলে যেন ফেরত দেওয়া হয় আর এটা একটু ঢুকিয়ে দেবেন ফাইল নেক্সট
3 hours of hearing on
Longest argument.
I must congratulate my learned senior friend. But
I was congratulating him.
I will be
Pat
entitled.
your each other's back and
Will be entitled to
relieve
at least,
Mr. Haradan Maharaj and Mr. Chatterjee from this.
at least 2 fees will be entitled to because of it.
No, Mr. Banerjee, you are always. No, not always. Nowadays, you are very short.
I'm so grateful.
Thank you.
On both sides of the recess, will not 2 fees. 2 fees.
Two?
2 fees.
We are not at all interested in fees of council.
Only court fees.
Mr. Chatterjee has a similar prayer.
Yes. Next matter call করুন আপনি মুগ্ধ হয়ে কি দেখছেন? Yes.
The appellant is the plaintiff
Yes.
who filed the suit for
Is it appearing for the first time before us?
a first appeal against the order passed by the senior judge. But the suit was filed by the plaintiff who purchased a shop room in the ground floor and paid for water connection and user right of the common spaces and the toilet, common toilet, not separate toilet.
You are a tenant.
I'm the owner, purchaser. I purchased from the defendant number 1, and the defendant number 1, when I purchased, it was not complete.
Yes.
Now it was not constructed as per sanction plan, and there is a toilet. They promised that after completion, they will provide me the toilet and the common
They means who?
facilities. The defendant number 1, the owner.
Achha, your vendor.
Yes, vendor.
Right, right.
There are 5 shop rooms. The defendant number 1, now he has also 2 or 3 shop rooms, and he has after that he has restrained myself from using the common space and the toilet. Now the trial court granted me partial relief that the water connection,
The subject matter of the suit is the toilet.
a toilet and user of the common spaces, which is my basic right. Without
What is the
which,
injunction you sought?
Injunction there at that time at this juncture there is
Oh, suit has been.
decided partly allowed relief for water.
What has been allowed?
That the direction given to supply me the water connection.
Right.
That
What has not been allowed?
not been allowed to user of the common right of the user toilet and the common spaces. That is not allowed.
So what are you doing? How are you?
No, I am closed. Without toilets, there's a
Without
shop-
toilet, how are you
That's why I'm
answering the call of nature?
Yes, that is why I have closed my business. There is a
Oh,
medicine
achha,
shop.
that's your.
Yes, but the learned trial court misinterpreted.
Why are you enjoying any injunction in the trial court
No.
during pendency of the suit?
No. That I'm not.
Then,
that's probably not.
then
Not this. Kindly
you
admit
never
the-
started your business was a non-starter then.
No, business was started. Thereafter, when they promised, somehow I managed. Thereafter, the water supply was not given. I
So
stopped.
that would be granting something which you are entitled only if you allow the appeal.
Yes, but
You're-
finally, I'm not paying.
You have asked for the stay. This stay. What
That's
is?
a formal application. That's
We'll direct you to paper.
Fine. Expedite the appeal.
Next.
Expedite the appeal. Some shorter time. Usual courts. I'm closed my business. That's not.
No. You'll. Put
I'll
in
file the paper book. I'll file the paper.
The present appeal arises against the partial dismissal of the plaintiff stroke appellant apostrophe suit for declaration of the plaintiff's right of user in respect of water connection as well as common rights, comma spaces and the common toilet. For sub next para, whereas the suit was decreed by holding that the plaintiff stroke appellant is entitled to get water connection in the scheduled shop room, comma, the other prayers, comma, pertaining to the toilet as well as the common spaces was refused, comma, against which the present appeal has been preferred. Full stop. Upon query of court, comma, learned counsel for the appellant, comma, in his usual fairness, comma, submits that there was no injunction in respect of the toilet during pendency of the suit. Full stop. Learned. Now we further find that since the suit has partially been decreed in favor of the plaintiff, comma, there is no scope for grant of any stay as prayed for in Can 1 of 2023. Full stop. Next para. However, comma, learned counsel for the plaintiff stroke appellant submits that the appellant seeks an expeditious hearing of the appeal since due to the non-access of the toilet, comma, the business of the plaintiff cannot be run at the suit shop room. For the next para, appreciating the urgency of the matter, comma, Can 1 of 2023 is disposed of by directing the appellant to put in due requisites and postal costs for service of notice of the appeal on the respondents, comma, within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to pray for inclusion in the list as and when the appeal is ready for hearing. No rest to cost.
My lord, I am for the petitioner led by Mr. Kunaljeet Bhattacharya.
My lord, I appear for the appellant opposite party, my lord. On 11th of June, your lordships were pleased to direct the respondent to file their affidavit in opposition within a fortnight, my lord. We have not received any copy.
I have already been filed, lordship.
You have not given any copy to them. How can they file the reply?
My
Your what?
my clerk already been sent to the advocate, lordship.
Have you got an extra copy? Give it to him. Affidavit in opposition will extend for a week, Mr. Bhattacharya.
Yes, your lord.
Affidavit in opposition filed by the respondent number 1 today be kept on record. Full stop. A copy thereof is handed over here and now to the learned advocate on record appearing for the appellant. Full stop. Next para. Accordingly, the time for filing reply thereto is extended for a week from date. Full stop. The application shall next be listed under the same heading on July 16, 2025. Thank you.
Grateful, my lord.
Thank you. You have filed an affidavit of service today? No, nothing to do. Oh, the
No,
opposition.
it was filed earlier, my lord.
Yes, yes, right.
Lordship, I am for the appellant petitioner. Lordship,
Yes.
I have served
Respondent.
lordship direction. I have served service effectual.
Refuse the brief. Don't take the brief. If no paper is handed over, what is the meaning of your appearing? What is the nature of the application?
Partition should.
You are enjoying an injunction already.
Lordship.
Let us give them a week.
Lordship, injunction till yesterday it was. In that event, let it be.
What till yesterday? Till disposal of the application.
Sorry, sir, I am lost.
18th of June order. If you want, we can restrict it to yesterday. On the prayer of the respondent, which respondent? On the prayer of learned counsel appearing for the respondent number 1, the matter is adjourned for a week till Monday. Adjourned till July 14, 2025.
I have served upon both 1 and 18. Lordship, sorry, Lordship.
All have been served.
Only Lordship directed injunction is paid for only against respondent number 1 and 18.
So you have served on both.
Lordship,
Both.
One typographical mistake in the forwarding letter. In place of case number 16 of 2025, it is typed wrongly typed as 2025. But that will not affect anyway because
Why? They will look for that matter.
Lordship, my copy of the application there, the everything is all right, Lordship.
After line add হবে, affidavit of service filed today be kept on record. We'll take up the application on the next day.
Yes.
Oh, sorry. Monday till Monday, July. Yes, yes. Oh, পরেরটা call করুন.
Madam, I am appealing on behalf of the
Yes,
exponent.
Yes, Mr. Mukherjee.
Application for injunction.
Right.
Filing our opposition. Oh,
You have given a copy, must.
We have given a copy. We have also filing the affidavit in reply.
Seeing a thin affidavit in opposition after a long time. Thank you.
No annexure. I was surprised.
Oh,
Absolutely
thanks to both of you. I mean,
Doctor, will kindly go to the application for injunction.
that is sufficient for.
Such a small opposition.
No, it's all right. It's up to you.
So bad an application, Mr. Mukherjee, that
That is what he's saying. Let me see.
What is the matter?
Matter relates to a gift deed
Yes.
executed by the mother of the parties on 19th of May 2010. Now, the gift deed, execution of the gift deed is not an issue in the issue is the son, the fight between brother and sister. Son has otherwise provoked the mother to file a revocation suit for revocation of that gift deed. Saying
It was in your favor. in your favor.
The gift was in my favor, my client's favor.
So initially you provoked, now they're provoked.
The question is not that. I am giving the details why I say this.
Yes.
There were two properties of the father and mother. The father's property at Pitambar Ghatak Lane in Chitla was given to the son absolutely exclusively. The other property, which is just 1 kata and 2 chitaks, that was 4 katas for the son, 1 kata and 2 chitaks in respect of undivided property, was otherwise gifted to the daughter. Now, the factum of gift is not disputed. Again, I'll submit. But the point is, they are saying that we have obtained that property by fraud. Their suit was dismissed against us. We have preferred the present appeal, and we say that there is a possibility of the brother otherwise selling off this particular share. Then we would be absolute difficulty. This is the short situation which I intend to submit before your lordship.
You failed to prove the fraud, Mr. Mukherjee. Just show us something prima facie.
No. We have succeeded in proving the
No,
fraud.
Oh, your suit was decreed.
Yes. Their suit was decreed. We have
Mother filed the suit. If you, after my senior friend
Mother's
has submitted, I will submit.
Mother's suit has been decreed.
Mother's suit has been decreed. Now,
mother has died in the meantime.
So,
my another submission is, if you take Hindu Succession Act, mother has said in the evidence, we can show from the evidence, I've got the papers of the evidence. Mother has said in the evidence that I didn't intend to do a gift deed in favor of my daughter alone. Why? She said that she wanted that the property should vest with the son and daughter in equal shares. That is in the evidence itself. If you go by section 15 of the Hindu Succession Act, automatically it will come to the son and daughter in
no
equal
gift
shares.
deed was
No
required.
gift deed is required. Why there should be a gift deed then? Now, these questions did crop up, and there is also a point which I intend to submit before your lordship. Here is a situation where the brother-in-law of the the donor, was given the authority to draft the deed. That is also admitted. The brother was a lawyer practicing in the Alipur court. He prepared the deed and he was present when the deed was signed. The acceptance of the deed is also there. In such a situation,
So what has been held by the trial court? Why decreed?
tell that this deed of gift is obtained by fraud.
Fraud in what, of what nature?
Fraud, forcefully taking the mother to the registry.
Coercion.
Coercion. Mostly coercion.
And the signature has not been challenged.
No, nothing has been challenged.
Only coercion.
Only coercion. We seek an injunction so that the property is not transferred to any other party. There is an interim order in our favor. If your lordship so feels, we can have the order.
your lordship has just already passed an interim order.
Yes.
Yes.
Restraining me from.
Yes. What is your objection to this injunction?
No, they should also be injuncted.
Why? You have to file an independent application then.
No, lordship. The property belonged to the mother.
Yes.
Now, after the demise of the mother, automatically the property will devolve upon son and daughter.
Yes.
Now, your lordship has injuncted me from dealing with the property.
Because they have filed an injunction. You don't. Their injunction is not a matter of right, Mr. Rai. You have to plead at least that there are grounds for
your
injunction.
lordship will kindly
You
pass
have
an
not
order of
pleaded, you have
maintaining
not.
status quo by both
Why?
the parties.
Why no?
Because
You have not
they-
asked for any injunction. You have to make an independent application alleging that they are trying to transfer. Because we are not staying the gift deed, Mr. Rai. You have to appreciate this. The decree remains. We are not staying the decree. So as of today, the decree, the gift deed
if
is
the
no longer
degree
there.
If the degree remains, then both are the owners of that property.
If the degree is set aside, I mean, yeah, if the degree remains,
Degree remains, both are owners of the property.
they may transfer, but you have to allege that in an application. You file an independent application for injunction. Why should you restrain them also?
Then lordship will
File an
file-
independent application. Have you alleged in your opposition something of that sort?
No, nothing of that sort.
Then at least in your opposition, you have to allege that they're trying to do that, not as a matter of course.
They have also not alleged their order of
We have alleged that you have otherwise trying to dispose of.
They must have alleged something.
Or else how do you otherwise continue with the application?
No, Mr. Mukherjee, in fact,
They have not alleged
you have
anything
not
like
alleged
that.
anything. Your application is styled as one for injunction, but your prayer is. But your paragraphs 23, 24 are more on stay.
Yes, those are more on stay, no doubt.
There are no averments regarding.
There is no
So you have to be equitable on that. We'll grant status quo.
Grateful to you.
Status quo will do.
Otherwise, we'll have to lift your injunction. You don't want to do that? Yes.
Yes, status quo to be maintained by both the parties. Grateful to your lordship.
Not yet. There's many a slip between the cup and the lid. Now take your seats, but Mr. Mukherjee, please take. Upon hearing learned affidavit in opposition and reply filed today be kept on record. Upon hearing learned counsel for the parties, it transpires that the present appeal has been preferred against a decree declaring a gift deed executed by the mother of the appellant and the plaintiff stroke respondent number 1 to be invalid. Full stop, next para. Upon a perusal of the pleadings of both the parties, we find that during pendency of the suit, unless the property is maintained in statu quo, there is every chance that the appeal will be rendered infructuous. Full stop. Accordingly, Can 1 of 2025 is disposed of on contest, directing the appellant as well as the respondent number 1 to maintain status quo as regards the suit property till disposal of the appeal. We are not restricting to anything. Blanket status quo. Till disposal of the suit. Full stop, next para.
Disposal of the appeal, my lord.
Appeal. Bole sir, appeal.
Till disposal of the application,
Appeal,
disposal of the appeal, sorry. Appeal. The pro forma respondents were dispensing with service.
Yes.
They are co-defendants with you. Next para. In view of the appearance of the plaintiff stroke respondent number 1 through his learned advocate, service of notice of the appeal on the said respondent is dispensed with. Full stop. Since the pro forma respondents number 2 and 3 were co-defendants in the suit and no relief has been sought against them, service of notice on the pro forma respondent numbers 2 and 3 is also dispensed with. Full stop. The appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the service of from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Puts up liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Lordship,
No
you
rest
have
to
mentioned plaintiff, substituted plaintiff, because the mother is the original plaintiff.
যেখানে plaintiff বলেছি না, no, but during pendency of the suit you were substituted.
Yes.
Plaintiff. No difference.
Grateful, man.
Yes. None appears for the parties. Let the matter stand adjourned for the day.
May I please your lordships, my lord? I beg to appear for the appellant wife, my lord.
Somebody is appearing for the respondent.
Yes, my lord. They were there, my lord. Mr. Ivan Roy, my lord, was there.
Ujjwal Rai, Ivan Rai.
My lord.
Today you have a resolution, so what do you do?
He was there standing.
Escaped after seeing you.
No, my lord.
Afraid of you. Either afraid of you or afraid of the court or afraid of the matter. What is the matter about?
My lord, it is a matter in which, my lord.
Condonation of delay first.
Yes, my lord.
What is the delay?
My lord, 2404 days, my lord.
Let them come.
My lord, my affidavit in reply.
Opposition has to be filed first.
It was filed on the last occasion, my lord. I sought time. Lordship was pleased enough to grant me time, my lord.
Opposition was filed on the last occasion.
If your lordship kindly have the last order, my lord. On 23rd of June, my lord, subject to correction, my lord.
দুটো কপি নেই তো? এটা না, এটা একটা opposition.
My lord, on that day, one copy was handed over, my lord, if I remember correctly, my lord, and they sought leave, my lord, to hand over the other copy in the course of the day, my lord. So, my lord.
You're appearing? We'll take up the matter tomorrow, Mr. Mukherjee. None appears for the respondent at the time of call. Let the matter stand over for the day.
Lordship will take this on record. My affidavit in reply, my lord.
Affidavits in reply filed today be kept on record. Ataline Adkodin, the learned advocate for the A respondent shall file the second judge's copy of the affidavit in opposition when the matter is next called out for hearing. Please inform him that we have directed this. They should come prepared with that other copy.
I'm grateful, my lord.
Only not today, my lord. And we have the respondent number 1, my lord.
Yes, what do you say?
For the petitioner, my lord.
Not today.
Yes, my lord. There was a direction for affidavit of service, my lord, to be.
File it.
Yes, my
You
lord.
have served on all the parties.
My lord, we have served to defendant number 3 through my lord courier. They have accepted.
3 to?
Through courier. They have accepted courier post. And defendant number 2, my lord, has changed his address. And my
You have to
lord,
find out the address.
we have sent through email, my lord. That has been accepted. And this, my lord.
Very well. The affidavit of service filed today be kept on record. Full stop. We find that the respondent number 3 has been served by post and the respondent number 2 via email. Full stop. Accordingly, the application is ready as regards service. Full stop. However, at this juncture, you are for 1. At this juncture, an adjournment is sought on behalf of the respondent number 1. Full stop. Accordingly, let the matter stand adjourned for the day. Come back to more. নাম দিয়েছে সবাই?
My lord, I am for the appellant, my lord. My lord,
Yes.
in this matter, my lord, your lordship will, if your lordship sees the last 2 orders, on last 2 occasions, my lord, my client, my lord, appeared in person. My lord, she was directed, my lord, to approach legal service authority, my lord.
Oh, acha, acha.
My lord, my lord, I have not yet received the whole papers of the case, my lord. I will appear them, my lord.
No, but you do your level best to get the papers. This is the Calcutta High Court Legal Services.
No, I'm not, she approached me through some other sources.
Directly, yes.
I'm not
So pro
connected
bono.
I'm not connected with the legal service authority.
Pro bono.
Yes, my lord.
Sir, I'm
So-
appearing on behalf of the respondents. Led by
Whatever papers are available to you, give copies to them.
No, she has the copy. A day before yesterday, she came to my chamber. But
When should you keep it? Tell us.
my lord, give me 2 weeks for one reason, because the affidavit in reply, my lord, possibly prepared by my client herself, my lord, and in the opposition to my stay application, my lord, they have relied upon a occupational. They have
Yes.
claimed occupational charges and annexing a report,
Right.
my lord. That I have to deal, my lord, to oppose, my lord. So for that reason, my lord, kindly give
You
me.
have filed your opposition.
Your Lordship, both the opposition and reply had been filed.
Yes. In reply, my lord, I have to
But Your
deal.
Lordship, that paragraph regarding the occupation charge had not been dealt
Yes,
with.
yes.
Then
That
you have to file some
supplementary, my lord, I want to use, my lord, so that, my lord, kindly give a.
Then they have to be given an opportunity to use a rejoinder to that. In reply, you are bringing in
My lord,
something.
in opposition, my lord, they place.
Acha, acha, very well. Yes, right. This is your reply.
Yes.
2 weeks.
2 weeks, my lord.
2 weeks takes us to sometime in. Will not be here. 21st to 1st. Both of us going to Jalpaiguri. Same bench will be traveling there. So we'll have to. I will keep it on 5th August.
5th August.
Immediately after that.
And the meantime, I will serve them, my lord.
An adjournment is sought on behalf of the appellant. Full stop. Learned counsel for the appellant submits that the appellant is required to file a supplementary affidavit to the affidavit in reply, which has already been filed in court, to bring before the court certain relevant documents and averments. Full stop. Accordingly, leave is granted to the appellant to file supplementary affidavit on the next returnable date upon service of an advance copy of the same on the learned advocate for the respondent within a fortnight. Full stop. The application shall next be listed for hearing on August 5, 2025.
And my lord, may I request my learned friend, my lord, if in case, my lord, I don't get the whole set of case papers, my lord, may I request my learned friend, my lord, to.
But that
supply-
also
I will-
nowadays leave of court is
No,
required.
my lord, I'm just
One
making-
council seeks
I will-
papers from another council.
I will
Court
write-
will have to direct.
I will write. I will write later.
Unheard of.
Grateful.
Yes.
My lord,
Yes, Mr. Sheth, what is the matter?
I am appearing on behalf of the appellant. My
So
lord.
thus you are for the respondent.
Yes, all the respondents.
My lord,
One respondent.
All the respondents.
On the last occasion,
the
you appeared for
affidavit.
one.
Yes.
Last occasion I
All.
appeared, we have
So you are relieved from further side. What is the matter about, Mr. Shet?
My lord, in the first matter, my lord, the plaintiff appellant filed a suit for specific performance. My lord, that suit was
Which FAT?
FAT number 176, 175.
175, you filed a suit for? You are the
Specific-
plaintiff.
Yes, my lord, I am the plaintiff. Suit for specific performance. My suit has been dismissed.
Right.
Second matter, my lord, my landed fence client, my lord,
Eviction.
suit for eviction of a licensee. That suit was degraded. Both the suits had analogously.
So what is the use?
My
You are
lord-
asking for an injunction.
Yes, my lord. Already, your lordship, my lord, grant injunction as well as next matter, my lord, stay. My lord,
Injunction regarding?
regarding FAT number
No,
175.
what sort of injunction did you do?
my lord, on 17th June 2025, my lord passed this order.
Transferring, alienating third
Yes,
party
yes.
interest? Yes. And stay of operation of the implement. Yes, we'll maintain this. Occupation charges.
Yes.
So you file your opposition then?
Yes.
File your opposition to the stay application.
Yes.
The stay application has been filed in FAT 176. Very well. Regarding the injunction, would you like to file opposition?
Both the matter I will find.
Very well. Learned counsel appearing for the respondents seeks to use affidavits in opposition to both the applications bearing Can 1 of 2025, respectively in FAT 175 of 2025 and FAT 176 of 2025. Full stop. Accordingly, the respondents shall file their affidavits in opposition to the said two applications within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The applications shall be listed for hearing next on August 6, 2025. Affidavit of service you are filing today?
Yes, my lord.
Affidavit,
Both the matter.
তাহলে না ওই হ্যাঁ FA 211 ব্র্যাকেটে FA এটি এবার থেকে না সব ম্যাটারই না ব্র্যাকেটে ওটা করে দেবেন, কেননা আমাদের ওই যখন অর্ডার পাস হচ্ছে FAT-টা আগে দিয়ে লাস্ট অর্ডার পর্যন্ত থেকে যাচ্ছে, এন্ট্রি হচ্ছে না, আপলোড হচ্ছে না, আর FA তে সব আপলোড হয়ে যাচ্ছে। লাস্টে গিয়ে FA যখন ডিসপোজাল করছি তখন FAT-টা দেখাচ্ছে পেন্ডিং। ওই জন্য যখন FA-টা দেবেন না ব্র্যাকেটে FAT দিয়ে দেবেন, বা ওল্ড বা আর্লিয়ার FAT এরকম কিছু দেবেন, এটা ছাড়া উপায় নেই। আমি রিসেল লিস্টিং এর সঙ্গে কথা বললাম, তা নাহলে একটা পেন্ডিং থেকে যাচ্ছে, ডবল পেন্ডেন্সি। আমি দেখলাম যে কিচ্ছু ওর সিস্টেমে গন্ডগোল আছে। আর একটা লাইন অ্যাড করে দেবেন, অ্যাফিডেভিটস অফ সার্ভিস ফাইল টু বি কেপ্ট অন
গ্রেটফুল, ইউর লর্ডশিপ।
অ্যাটলিস্ট অর্ডারটায় থাক, পরে দেখা যাবে কি করে FAT-টা। একটা কোথাও থাকলে পরে ট্রেস আউট করা যাবে।
I am for the petitioner.
Yes.
I am for the respondent number 4, 6, and 7.
ওই such an odd combination. আচ্ছা পেনটা পাওয়া যায়নি না? কোনো ফাইলে না না ঠিক আছে। ইয়েস সরি, আছে এখানে অন্য পেন, অন্য পেন আছে হাতে। কি 467? Yes.
467. Lord, I have gone through your lordship's order, Lord, that was passed, Lord.
We have not gone through it. Injunction.
Yes.
Should arise partition, dismissal of partition suit.
Yes, Lord,
So
I want to join one issue on. Lord, it is a case, Lord, where Lord, the mother of the plaintiff and the beneficiary is Lord, my client. The
beneficiary means will.
No, there is a deed of settlement executed. Deed of settlement executed by the plaintiff's mother and her two brothers. In favor, Lord, it is stated that this, by virtue of this deed of settlement, they will get their life interest, and thereafter the beneficiary will be my client.
You are. How are you related?
Lord, I am the brother's son.
Nirmal Kumar Mukherjee was the brother's son. You are his heirs now.
Lord, I am the brother's son. Lord, the Nirmal and Chanchal, his sons is Pritam and Lord Soumitra.
Achha.
Prithvish and Pritam.
So
Prithvish and Pritam, Lord.
So they had a life interest.
the brothers have a life interest.
No, the deed
But
of settlement was executed by mother and two brothers.
Yes.
Mother and
of the plaintiff and her two brothers.
her two brothers. So very well. So they were the owners of the property. Deed of settlement said that they will get a life interest only.
They will get a life interest.
She will get a life interest.
No, in respect of the mother of the plaintiff, his husband will get the life interest, and in respect of other two brothers, they will get the life interest. And thereafter,
Her husband means whose husband? The mother's husband.
Mother's husband.
After life interest, it will devolve upon you.
Upon 4 and 5.
So how is the
4 and 5 is this brother.
How is the plaintiff claiming title? She has challenged the deed also.
Kindly now takes up the plaint and one paragraph of the judgment. Plaint, it starts with page 44. Kindly takes up page 49. Prayer.
Yes.
Has your lordship got it? So 1/6 share upon a declaration that the alleged deed of settlement is void.
He does not mention the deed of settlement anywhere.
The deed of settlement is mentioned, in the paragraphs.
Yes, that the aforesaid deed is a fraudulent deed, yes, but no declaration, no decree sought.
No decree sought. Far less, my lord, kindly takes up now the judgment. It starts with, page 69 of my lord's brief. One paragraph, my lord, I will look in. I will, Judge Saheber. Lord, kindly takes up the issue number 3. My lord, at page 81. Apparently, my lord, since I am in the interim stage of injunction, I cannot argue the appeal.
Yes.
Kindly see, issue number 3 to 8. My lord, may I read? It appears from the pleading, has your lordship, that the evidence adduced by the parties as well as document which has been marked as exhibit in the instant suit on behalf of the defendants, that defendant number 3, since deceased, and the plaintiff jointly filed a miscase, kindly marks, my lord, MP case number such and such of the year 2004 against the defendant number 1 and 2 and HMC 144 before the SDM Howrah. The order passed by such and such along with the petition has been marked as exhibit E on behalf of the defendant in the instant suit. From the exhibit E, it transpires that the defendant number 3, namely such and such, since deceased, who being the father of the present plaintiff, along with her daughter, namely Shubhra Goswami, that is the present plaintiff, has filed the MP case in the year 2004. The MP case above mentioned petitioner and the present plaintiff has stated about the deed of settlement of exhibit 1 and B. It is the subject matter of the instant suit upon which the declaration has been sought for by the plaintiff, and also subsequent deed of rectification dated such and such. Therefore, it is evident that exhibit E itself, that the plaintiff had knowledge about the deed of settlement since from the year 2004, that is when the MP case was filed. In order to seek any declaration of the deed of settlement, the plaintiff ought to have filed the instant suit by 2007 in view of admittedly Article 59 of the Limitation Act.
But she has not sought for any declaration regarding the deed of settlement.
Kindly see, now in one prayer, I have shown before your lordship, prayer A kindly takes up the
upon a declaration.
Yes. So it is a primary relief that he has to get rid of that deed. That deed knowledge is from the document exhibit D 2004, suit file 2009.
What is your answer to this, Mr. Shah?
The question of limitation should be heard along at the time of hearing.
We are hearing. What is your answer to the limitation point?
Whether the in MP case answers they mentioned the deed of settlement, that is not clear.
Exhibit E, court relies on exhibit E.
Exhibit E is the application.
That application you have mentioned the deed of settlement.
No, we have not mentioned. They are claiming that we till that
in the said MP case, the above mentioned petitioners defendant number 3 and the present plaintiff had stated about the deed of settlement.
We have not mentioned about the deed of settlement.
You have not mentioned, but you have stated.
Stated in the
MP case.
We have not mentioned. We have not mentioned.
Have you got a copy of that MP case? Show us. We'll dismiss this application for suppression. We'll record your submission that you have not mentioned.
1430. Yes. Kindly see paragraph 4 and 5 of the MP case. This is the exhibit list.
আমরা বলেছি নাকি?
Both the settlement and the subsequent rectification.
The deed of settlement is dated 31st of March 1992. Can you?
Yes, it has been mentioned.
Can you give during the course of the day? Can you hand over photocopies of this?
Yes, this is the exhibit list, I will give entirety of it to your lordship.
Show it to Mr. Shah. Show paragraph.
This is exhibit 1 and
4 also. Paragraph 4 and 5. That page itself. Top. Deed of settlement. Show the third line from the top, third or fourth. Deed of settlement date is given.
31st of March 1992.
Have you filed any objection to this, Mr. Mukherjee? Any objection to the injunction application?
No, I have not.
We will direct you file. Learned counsel for the respondent numbers 4, 6 and 7 submits that no prima facie case for grant of injunction has been made out insofar as the suit from which the present appeal arises was filed inter alia for partition on a declaration that a deed of settlement of the year what is
number 1725 for the year 1990. Date. The date, exact date.
There, paragraph 4. Whatever you handed over this written there. March.
But it's 31st of March 1992.
Deed of settlement dated March 31, 1992 was
page 49.
Was is void. Full stop. Next para. The learned trial judge, while passing the impugned judgment and decree, categorically came to the finding that it was evident from exhibit E stroke exhibit 1 a criminal case filed by the plaintiff stroke appellant and her daughter, that in the year 2004 itself, the plaintiff was very well aware of the deed of settlement and had challenged the same. Full stop. As such, the statutory limitation period for challenging the same expired in the year 2007. Full stop. However, the suit was filed in the year 2009 and as such was palpably barred by limitation. Full stop. Next para, now upon query of court, learned counsel appearing for the appellant denies that any such disclosure was made in the concerned criminal case. Full stop. However, learned counsel for the appearing respondents hand over copies of the said exhibit from which we find prima facie that such disclosures were indeed made by the plaintiff stroke appellant as held by the learned trial judge, thereby belying the denial of learned counsel for the appellant before us. Full stop. In the event the said exhibit was before the trial court, it is extremely doubtful whether any prima facie case for grant of injunction has been made out by the appellant at all. Full stop. Next para. As such, comma, now, particularly, comma, in view of the denial of the learned advocate for the appellant before us of the factum of the disclosure of the said deed of settlement in the concerned MP case, in the teeth of the copy of the same handed over by the appearing respondents containing such averments, comma, we are hesitant to extend the interim order granted earlier. Full stop. Next para. To bring on record the relevant documents and pleadings, comma, the respondents are directed to file their affidavits in opposition within 1 week from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The application shall be listed for hearing in the monthly combined list of cases for August 2025. Full stop. For the present, comma, the interim order shall not be extended.
I'm grateful.
And for the appellant, Your Lordship.
Yes.
Your Lordship. Yes.
Yes.
A copy of the affirmed affidavit in opposition was served on us last Friday, Your Lordship.
Last Friday you've got last Friday, today we are on Wednesday.
Yes.
You've
Your
got
Lordship.
5 days.
They were already out of time, Your Lordship. Kindly, it's already ready. It has to be affirmed.
Why are you citing their delay? You should have prepared your reply by now.
Because there was a change in the advocate, Your Lordship. Vakalatna was not filed. They did not appear on the last to last
This is the
occasion.
default excuse. Any other excuse if you deny that also? How soon can you file a reply?
Your Lordship keeps it on Monday. It will be filed tomorrow.
Very good. Affidavit in opposition filed today be kept on record on the prayer of the appellant, comma. The time for filing reply is extended till July 14, 2025. Full stop. The application shall next be listed on July 15, 2025.
Great.
Yes, Mr. Raut.
We are for the respondents.
Oh, then no, Mr. Raut.
Application for stay.
None appears for the appellant, although the respondents are represented by counsel. Let the matter stand adjourned for the day. Today.
Yes. My lord, a copy have been served, my lord. Affidavit of service also affirmed.
Why are you scratching your head then?
No, my lord. There's a resolution today, my lord.
Nobody is appearing for the respondent. Take that advantage. None appears for the respondents. Let the matter. None appears for the respondents. Let the matter stand adjourned for the day.
My lord, I'm at a disadvantage, my lord. I'm for the appeal.
Oh, your name should not be recorded.
No, my lord. My lord. Lord Chief said, my lord, take the advantage, but I'm at a disadvantage. I'm the appellant.
No advantage of his absence because you don't want to do the matter.
I want to do. I wanted to do. Grateful. I'll come back tomorrow.
Well, give your whoever is appearing. You give
Yes,
it.
yes.
21, my lord, I appear for the appellant petitioner.
Yes.
Lord, may I file my affidavit in reply?
Opposition already filed.
Yes, opposition, my lord. Lord, may I serve a copy to my learned friend?
You're serving now.
My lord, I was out of day by 1 day, my lord. I tender my
The
apology.
affidavit in reply filed. One copy. 2 judges.
My lord, I
2 advocates, 2 judges,
My lord,
copy 1.
My lord, I
Eh,
have to
Din-
put kindly, my lord.
Din.
My lord, I'll file it by tomorrow, my lord.
On the prayer of the appellants, comma, the time for filing reply is extended till tomorrow. Full stop. A copy thereof shall be handed over to the learned advocate for the appellants during the course of the day.
Handed over already.
আচ্ছা তাহলে ওটা না বলে a copy thereof is handed over to the learned advocate for the respondents here and now. Let the matter stand adjourned till tomorrow.
Tomorrow.
Adjourned for the day. Come back tomorrow.
I tender my apology, my lord.
No, it's okay. All right. Just take out another copy and bring it tomorrow. We are not recording that as a ground. Next.
I'm for the appellant.
Bring your other side. Your resolution
So-
prevents us from passing.
Lordship, there is up till now no other side. There was a
This is for the
deficit in
first
court
time?
fees. First time deficit court fees. I have filed the deficit court fees amounting to 49,500.
If you have paid 49,500, you are entitled to a hearing at least.
Lordship.
No, but there is no. No, the trial court's decree,
Trial court dismissed it because we failed to
the
produce.
stamp reporter says that you have not filed a copy of the trial court's decree. You have filed only the judgment. Yes. You have to file a copy of the decree, otherwise nothing can be ascertained. The court fees, the parties' names.
Lordship, it was dismissed for default.
Oh,
Lordship, kindly have a look at the impugned.
very well. Dismiss for default.
This is for default for not for non-appearance, Lordship.
ডিক্রি হচ্ছে সন্দেহ আছে দেখে নি একবার ডিক্রি হচ্ছে না বোধহয়
Lordship, it was deemed decree because
come to section 2 subsection 2 of the code of civil procedure এটা দিন 2 shall include rejection of plaint and 144 but shall not include two things. One of this is a dismissal. File a regular revision. Order 909.
dismiss for default. Actually, we failed to produce.
No appeal is maintainable. We don't have determination. If it is not a decree. File an order 909.
Lordship, kindly, it was not because of a non-appearance, like order 9 rule 9. It was dismissed for default because we failed to deposit the.
Even then, dismissal for default is not a decree, so no appeal lies. Then you have to file a division.
Actually, the lower court order records it is dismissed for default because we failed to put in the stamp duty that was assessed. Agreement for sale.
Section 2 says dismiss for default is not a decree. And this is a dismissal default. This is also default.
Yes.
This is also default. Default does not only mean the non-appearance.
Non-appearance.
Default on any count. You are a defaulter in complying with the order of the court must be. The present appeal, no appeal lies against the impugned order, comma, which is a judgment of dismissal of the plaintiff appellant suit for default. Full stop section 2 within bracket 2 within bracket small b specifies that a double inverted with the decree does not include, shall not include any order of dismissal for default. Full stop next para. Although learned counsel for the appellant submits that the dismissal for default was not for non-appearance but for non-compliance of the trial court's order, comma, there is no such distinction in the definition of decree as stipulated in section 2 within bracket 2 of the Code of Civil Procedure. Full stop next para. In any event, comma, a default, double inverted with the default, for the present purpose need not be restricted to the non-appearance of the plaintiff but may also pertain to non-compliance of a court's order. Full stop. Accordingly, FAT 216 of 2025 is dismissed as not maintainable with liberty to the appellant to prefer an appropriate challenge against the impugned order. Full stop. Can 1 of 2025 is also disposed of consequentially. Full stop. The learned advocate of the advocate on record for the appellant is granted liberty to take back the certified copy of the impugned order upon furnishing photocopy of the same for the records, comma, from the department.
My lord, item number 34, my lord, is my second appeal, my lord. My lord, instead of my lord, the day after tomorrow, may I be directed to come on Monday, my lord?
Why day after tomorrow? Tomorrow we.
But day after, instead of tomorrow, my lord, day after tomorrow, this bench doesn't sit, my lord, perhaps.
Yes, we
Friday.
don't see.
So
No,
instead of
tomorrow is a hearing day.
hearing day, but after that, if the in case the matter is taken
After
up,
hearing,
malad, only make it malad. May that
keep somebody, ask any of your friends. If you by chance take up the order for 10 matters, there's least chance of taking up after the hearing matters. If the list collapses for some reason, keep somebody. Or you will have another opportunity to appear before us with a restoration application.
That's the malad, the anxiety.
Keep ask any of your friends to just look after them. He's there. He's not your friend.
No, I am the advocate.
The moment my
The advocate, you have to be there.
grateful.